Hello and welcome to Take two. Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Can you tell it's a Monday morning? Yes. How is everybody doing today? We are continuing our coverage of Florida versus Mario Fernandez Saldana. We are on day 6. I'm starting a little bit early because we have some activity in the courtroom. So I just want to make sure that we capture everything. So let's get started. All right. Good morning, everybody. Good morning. I just wanted to make sure that we don't miss anything. So let's get you in here. We'll make sure we're not missing anything. No audio yet, but they're bringing Mario in at 8:30. So last we heard there was going to be a proffer of Kim Jensen today at 8:30. So I just want to make sure that we capture that. Let me just... We'll skip ahead to live. All right, actually, let's see. We'll see Mario come in, and then I'll go to live. So here comes Mario. So yeah, the last time we left on Friday, they were talking about a proffer of Kim Jensen. I watched both interviews. I've seen the first interview, but I watched the second one of Kim over the weekend. Talking about everything and everybody. So it was pretty interesting. So how's everybody doing today? Green Eyed Cat, great intro music. Thank you for that, Green Eyed Cat. Appreciate that. Green Eyed Cat. Michelle Mixed Media Art, how are you doing? I missed what happened with Kirsten's phone. They pushed it out for 3 days. She has 3 days. 3 days to respond to a potential show cause, potential contempt of court. So she refused to hand over her phone on Friday, and they got from the appellate court, her attorney, Doug Clifton, was able to get a 3 business day stay, if you will. So they have 3 days to kind of sort everything out. Jane Dixon, good morning. Kimbers, how are you? Great to see you. Jackie Starr, hello, happy Monday to you. Kelly B, if the text messages are in her trial, I think they show motive. Yeah, we'll see. There was definitely some pretty interesting text messages between Kim and Shanna. That was like 2015, I think, 2014, 2015. So we'll see if those come in. Kimber is saying hello to everybody. Cindy Davidson, how are you? Iowa Backyard Cam. Angelique, good morning. Hey, Barry. Tao Tao, how are you? Debbie, good morning to you. Elizabeth Tanner, will the proffer of KJ be shown on this channel? We certainly hope so. We certainly hope so. I hope you're still with us, Elizabeth, because that's where we are right. That's where we are right now. Hey, Linda, how are you? Good morning. Welcome in. Debbie, hello, hello. Welcome in. Kelly, Kim Jensen knows a lot more than she wants to admit. Text messages say it all. Those interviews with her with law enforcement were very eye-opening. Very eye-opening indeed. So, let me just see if... okay, they do have a live feed there too. All right, let me pop over here and just interact with this. Okay. So we've got that feed. We have this feed. All right. Kaylee, good morning to you. And for those that were not with us yesterday, Kaylee is now our newest mod. So please take a moment to welcome in Kaylee to being a mod here on Trial TV Live. So Kaylee is joining our mods. So please take a moment and congratulate Kaylee and welcome her to a modship. Good morning to Michelle. Great to see you. Thank you for joining us today. Hey Mal, how are you? Good to see you. Debbie, how are you? Good morning, good morning. Welcome in. And let's all take a moment to hit the like button as well if we have not already. I know Superball has hit the like button. All right, so we're fairly sure there's going to be a proffer of Kim today at 8:30. Those are my notes. That's where we left off. My last note is 8:30 Monday, proffer of Kim Jensen. So that's where we left off. So let's see if that's actually what happens. Everybody's there. Everybody's ready. You know what, Michelle? I first was saying Klee as well, and then I just started to say Kaylee, and I guess I was never corrected. So that's my story, and I'm sticking with it. Hey, Jags girl, great to see you. Thank you for joining us. Hope you had a good weekend. Yes, Green-Eyed Cat. We are so happy to have you with us on the team. Good morning, Jags girl. Great to see you today. All right, so we're waiting for, theoretically, this proffer on Kim Jensen. So I watched, we watched the second interview yesterday. And we watched her first interview with law enforcement like a couple weeks ago. And then we watched her second interview of Kim Jensen in front of law enforcement. And very, very interesting thing she had to say about all parties. But as she said, she's going to protect Shanna. That's her number one priority. But if you guys have not watched that, I definitely recommend you guys watch it. We're trying to get our hands on it so we can maybe show it during lunchtime, or so we're trying to get our hands on it. There's a couple people that have shown it already, but we like to ask permission first before we just grab things and start to show them. All right. Just waiting for, I would assume, I guess Judge Kite. Everybody else is there. Jags girl, Kim Jensen talks and talks like Mario. She's got a lot to say. There's no question about that. Brenda, good morning to you. How are you doing? Hey, Jen, how are you? Welcome in. Great to see you. Thank you for joining us today. William, good morning to you. Welcome in. Jags girl, at one point she talked so much I forgot the question law enforcement asked. Didn't that happen with Mario too? You guys thought the same thing. Mario just continued on and you guys were like, what was the question? Well, sometimes that's not a bad thing if you're looking for information. Sometimes that's not a bad thing when you're looking for information. Just let somebody Just let somebody talk. Just sit back and let them talk. All right. Hope everybody had a good weekend. It is August 24th, 2026. It is a Monday. We are in day 6 of the trial of Mario Fernandez Saldana. Week 2, for those keeping track at home. And they were expected to finish this Wednesday or Thursday. That's what they said last Wednesday, I think? They were talking about, they were thinking that they were going to be done by Wednesday or Thursday. So, and then Shanna's, which makes sense because back in pretrial hearings, they said they would be done by the 27th, which is Thursday. So, and then Shanna starts, her jury selection starts on the 31st, which is Monday. Petram, what's on tap today? We are waiting for trial to start. We believe there's going to be a proffer of Kim Jensen to start us, and then day 6. Good morning, Paula. How are you? You know what I mean? Yeah, I know what you mean. I do know what you mean. So, yep. So we're expecting Kim Jensen proffer to start our day, and then day 6. So that's what we have on tap. So once Judge comes in, I'll jump back over here. We'll jump over here once Judge comes in. But for now, I like to look at all the cameras just to see what's happening. Give you guys a little bit different view. So you see behind the camera that I'm in, on the bottom left, you see those jury seats. That's not where the jury sits. That could be when they have a dual defendants and 2 juries. They would sit there, but the jury's actually sitting kind of behind me, if you will. So they do have 2 jury boxes, so that's one of them, but that's not where they sit. They sit on the other side. So they would sit basically behind, over this way. They would sit back there. But at least you kind of see what the jury box looks like. And they have TV monitors, computers, I guess, however you want to say it, a monitor. So whenever they show anything on, and they have huge TVs, they've got 4 TVs, 2 on either side of the courtroom, so you can look. Whatever is projected, whatever they're showing the jury. That's where they showed the video of Brexley. That's where they showed his autopsy photos. That's where they showed the crime scene. So the jury has these TV monitors right in front. All right, so we're just waiting for Judge Kite, it seems like, at this point. I see State's at their table. Mario's got Mr. Hill at his table. I'm just waiting for Judge Kite. And or Kim Jensen. I would assume she would be there if she was scheduled to be proffered at 8:30. Hey, Robin, how are you? What the Healer? Hello, hello. Rob Christopher, how are you doing? Barry, Judge Kite's courtroom is more high tech than Judge A's. Yeah, this courtroom is really very, very well thought out. definitely. What the Healer, I love all the different camera angles. Yeah, I do too. It's fun. Camilla, good morning to you. Joy, interesting. Hope you had a good weekend. We did. I hope you did too. I did. I got a new lawnmower, so I was very excited. I was able to mow the lawn in like record time. So I had a pretty productive weekend. We streamed yesterday. We streamed day 4 of Keefe D, so that was good. And I got some good yard work done over the weekend. Mowed the lawn. Lawn looks awesome. I'm a happy camper when the lawn is mowed. Hey, Rev Ben, how are you? Welcome in. Great to see you. Thank you for joining us. So, P. Cooper, how are you? Let's see. You've been on tour with Mr. Depp. Nice. Very nice. Very cool. That's a great reason to be missing in action. Very cool. Jax Cooks, good morning to you. Welcome in. Great to see you. Ruth Ann, hello. Good morning to you. Thank you for joining us. Jennifer, 7 months. Yes, wow, 7 already. Time flies when you're having fun. Thank you for 7 months. Thank you for your support for 7 months. Thank you so much, Jennifer. Barry says, it rained all weekend here, so I caught up on inside chores, but now the sun is out, so I can see the grass marching growth. Yeah. That's the way it works, right? Rains on the weekend and sunny Monday through Friday. So if you missed it, Friday was Kirsten was supposed to hand over her phone. Judge Kite stopped testimony like in mid-sentence at 9:30 because she got a notification that Kirsten was not going to hand over her phone. So they had Mr. Clifton, who is Kirsten Bridegan's lawyer, they had until 12:30 to show cause or to answer to a show cause, which is basically just contempt. And they filed another appeal, and they got a stay for 3 business days. Hi, what's up, Rafa? So they got a stay of 3 business days, which would be Wednesday. So now they have till Wednesday to sort out whether or not Kirsten is going to hand over her phone or not. Sandra, good morning. Hope everyone had a good weekend, or a great weekend, I should say. Yes, we did. Thank you. I hope you did as well. Kelly, silly question. No silly questions here. Do judges use the same courtroom for different trials or just what's available? I think they are, because they feel like this was a large trial, even though there's like nobody there. The first day it was somewhat crowded, but there was still a lot of seating. And since then it's been very, very quiet, like a couple people in the courtroom. So they probably request certain courtrooms, based on availability, and then based on the volume of what they are anticipating. So I don't know if they use the same I don't think they use the same courtroom. Like if it's not I hate to say it this way, but if it's not a high profile case, they'll probably use a smaller courtroom. But these high profile cases, they use, the main courtroom, which is certainly this courtroom. There's 7 rows on both sides, so you got 14 rows, and each row I think would seat comfortably 7 to 8. You could probably cram in 10 people. So you're looking at 120 people can fit in here. It's pretty big. It's pretty massive. Good morning, Debs. How are you? Welcome in. Grizzly, you're new from Grizzly True Crime. Thank you so much for that. Grizzly B23, appreciate it. We are huge fans of Gisela here. She is a huge supporter of our channel. We are a huge supporter of her channel. So thank you for coming in. Appreciate that. Actually, that was the interview that we watched, was from Grizzly's. She released that, I guess, was it Friday maybe? Thursday or Friday, she released the first interview. So we watched that over the weekend. Let's see. Tao Tao says, I wonder why she doesn't want to hand her phone. Do we know? She is considering it a invasion of her privacy. Well, this is all from her defense, that they think it's a fishing expedition. They want to know specifically what they're looking for, which messages they're looking for, what day, who it's from. So they don't want to just hand over, 4 years worth of text messages. The defense is saying it's going to show bias. It's going to show Kirsten talking to maybe her kids or Shanna's kids, maybe some friends, maybe family, trashing the defense, saying this and that about the defense, because I'm sure there weren't kind words. I'm sure of that. So who knows what's there? Is Kirsten trying to hide something? Who knows? We don't know. Shanna's defense is saying she is hiding something. Kirsten saying, no, we just don't want you looking at everything and anything. So I can see both sides. Judge Kite's trying to ride that fine line between protecting Kirsten's privacy, which she has said multiple times. It's her constitutional right not to have everything, disseminated. And then she also has to be conscious of Shanna having a right to a fair trial because she is presumed innocent at this point in time, regardless of what the public may think. In the court of law or in that courtroom, both Mario and Shanna are innocent. So she's trying to make sure that there's no appellate issues down the road because, God forbid, she doesn't hand over the phone and then Shanna wins an appeal because of that. So she's trying to protect that as well. So Texas Law Cat, good morning. Hey, Mike, how are you? Great to see you. Thank you for joining us. Treasure Hog, how are you? Good morning. Thank you for that, Grizzly. Really appreciate that. Thank you. Dreamcatcher, good morning to you. Beginner Crafter, good afternoon from Poland. Welcome in. Hey, Michelle, how are you? Great to see you. Muggsy, good morning. Welcome in. Hector's mom, hello. How are you? Deb's waving. Good to see you, Debs. Thank you. All right, let's all take a moment and hit the like button. See if you guys have hit the like button yet. Let me just see how many we have here. Just give me a second. Yes, Roger. I know, Rafa, I should say. All right, we got 77 likes. Let's see if we can get that up. See if we can get to 80 likes. If you can hear my voice and you're not in chat, please take a moment and hit the like button. Let us know that you're out there. Here comes Judge. All right, Judge is on the bench.
Thank you. Thank you. Good morning.
Morning.
Judge looks flustered like she did on Friday. She came in like that on Friday, too.
Is there anything that we need to take up prior to starting the trial?
No, Your Honor. Correct.
Of Ms. Jensen?
Right, we have her here. She's present. We're ready to go.
Okay, let's bring her in, please.
She's here. Good morning, Honor. Ronald Manto on behalf of Kim Jensen.
Right, thank you. Good morning.
Good morning. I just wanted to put on the record.
Do you want to come forward?
Sure.
I was trying to pull up my transcript. Give me just a second, okay?
Yeah.
I apologize. I didn't know that it was a proffer. I thought she was testifying, so I would have come out earlier.
No problem. And just for the record, Your Honor, my name is Jesse Dreiser. I represent Mr. Fernandez, who's present. Mr. Hill is present. Ms. Day is present. And Ms. Nepstead is present.
All right, Mr. Mizrahi, if you could put the state of Florida's appearances on the record.
Christina Stifler, Alan Mizrahi, and Steve Siegel on behalf of the state.
Okay.
Okay, Judge. Yes, just based on the statement of particulars that were filed by the state on July 24th, I believe that Ms. Nelson would be in a position to invoke, but she's been served to testify, and therefore I believe she's under the protection of Florida Statute 914.
Well, my understanding of the case law is that she cannot just blanket invoke. So it has to be question by question. What is she going to testify to and what she's not? And then the court has to make a finding about whether there is any type of meaningful ability for cross-examination in order to determine if she would testify. That's my understanding of the case law.
Yeah, I think we're in agreement that the state is, based on the subpoena that we've provided the witness, that we are providing her immunity for her testimony and cannot use it against her. And therefore, she's going to be willing to testify. I think Counselor just wanted that on the record, that what she says cannot be used against her. And that's
Okay.
your statement.
Therefore, she doesn't have to invoke for every question. We're in agreement that she's afforded the protections.
All right. So where is Ms. Jensen?
She's right here, Your Honor.
Okay. Good morning, Ms. Jensen. Come forward, please. Raise your right hand to be sworn in.
Ma'am, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, Ms. Jensen, before you take the witness stand, I'm going to have you kind of step back so that it doesn't, no. I mean, back outside when you're called as a witness, so it doesn't appear that there's something unusual going on. Most witnesses just come in from the doors. Do you understand? In just a minute. So I need to have a conversation with you, though. Give her a microphone, please.
And Judge, maybe a little bit of background as to what we expect is going to happen. Ms. Rahi is going to enter proffered evidence, and then unless there's a major changing in the court's ruling, I do not believe Ms. Hall
Would not.
would not be.
It's on.
Okay. All right. So, Ms. Jensen, first, let me make sure that you understand. Do you understand what your attorney is explaining to the court?
I do.
Okay. Which is what?
That I have
You have a constitutional right.
to invoke.
Right. And so the state is giving you a subpoena. So that means that.
I was forced to come here, not, right?
Right, but you're compelled to come here.
Right.
But on top of that, more important than that, is that if they gave you that subpoena, that means that your testimony, since they're compelling you to talk, to testify, then you would have immunity as to the answers.
Yes.
Okay. So that's important to understand, because otherwise, if you did not have that, then they could possibly use this as some sort of information or statements to use against you. You understand that?
I do.
All right. So the second part of this is that this is a proffer, meaning that they're going to call you to the witness stand. There won't be a jury here. So I'm going to determine whether these questions would be asked in front of the jury or not. So what's important is that, I try to explain this to witnesses, because proffer means an offer of proof. So he's going to ask you some questions that he would want to ask in front of the jury. So I like to explain it to witnesses, because you're like, why are they asking me the same thing again? It's because the jury's not here. The jury is the fact finder. Do you understand that?
I do.
And so I'm trying to make a legal ruling, all right?
Okay.
You've already been sworn in, so you can go ahead and take the witness stand. You can take the microphone away from her. There's one on the witness stand.
Thanks, Ron.
Do you want to take this?
So there's a slight incline here, okay?
I thought you wanted her to go out and come back in.
Did you want me to go back out?
No, not yet. You just have a seat. All right, Mr. Mizrahi.
Thank you. Please state your name for the record.
Kim Jensen.
And how do you know Shanna Gardner?
I know, I initially met her probably 11 years ago through church.
And would you consider yourself close friends with Shanna Gardner?
Yes.
Have you
Come
had
up a
the
little bit closer.
opportunity to review a series of text messages that have been labeled State Exhibit 10F for identification?
I did.
And are these some of the text messages that you and Shanna Gardner exchanged and you and Susan Lee exchanged?
They are.
Okay, Your Honor, I would enter this as a court exhibit.
All right.
Exhibit 1.
I'm assuming no objection to that for the court exhibit.
As a court exhibit, no objection.
Okay. Can I see it? Thank you. You can proceed.
Thank you. So, Ms. Jensen, many of those text messages have to do with Shanna Gardner's ex-husband, Jared Bridegan. Is that true?
Correct.
Describe for the record how the divorce went and how the child custody went with regard to Shanna Gardner and Jared Bridegan.
From a legal standpoint, I guess the divorce went quickly, but it was not amicable at all. And the child custody was 50-50. And that was the ruling.
How did Ms. Gardner feel about Jared Bridegan as a father?
He frustrated her as a father.
And did Ms. Gardner share with you that she wanted to have more custody of her children?
Shanna wanted more communication more than anything.
Okay. Does that include that she wanted more custody or no? Yes or no? Or I don't know.
I don't know.
I'm going to object to leading. She's free to answer the question on direct as she wishes.
I don't think giving 3 potential options of an answer.
I'll overrule it. Go ahead.
You would, well, let me ask you this. In those text messages that have been entered as a court exhibit, did Shanna ask about a hitman?
Those were in the text message.
And based on that request, you texted another friend, Susan Lee, about finding somebody for Shanna. Is that fair? Or?
That's not fair.
Okay. Well, what do the words say?
The words say that.
You've testified previously that you were joking about this. Is that fair?
Something that had nothing to do with Shanna, yes.
But you would agree that shortly after Shanna asked you for a hitman, that you then reached out to Susan Lee.
I'm going to object to leading again.
I'll overrule it for the purpose of the proffer. Okay. So we can get through it.
Yes, ma'am.
I did reach out to Susan Lee.
And the words are what they are.
They are what they are.
Okay. Describe for the record how Shanna married Mario, what you knew about it, and then what your relationship was with Mario Fernandez.
How she married him?
Yeah, what did you know about it? Was it fast? Was it slow?
It was fast. She met him and then married him within just a few months. It was it was quick.
And what did you think about Mario Fernandez?
I thought she shouldn't marry someone so quickly because I didn't know Mario particularly, and I didn't think that she was ready to move on.
And do you see Mr. Fernandez here in court?
I do.
Can you say where he is so you can identify him for the record?
Right there in the blue suit.
I made the record reflect the witnesses identified the defendant.
Yes.
So did you have conversations in the presence of Shanna Gardner about Jared Bridegan with Mario Fernandez?
Maybe. Most of my conversations were strictly with Shanna.
Okay. In your meeting with Mario Fernandez, did you think that he was a boastful individual?
I did.
Did you think he would brag about being able to do things that you believed he could not do?
I did.
And was that, just describe a little bit more for us.
Mario was always a big talker. I always believed that he wanted to be the biggest person in the room. His personality was such that he always had a story about everything. He always had, he always knew somebody. That was his personality. He had a very big personality.
And did that big personality sometimes relate to his Navy career?
I think it was Army, but yes.
Okay. So he would talk about doing big things in the Army?
Yes.
Okay. Did then Shanna Gardner ever share with you statements that Mario made about being able to fix things, take care of things?
And just for the record, I'm objecting as the same objections that I've made in my motion to eliminate, Your Honor, that you've ruled on.
So just so that I'm clear, this is the objectionable part that you're indicating. There's no objection to the previous testimony? Just so I know that what I'm ruling on.
Yes, well, it's very complicated. There's going to be two separate things that I don't think any of that other stuff get to if this statement doesn't come in and your ruling stands. And I think Mr. Mizrahi agrees to that. Those conversations that Ms. Jensen just testified to, Mr. Mizrahi specifically said that Mario was present for. So obviously there's no marital privilege to that.
Right, so y'all keep doing this. A proffer is get to the objectionable part. So like if there is no, Mr. Mizrahi, if there is no objection to that, I've heard Ms. Jensen testify before. And so if you could get to the part that you believe I need to make a ruling on, that's what I'd like to get to. If there's no objection to this and other stuff, there's no need for me to hear it.
The state of Florida has to lay some background. This is not a situation where the witnesses testify and we let the jury out. I have to let some background.
I agree.
So I spent 5 minutes laying a background and
Longer than that. Longer than that. Get to it, Mr. Mizrahi.
I am, Your Honor. I'm getting to the point now where that's why he objected.
Well, so I'm sorry, but just to be very clear, that court exhibit, Your Honor, would never come in, and we would object to that. But
okay.
I got it. Move on. Mr. Mizrahi, go ahead.
Yeah. So describe the things that Shanna Gardner shared with you about Mario being able to fix things.
That was his catchphrase. He would say that about all things, no matter what it was. If it had something to do with me, if it had something to do with the kids, that was just a common phrase that he would say.
And did Mario Fernandez share with Shanna Gardner that he could take care of, fix the issues Shanna Gardner was having with Jared Bridegan?
In a family law setting, he would say he believed that they could use the family law courts and fix the problems.
And so that's something that Shanna Gardner shared with you, that Mario says he can fix it, he can take care of it. In a family law setting is what your impression was.
Yes, that was my impression.
So did Shanna Gardner also share with you that he could take care of it because there was a motorcycle gang that was living in close proximity to Jared Bridegan?
When Shanna relayed that statement to me, it was I have eyes.
Okay, and that statement, I have eyes, has to do with Jared Bridegan.
I have eyes on the kids at all times, so yes, I guess.
Did Shanna Gardner share with you that Mario Fernandez shared that he was close on multiple occasions to Jared Bridegan?
I don't know that I remember that.
Did Shanna Gardner share with you that Mario Fernandez had eyes everywhere?
Yes.
Did Shanna Gardner say that Mario Fernandez said that there had been missed opportunities?
Yes.
As far as taking care of the situation with Jared Bridegan?
I'm not 100% sure if those were the words.
Tell me what you remember.
You're asking me to go through years. I just need you to be more specific, please.
Okay. Well, have you previously testified that there were missed opportunities with regard to Jared Bridegan? Have you had the opportunity to review your grand jury testimony?
I did.
Would you refresh your memory to look at it again?
Please.
You have it.
said grand jury testimony, I really meant your hearing testimony. So would that help?
If you show me.
Look at page 76 of the hearing testimony. You go up there.
So what was your question again?
Did Shanna Gardner indicate to you that Mario Fernandez said that there were missed opportunities with regard to Jared Bridegan?
I don't see those words here. Oh, maybe down here, maybe. That
Point two.
was a question.
What was your answer?
I don't see an answer here. I said, my answer is, I mean, I heard the whole hearing, so I did hear the statements. I don't see where I answered that question.
Well, if you keep going, you do. 18, 19, page 77, lines 18 through 25.
I mean, depending on the question, I guess it's possible, but I don't think so.
Okay. Now, turning to page 78, lines 5 through 7, do you recall the statement? We'll just do it like that, it's quicker.
Okay.
That there was a delay based on COVID?
My answer was, I never said anything about a delay in killing Jared because I never had any knowledge of Jared being killed or planned to kill him.
And then lines 13 through 16?
Not long after that, Mario had made a statement that he never goes anywhere. Neither did anyone else in COVID. Like it just didn't seem, you know what I mean?
I'm going to ask you a couple more statements and then we'll be done. Do you remember a statement that was made shortly before Jared Bridegan's killing?
Can you be more specific?
Hawaii.
I remember talking to you about Hawaii.
Okay. Tell, for the record, and tell the court what you remember Shanna Gardner telling you.
Shanna told me that they were getting divorced and how they were going to go about that as far as the kids were concerned. And at some point, Mario asked her if she wanted him to take care of anything. And she said, Jared, and he said, or she said, absolutely not. I don't want anything to happen.
So say that again since you kind of mixed it up.
What did I mix up?
But take care of who?
He asked if there was anything Shanna wanted him to take care of, and she said Jared, and then she said absolutely not.
Okay, so who said Jared?
Shanna.
Okay, so I want to break down. Mario Fernandez says, is there anything you want me to do to take care of?
Correct.
And then she said Jared.
Yes.
And then Mario said, okay.
Mario didn't say anything. She said no.
And then she said no.
And she said absolutely not is what she said.
And this is what Shanna Gardner is relaying to you a week or so before the homicide.
I can't be sure. I told you originally that I wasn't 100% sure which trip that was, because every trip had something to do with divorce in the past, in the couple of years prior.
Right. You know when the murder was.
I do.
And you were aware of this statement a couple of weeks before the murder.
If it was that trip, but I said I couldn't be sure because there were many trips.
Okay. All right, Your Honor, that's all the questions I have.
Just so that I'm clear, and y'all can ask whatever questions you need to after the fact. So the Hawaii trip, when you said they are getting a divorce, you mean Miss Gardner and Mr. Fernandez?
Yes.
Okay. right, Mr. Dreiser. Sorry.
Ms. Jensen, good morning.
Good morning.
I only have a few questions for you. To be very clear, this is what Miss Gardner is telling you,
Yes.
a conversation that she had with her husband.
Yes.
You have no doubt in your mind that Mario Fernandez did not know that she was sharing these things with you, correct?
Correct.
And Mr. Fernandez you have never heard any of the words that you testified to regarding this last conversation, and most of your testimony, that Mr. Fernandez wasn't present for that. That's what Ms. Gardner was reporting to you that her husband told her, correct?
Yes.
And even that last statement, you don't know what Hawaii trip it happened on, do you?
I don't.
And there were many Hawaii trips, correct?
There were.
And divorce was something that was talked about from time to time with you and Miss Gardner, correct?
Yes.
Okay. Regardless of how quickly they got married, Mr. Fernandez loved those children, right? That's what you believe?
I believe that.
And he was an active and engaged stepfather?
He was.
And Mr. Mizrahi didn't ask you in those statements the questions in between all the different questions, but you would agree you kept telling Mr. Mizrahi that Mr. Fernandez just wanted to keep Ms. Gardner safe. That's what he was referring to in all those questions, right?
Yes.
I don't think I need anything else, Your Honor.
I just want to make sure. So the questions by the defense, those are specifically related to Hawaii, the Hawaii statement.
And all the other statements that Ms. Jenkins said that Mr. Fernandez was not present for. That's what was
That's the problem. So I don't know that the defense needs to do it, but that is the purpose of the ruling. It's not necessarily all these statements. It's the circumstances surrounding the statements that.
I totally agree. That's why
I don't know anything about that to make a ruling. It's the circumstances for which the statements occur.
Circumstances under which the statement, state theory, that there's true prong way why this comes.
I understand the state's second theory that it's about child custody. However, I want to be clear. I think about 45% of her testimony could be admissible. I find probably 3 statements that she couldn't make. I don't think that this is admissible. There are no circumstances for the court to make a ruling. However, the facts and the circumstances related to the Hawaii trip, I don't know, were they just made via witness to Ms. Gardner or vice versa on a telephone call? Was he sitting on the couch? That's what I mean, the circumstances.
It was a call between Shanna and I. I believe so.
Judge, there's no dispute. Mr. Mizrahi will agree with me. Mr. Fernandez was not present, and he did not know that she was ever going to share those communications. So there's nothing in your ruling that you heard today that's different.
Well, I want to be very clear. I did not say that she couldn't testify. Like I said, I think probably about 45%, but for these private text messages back and forth between, I don't know who some of these numbers are.
They're not.
But anyway, you're not. Okay, so I'm not making a ruling on that. You just want it admitted for what purpose? So as it relates, hold on, let me pause you. As it relates to the co-conspirator statements that pass prior to her marriage of Mr. Fernandez, I'm not excluding that. Okay, so, but you're not admitting this. Okay.
conspirator hearsay statements heard before Mario Fernandez getting that these conspirators. There is would have been a potential process confrontation.
Okay. All right. So the state is, all right, so you're putting in a court exhibit that you do not intend to actually introduce as evidence. However, the statements, I only really see 3 potential problems with the admission of some of these statements. The Hawaii statement, a private conversation between this witness and
Statement, main purpose, why I'm doing all this once. That is why I'm on a proper Friday, it's why I'm putting on a proper April, American privilege, here's meeting.
right. Thank you, Ms. Jensen. Do you have anything further for Ms. Jensen?
No, can I have 1 minute with counsel?
Okay.
So unfortunately, we missed those last couple statements that Mr. Mizrahi said there.
The state and I I think we understand it wasn't as clear, but I agree with the court. Anything that she heard Mr. Fernandez say, it would be admissible if the state so chooses to call her. I did not object every single time this morning because
Right.
I was trying to get through it. Most of what she testified to was just what Ms. Gardner told her, and the state agrees with me. They're not calling her to put any of that in. So just so the court's aware, I would have objected to every single question where she was reporting what Ms. Gardner told her Mr. Fernandez said. With that being said, I think the witness can be excused.
All right. Just temporarily so that I can make a ruling. Okay.
Okay.
Thank you.
All right, so this was a proffer, which is really interesting because the judge said she thought that she would be testifying, thought Kim Jensen would be testifying. She didn't think it would be a proffer. But my notes say the very last thing on Friday was there's going to be a proffer at 8:30 of Kim Jensen. So they talked about it. For whatever reason, Judge Kite maybe just didn't connect. So the defense was going to object to anything that Kim was going to say. Shanna told me that Mario told me this. So that's going to be like double hearsay or hearsay out, left and right. So that's what the defense was going to object about. But what Kim actually testified today or proffered today was that there was never anything about Mario told Shanna this specifically. And the judge is saying 45% of this testimony would be admissible. She said there was only like 3 things. Although it's really interesting, I just finished saying, oh, wait, hold on.
Thank you. So I wrote in the court's order, the state's secondary theory related to Ms. Jensen. I've rejected that line of thought. I saw no support in the law nor the rule that would allow the state to submit that statement and pierce the marital privilege. I left open the potential that if there were circumstances surrounding the actual statement that would basically the privacy would fall away. The circumstances for which it was made, but generally speaking, I believe that the exceptions to the marital privilege outside of the privacy area are well defined. It is a crime against either one of their children. AB and LB are Miss Gardner's child. But none of what I saw, and I'll hear you out, changes the court's analysis. So I'll hear you if you want.
Yeah, just very briefly. Thank
Okay.
you. The AB and LB are victims of an intentional act that reasonably could lead to their physical or mental injury. Because this is not a murder that is done for a gang reason or for money reasons, and tangentially those children are injured. The goal and purpose of this homicide was to take away Jared Bridegan's parental rights to eliminate their father intentionally. This was the intentional act done that could lead to their physical or mental injury. LB and AB are children of Shanna Gardner. Therefore, she has the ability, her statement pierces the marital privilege because it's a statement about the homicide involving her two children. That's the theory. The reason why we put on Mr. Ponder yesterday is it was direct evidence from the defendant's mouth to Mr. Ponder's ears that the purpose of this homicide, the purpose he hired someone to do this, was for child custody issues. So this isn't the act itself was an intentional act to inflict physical or mental injury upon these children. In addition to obviously Mr. Bridegan, but that was the goal of it. In order to prove a child abuse, that the act has to be intentional. So the court's concerned that it was just some random act of violence. That would not be intentionally to the children. The court.
That's not my concern.
Okay.
What criminal case has ever centered on child abuse where the children are physically safe in their house and let's say the other spouse gets beat up, or let's say it's that, beat up by the other spouse, and then somehow that pierces some sort of marital privilege. AB and LB, I believe we all could agree, were safe, at home, dropped off, physically safe. So the mental argument by the state is that, I guess, do you know a case where that's been the child abuse theory?
There are cases where the child abuse theory has been premised on mental injury, 100%. There is not a case that deals with child abuse that mental injury is the reason to pierce marital privilege.
No. Have you seen a child abuse case where one parent is trying to get custody over another parent and therefore the state of Florida intervened with criminal sanctions saying that, no, that's child abuse?
No, there is not a child abuse that I'm aware of, at least an appellate case, an opinion case, where the murdering or injuring of another parent for child custody.
I'm not talking about, let's say not murder. Let's say just a third-degree child abuse where the state of Florida goes and arrests another parent because they want more custody than another parent.
Well, that would never be a child abuse.
Okay, but that would be mental. That would be mental injury on the child potentially, right?
No.
Okay.
You're talking about murdering their father.
All right. What about breaking their legs?
Well,
breaking their legs or doing something horrible to the other parent.
That doesn't interfere with their custody. They still have custody of their child if they're beaten up, if their legs are broken, if they go to the courts. That's all legal methods. You're talking about the only true way that they could eliminate custody, the only way they could take this father away from his children was to murder him. There is no other way. That's our theory, is that that was done intentionally, and that reasonably could lead to the children's injury. It's a very unique set of circumstances. Certainly, we don't have third-degree child abuses under that premise because it wouldn't exist. We do have third-degree child abuses with an act that could intentionally lead to mental injury to a child. Those exist.
Quote me a case.
I don't have a case right off the top of my head. It's the statute. And there are certainly premises under the statute, under 82703, It says an act that reasonably could lead to the physical or mental injury of the child, and we have to be able to prove those elements. There's not a, I mean, I could probably find one. I don't have it at the top of my mind because there's not one. I concur with the court. There's not going to be a case that says that pierces marital privilege. There are, and I submitted in our argument, cases where the reckless driving pierced marital privilege.
Right, but that was one parent that was driving and then injured the child. That's, in my mind, so factually distinct from this scenario.
I don't think the child was injured at all, Your Honor. If you read the case, that child was subject.
I've read a lot of cases very recently, so I apologize for getting it. But I believe that it related to the child. I'll pull it back up.
Yeah, the child was in the car and the person was driving recklessly, and that could lead, that was considered a child neglect. It wasn't an abuse, it was neglect. For failure to provide the care necessary for the child's well-being by driving recklessly while the child was in the car. I agree that was, the child was in the car when the recklessness occurred. But it doesn't change the state's argument that the intentional act was to eliminate the parental rights and take away these children's father.
That case also went to the premise of the psychopatient privilege. That's what the court was ruling on, not the marital privilege. They punted, or they didn't need to go to the marital privilege because they relied on the psychopatient privilege, which does not have the same elements as the marital privilege. I'll just wait.
What's interesting is that was one of the charges because Brexley was 2.5 years old and almost got taken out, but they dropped those charges from Mario's case. They dropped that charge in one of the pretrial hearings. So I'm not quite sure why they're arguing that's one of their theories. I mean, I guess it could be a theory, but they dropped that as a charge. That was one of the charges that they dropped. This angle gives me closed caption, you guys. The other angle, I don't have closed captioning. So that one I don't have closed captioning. This one I do. So we'll hang here for a second or two. Yeah, Jags girl, I agree with you. Yeah, this is about the twins. This is more about the twins and the parent, the father, Jared, being removed, that causes mental and physical I can't say it on YouTube, but you know, the A word. Hey Beach Mom, welcome in. Pippi, how are you doing? Hell Rider, welcome in. Good to see you guys. Thank you for joining us today. So judge is going to make a ruling, and the state, I think, was trying to find some case law. I think that's what they were trying to do. Let's go back here. Yeah, I think Mr. Mizrahi is trying to find some case law. And the judge might be trying to find some case law too. So that's what we're waiting on right now.
So there's a Florida Supreme Court case, Dufresne, Dufresne v. State. It's a Florida Supreme Court case, 826 Southern 2nd 272, that goes through, I guess there was a challenge to the phrase mental injury, where there was a constitutional challenge for vagueness, and it goes through the history where it falls. The Florida Supreme Court, it says that we know the definition of mental injury now found in 39, that's when they redid the statute, this is a 2002 case, is a limiting definition as opposed to a broad definition, which benefits the defendant. Thus, mental injury, as defined, will present only in limited circumstances, thereby discouraging arbitrary and discriminatory enforcement. Accordingly, pursuant to this analytical framework, which sets forth in Fuchs, we conclude that the district court properly held that the challenge statute is not unconstitutionally vague. Mental injury is adequately defined, is what it says. And I'll go back up to what they are affirming is not vague, which in 39, I know the state is focusing on the intentional part because your theory is that the murder is the intentional act that would somehow produce this, which is mental injury means an injury to the intellectual or psychological capacity of a child as evidenced by a discernible and substantial impairment in the ability to function within the normal range of performance and behavior. So you're saying that LB and AB, that is the fact. So I would need more facts there.
I understand the court's, I understand that law. I'm very well of the mental injury law and what is required. I would point, Your Honor, to Hill v. State, which I argued at our last hearing at 846 Southern 2nd 1208. It's a 2003.
Repeat the last numbers.
I'm sorry. 846 Southern 2nd 1208. It's a 2003 Fifth DCA case, and under head note 5, 6, and 7. Your Honor, we don't have to prove beyond it to the exclusion of a reasonable doubt that a child abuse occurred. In fact, the court quotes, and I'll read it for Your Honor, although we have found no case in which the defendant has been convicted of this crime of child neglect based on reckless driving of a vehicle, if the defendant's reckless driving is shown to be sufficiently gross, there is no reason why the charge could not be proven. Because of the clear statutory language in both Section 39, which is what we're going on, we agree with the trial court that the psychotherapist patient privilege does not exist in this case as to any communications relevant to the child neglect felony count. So the law doesn't require you to prove.
I'm not putting that burden on the state.
Sorry, what?
I'm not putting that burden on the state. I don't want you to even argue that. I'm not putting that on there. However, I do have to find that would be potentially a child abuse, correct? In some form. I'm not saying that you have to prove beyond a reasonable doubt each and every element, and I don't want you to think that I'm doing that.
Okay.
And as well as I don't want you to put on an entire proffer of things that I probably about 80% I would allow. I'm not putting the state in a box like that. Instead, I don't know, just like the state is being cautious, saying that we don't want to put in evidence that there was a pre-existing conspiracy for confrontation. That's your choice. That's your strategic choice. However, I need a legal path to admissibility. Admissibility isn't beyond a reasonable doubt. So I want that to be very clear. I'm not putting that burden on the state.
Okay.
But I do, you would agree, Mr. Mizrahi, that this is unorthodox.
I wouldn't call it unorthodox. I would call it using the law to get in pieces of evidence. That's what I would call it. I wouldn't call it unorthodox.
All right. So Earhart is like my favorite book.
I love it too. I've seen
Okay.
him lecture many times.
Me too. All right.
You have.
Total fan club. However, I don't see the Earhart has anything. And he
doesn't.
is a guru on evidence that would even suggest a path like this.
My argument to the court's last inquiry about whether or not it is inconceivable that a 9-year-old child whose father has been murdered would not have some discernible psychological issues as a result of the elimination of that parent. This is not unorthodox or way out there. It is incredibly logical that if a child loses a parent, that they will be subject to some type of psychological damage as a result of it, discernible as required by Dufresne. So I think the court's analysis ends there. Is that reasonable? Yes, I think that's reasonable. Therefore, it pierces husband-wife privilege, and it is admissible. That is the state's argument. And if the court, I agree with the court that there is not a case on point, on all fours, that deals with this issue. I agree with that. I agree that with the reckless driving, the child is in the car. This is a mental injury situation as opposed to a reckless driving situation when the child is in the car. Those are two different scenarios.
Well, let me ask you this. I'm still messing. I've got to figure out what Mr. Mizrahi is, what his path to admissibility. And he keeps saying all these much higher hurdles that I'm not putting on the state.
Okay.
And so let me go ahead. What's your objection?
My objection is, and I've been quiet and letting the court and Mr. Mizrahi go, is that you made a ruling and you gave a pathway to the state to see if they could breach the marital privilege. And they put on their proffer. There was no breach of the marital privilege. And now Mr. Mizrahi is getting essentially now what's been 30 minutes of an opportunity to re-argue and start citing case law of cases you've already ruled on, you've already read, that is not what today's hearing was for. It was, your ruling was very clear. If they can breach the privacy, then you made the ruling. You've read Hill. You've read all these cases. So I'm just sitting here letting him get a second bite at the apple in the middle of the trial. And I think that's unorthodox. I think your ruling, which was written, well thought, well written, and took time and days before we got a decision, is now just being relitigated on the very premise of not what you said they could do, which is break the marital privilege. And that is frustrating as I sit here and allow this to go on, but it's as you see fit, Your Honor.
So this is where I'm at. In that hearing, there was the opportunity to call these witnesses. It didn't happen. The state is able to make a record, which they're allowed to do, which is a proffer. And while I don't necessarily, generally speaking, proffers are the objectionable evidence, and their record needs to be clear, Mr. Dreiser, that generally speaking, the proffer only includes what is being objected to. Like I said, I don't want the appellate court to be under the impression that I ruled all of that inadmissible, which I did not. I don't want the state to make a record saying that I'm saying that it's not admissible because they have to prove something beyond a reasonable doubt. It is not. I know the rules of evidence. So I don't want, that is what I'm doing. Okay. So as far as that is concerned, I have heard part of this. I haven't seen it in real life. I did not know what the purpose of Mr. Ponder was or what he was saying, I guess, at the very end. And then I want to make sure that the record, what you're objecting to is the Hawaii statement. And then some other statement that was made on the phone, but there were statements put in that apparently Mr. Fernandez was here for. And so that would not be marital privilege. That is not inadmissible.
I agree.
And so my last question for Mr. Mizrahi is that the statements that you were seeking to admit where you're saying it was related to child custody, you're depending on Mr. Ponder, not from Ms. Jensen, because she said that Mr. Fernandez said he was going to fix things through the family law system.
Well, it's both.
It's both. Okay.
It's both. The Ms. Jensen doesn't say that Mr. Fernandez said he was going to kill Jared Bridegan for child custody. That's why we put the Ponder on that.
Okay.
The Ponder statement is the direct evidence the murder is done with the intent
Let's
be
be
child abuse.
All right.
Mr. Ponder did not need to be proffered. I agree. You weren't making a decision as to whether what he could say comes into evidence. You were very clear about that, and I agree with the court. They just chose not to call Mr. Ponder for strategic reasons. They had no, Mr. Ponder.
They have?
Yes, they have chosen not to call him.
Okay.
And they brought him in to tell you evidence that the jury has not heard that could come in. He can say what Mr. Fernandez told him, and then I'll cross-examine him, and the jury will decide what they're going to do with Mr. Ponder. But now they're trying to get in what Mr. Ponder said to influence your ruling when that's I don't know why they proffered it, quite frankly, I guess to stack inferences, but Mr. Ponder could have testified in front of the jury. He wasn't saying anything, as you said, you don't make determinations on believability. You make legal decisions. There was no legal objection that I know of that I could prevent Mr. Ponder from testifying. So let's be very clear about that.
Okay. Well, I didn't know the state wasn't calling him. So, all right. If you, Mr. Mizrahi, I stopped you because I thought he was going to testify and they'd hear all of that stuff. I needed to make a legal ruling. But if you wanted to put him on again to, I guess, or put his deposition in, I don't know. But I stopped you because I thought he was going to testify.
The state does not need to recall Mr. Ponder for any purpose of the proffer.
All right. So
We have put on the evidence that we think the court can make this decision, and we understand the court's previous ruling, and I've made my argument, so we're good.
all right. I'll maintain the ruling. Are y'all ready to get started?
Yes, Your Honor.
Ms. Jensen, you don't want her anymore?
Excuse, it needs to appear. And needs to be appear for the Gardner case. And she's under subpoena.
Okay. Thank you. Nice meeting you. Ready? Ready? We'll see. Mr. Hathaway, will you get that exhibit? Who's the state calling?
Fred Barton, Your Honor.
Thank you. Waiting for them to be
Sorry, I didn't
ready.
do that, Mr. Conversation.
So after all of that, judge is going to stand by her ruling. After all of that, judge is going to stand by her ruling, which
Thank you. Thank you. Welcome in, members of the jury. Everyone may be seated. Welcome back, members of the jury. I hope that you all enjoyed your weekend. We are in the 6th day of trial. I want to, before we begin the proceedings today, just confirm that you all follow the communication rule over the weekend's recess. If you could all answer out loud.
Yes.
Okay, great. Now, to remind you where we are procedurally, the state of Florida is presenting their case. They're going to call their next witness. Ms. Stifler?
Your Honor, the state calls Fred Barton.
Fred Barton, please. Good morning, Mr. Barton. Come all the way forward, please. All right, raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, sir, go right to your left and then be seated in the chair. Pull yourself all the way up so that you're speaking into the microphone, okay? You may proceed.
Thank you, Your Honor. Good morning, sir.
Good morning.
Can you hear me okay?
Very well.
Thank you. Could you please state your name for the record, introduce yourself to our jurors, please?
My name is Fred Barton.
And Mr. Barton, do you live here in Duval County, Florida?
Yes, ma'am.
How long have you lived here in Jacksonville?
Since I retired from the Navy, 2002.
And what do you do for a living, sir?
I'm a manager for Allied Security Company.
I'm going to keep this brief because I know you got to get back to work. I want to ask you about an incident that occurred several years ago with a man named John Biggerstaff.
Mm-hmm.
Do you know John Biggerstaff?
I do.
Can you tell the jury when you met Mr. Biggerstaff originally?
I can't remember exactly, but I met him years ago through his wife, who I met on a dating app.
Okay, and you had some kind of dating relationship with his wife?
That's correct.
She was married to Mr. Biggerstaff at the time?
That's correct.
And did you and Mr. Biggerstaff have any type of interaction yourselves?
No, just when I went around their house, he was there, or he would bring her to my house. She would stay with me on the weekends.
No problems with him? This was a consensual, everyone's copacetic type of relationship?
If you could say yes or no, please.
Thank you, sir. At some point, did you become aware that Mr. Biggerstaff was being federally prosecuted?
I did.
And during that time, did you know that he was going back and forth to federal court during his case?
I did.
And I want to ask you about, while he was litigating his case, did he ask you to hold an item for him?
He did.
And did he bring that item to your home?
He did.
Can you tell the jury what that item was?
It was a metal cabinet. He called it a gun cabinet, but I don't call it a gun cabinet, but it was a metal cabinet. And he brought it to my house, asked for me to hold it until his son would pick it up the following week on Friday.
And I know you can't remember the exact year, but in the timeline of his case, when did he bring this gun cabinet to your house?
The last conversation I remember having with him was based on his attorney advised him that he needed to get rid of those guns or any firearms in which he had possession of, because if he was convicted, he wouldn't be able to touch them, do anything with them, so he was giving them to his son.
Okay, so this was prior to his sentencing, but after he was originally arrested and litigating his case?
That is correct.
When he brought the locker over, where did you store it at your home?
In my closet, in my bedroom.
How did he bring it over?
He came over and I put it on a hand truck, and he brought it to my room. I put it in my room and locked my room, because I locked my room on the outside because my kids used to break in my room. So I locked my bedroom also to keep them from breaking in my bedroom.
Okay, and so he brought it on, he said a hand truck.
Mm-hmm.
What is that? Like a dolly?
Well, it's a hand truck. You just pull it back and you roll it high. You got to...
Did you ever look inside the gun cabinet?
Never had access to it. Told him I didn't want access to it. I don't want to have any responsibility if anything's missing, damaged when he picked it up. So I couldn't tell you what was in it.
You couldn't tell what type of firearms were in there?
I wouldn't even know if there's firearms in it because we never opened it prior to him leaving it. We didn't open it when he came to pick it up.
Right. So you never looked inside.
Mm-mm.
You wouldn't know what's inside other than his statements to you that it was
Correct.
a gun cabinet and his lawyer told you to take it with his
That is correct.
Who came and picked it up?
Him and his son.
And what's his son's name?
Juan?
How long after Mr. Biggerstaff dropped off the gun cabinet did they come pick it up?
It's about a week, the following Friday.
Did you keep any firearms or ammunition that Mr. Biggerstaff brought to your home?
No.
Would any of his firearms or ammunition, if they were in that gun cabinet, have been left at your home?
No.
Do you have any of Mr. Biggerstaff's firearms or ammunition to this day?
No.
And you're obviously in your job at Allied Security, you're lawfully allowed to possess and own firearms.
Yes, I have a gun from them.
Do you know the defendant in this case, Mario Fernandez?
Never heard of him.
Do you know a woman named Shanna Gardner?
Never heard of him.
Do you know a man named Henry Tenen?
Never heard of him.
Do you know a man named Jared Bridegan?
Never heard of him.
May I have a moment with counsel, Your Honor?
Yes.
No further questions. Thank you, Mr. Barton.
Thank you. Cross?
Yes, Your Honor. Good morning, Mr. Martin.
Good morning.
Nice to meet you. My name is James. I represent Mario Fernandez.
Mm-hmm.
If I understood correctly from your testimony, sometime in a year that you don't recall, Mr. Biggerstaff brought over this cabinet as you described it.
Mm-hmm.
Is that a yes?
Yes.
Sorry, we just have a court reporter. She needs to hear exactly what your answer is.
I got you.
My understanding is you never opened that cabinet.
That's correct.
No idea what was in it, correct?
That's correct.
And if there were firearms, no idea how many?
That's correct.
Certainly no idea what make and model of those firearms.
Say that one more time.
You wouldn't know what make or model of firearms in a cabinet you've never opened.
He never opened it. I never opened it. He never opened it. I never wanted it to be open.
Understood. And that was about a week it was in your closet.
That's correct.
After that, you testified that his son, Juan,
And him.
came and retrieved that cabinet.
That's correct.
Where it went after that, you have no idea.
I've never seen or spoke to them ever since that.
And certainly you would not have given firearms to a convicted felon, correct?
I definitely wouldn't have done that.
As to whether or not that cabinet was transported somewhere else and opened, you wouldn't be able to testify to that.
I wouldn't know what they did with it once they left my porch.
And what year do you believe this?
I don't recall what year it was.
And ultimately, you and Mr. Biggerstaff had a falling out later on. Is that correct?
Well, I distanced myself once he got convicted of what he told me he was innocent of.
You and John Biggerstaff no longer had a relationship at that point?
At all. Not at all.
And I know Ms. Stifler asked you whether or not you knew Mario Fernandez. That name means nothing to you other than maybe at the top of the subpoena that you were served.
That's correct.
And so you have no information as it relates to the homicide of a man named Jared Bridegan.
Except for what I see on the internet.
But you personally have no information as to...
Never seen him before in my life. Never heard of him.
And certainly no information as it relates to Mario Fernandez and the homicide of Jared Bridegan.
That's correct.
May I have just a moment, Your Honor?
Yes.
No further questions for Mr. Barton.
All right. Any redirect? Thank you.
Be excused.
All right. Thank you very much, Mr. Barton. You can step down. Call your next witness.
State calls John Biggerstaff.
John Biggerstaff, please.
He has a walker, so he may take it.
Okay. Okay. Good morning, Mr. Biggerstaff. If you could walk all the way forward, please. Good morning. Can you raise your right hand and be sworn in?
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, if you'll make your way over to your right. Mr. Holman, can you help him with his walker as well?
Jim, I need the...
Just get yourself situated in the chair, okay?
I need these two things. Purchase of the 10 millimeter document. Okay. Inventory.
You have to pull yourself up and talk into the microphone.
Just a little bit. Inventory. Come on. Yeah. And the purchase of the 10 millimeter.
Mr. Mizrahi, when you're ready.
Thank you. May it please the court. Counsel.
Yes, thank you.
Good morning.
Good morning, sir.
Please state your name for the record.
John Robert Biggerstaff.
And are you a convicted felon?
Yes, I am.
When did you become a convicted felon?
When I pled to felony misprision in 2017.
2017. At the time, before you became a convicted felon, did you have to get rid of your guns?
All of my weapons, yes, sir.
Okay, and that's why we're here. You know, that's why we're here to talk about that.
I understand that, yes, sir.
Did you purchase a 10 millimeter firearm?
Yes, I did.
When did you purchase a 10 millimeter firearm?
I don't know the exact year, but it was prior to 2016.
Why did you purchase a 10 millimeter firearm?
I was a member of a hunting club for a few years up in South Georgia, and where I was making my hunting stand, there were bears. Did some research and talked to a friend of mine who suggested two different kinds of weapons, a Casco 454, I think it was, and a 10 millimeter Glock. Having served with JSO and my military experience, I preferred the Glock weapons over anything else that I was unfamiliar with.
Where's your gun now?
I have no idea, sir.
No idea where your 10 millimeter firearm is?
No, sir.
Do you regularly take gabapentin? I'm not going to get into your medical history, but you mentioned that in deposition.
Yeah, I'm sorry. What did you say?
Gabapentin, do you normally take that?
Yes, sir.
Are you on that right now?
Yes, sir.
Okay. And what is that?
Gabapentin is for nerve pain.
And are you still able to perform your daily functions having taken that prescription drug?
I don't know what you mean by daily functions, no, sir.
What'd you say?
I don't know what you mean by daily functions.
You're able to come here and testify.
I'm able to come here and testify, correct.
There you go. Were you in the Navy?
Yes, I was in the Navy.
Tell the jury about your career.
I was in the Navy on active duty from July 86 until October 1st, 2007. I served on active duty as a cryptologic technician collection specialist.
What does that mean? What you can share with us?
Cryptologic technician collection specialist changes with technology and threats as perceived by the U.S. government, National Security Agency. I maintain a top secret sensitive compartment and information facility type of access for my 21 years plus. when I first came in, I was it's known now as an HF Manual Morse intercept operator. Over the years, I learned some different languages and performed different duties.
Well, thank you for your service. Did you also become a police officer?
I did, yes, sir. I became a JSO reserve officer.
Tell the jury about that.
I ran into somebody who mentioned to me he was a reserve officer with Jacksonville Sheriff's Office. Thought I'd be a good candidate. Mentioned to me about the academy and so on and so forth. They're in a safety fair, I believe, at Regency Fair, or Regency Mall at the time.
You have to undergo training.
Yes. Following my knee surgery, I had a physical fitness test the following week and started the academy right away. Yeah.
And what years were you a member as a reserve officer with the Jacksonville Sheriff's Office?
It was about 3 years long, but I don't remember the exact years. Oh, well, yeah, and it ended in 2016 when I was arrested.
And I guess that was my next question. Obviously, you can't be a police officer if you're a convicted felon. Did you have it down, something happened in your life that you've talked about your Navy service and your police service, and did you have some things in your life that led you down a path that you're not proud of?
Sure, absolutely.
All right, just briefly, we don't have to get into all the details, but briefly tell the jury about it.
As a result of severe...
Yes.
All right. So he was convicted of trafficking women. That's as safely as I can say. He was using a facility of interstate commerce to promote, manage, establish, carry on a business. If convicted, he faced maximum penalty of 5 years. So he established, promoted, managed, established, carried on a business enterprise that involved trafficking women. The indictment, it was because he used a phone or something. Hold on. The indictment alleges that Biggerstaff used a facility of interstate commerce, a cell phone, to commit the offenses. So between July 30th of 2016 and July 31st of 2016, I'm sorry, June 30th to July 31st. So basically the month of July, he was using a cell phone to promote, manage, establish, and carry on a business enterprise that involved female trafficking. So don't know if it was his wife, don't know. That I don't know. All I know is it was... And don't forget that he was a swinger. We've heard that testimony that John was a swinger and Mario may have been involved in that. Who knows? So anyway.
You may proceed.
Please, the court. So I just, as opposed to that open-ended question, I'm going to ask you two directed questions. Did you end up with financial problems in your life?
Your Honor, if I may.
Okay.
Needs a break?
Well,
Let me have the jury step in the back, okay?
Idea what happened there. I don't know if he doesn't want to answer that question, or if he has something medically going on. I have no idea what's going on. We won't know until we get...
Okay. Everyone can be seated. Here, Mr. Holman. Okay. All right. So I'm assuming that the state told him to look at me if he had concerns.
I did not tell him.
You did not tell him that.
He's educated enough to probably know that.
All right, Mr. Biggerstaff, I cannot have any type of private conversation with you, but I can do this. So what are your concerns?
yes, ma'am. My concern is, as a cryptologist, I've been trained to look at everything and listen to everything. So I don't know if I wasn't supposed to hear that conversation over there, but the court reporter has the screen open right in front of me that I can read. I didn't read much, but I just saw that the words going across match what I could overhear over there. And I just wanted to let you know in case there's something that comes out of that later. I'm sure that either needs to be screened, needs to be closed if you have some kind of a side conversation I'm not supposed to hear, or I need to turn away or something.
All right. So your concern was that you overheard part of what the sidebar was about.
Via the screen, yes, ma'am.
Did you hear it or you read it?
I read it.
Okay. Is any of that causing you a concern?
No, ma'am.
Did the objection cause you any concern?
I didn't hear the objection.
You didn't?
No.
Did you read it?
No, ma'am.
Okay. So I will tell you, since the state didn't, if you do have some concern about, did you tell him some area that he shouldn't get into or not? I'm not sure. With the other witness, there was that issue. I'm asking.
I don't think that there's an issue with this witness.
Okay, Mr. Dreiser, do you?
Not that I can think of off the top of my head.
All right. So did you have any concern about your background, sharing that with the jury? I just want to make sure that we can, when I bring him back out, we can go
Military
forward.
background? No, ma'am.
All right.
No.
Okay. I think we're good to go. I don't, unless the lawyers think that there's something wrong, I'm not going to have Ms. Simpkins put her screen down.
No, Your Honor, we're aware of the issue now, and if the lawyers will bring it to your attention if it needs to be put down for the witness.
Okay.
Agreed.
Well, I can do this. Ms. Simpkins, can you angle it a little differently? I'll go off. No, right now. Just angle it down a little bit. Is that good?
Yes, ma'am.
Okay.
I didn't intentionally read the whole thing, but.
For the record, the screen is angled down. Let's bring the jury back.
Well, this trial has a little bit of everything now, doesn't it? we have a witness seeing the court reporter's screen. Interesting.
You need it up like that.
All right. Telling you, this trial has a little bit of everything.
Okay. Okay.
You're in the courtroom, Your Honor.
Thank you. All right, welcome back, members of the jury. Everyone may be seated. Members of the jury, pardon the interruption. Mr. Mizrahi?
Please, the court. So, Mr. Bickerstaff, we left off with my question about the change in your life. You were you were a police officer, you were Navy, and did you end up with financial problems?
I had financial problems long before that, yeah.
Did you also end up with a drug addiction problem?
As a result of PTSD, drug addiction, depression, anxiety, yes.
I'm just trying to explain to the jury the shift in your life. Would you agree there was a shift in your life?
Yes.
Do you know Mario Fernandez?
I do, yes.
And how do you know him?
I've known him for about 18, 19 years. My daughter got a ride home from him one day from school, introduced us, and we became workout buddies for a while.
And do you see him here in court?
Yes, I do.
Did you say where he's seated? He's wearing so you can identify him?
Seated to my right.
What color suit is he wearing?
I'm colorblind, but it appears navy blue.
You nailed it, Your Honor. This time, the state would ask for the record to reflect the witnesses identified the defendant.
I think they're all in blue.
You said navy blue, although I think Mr. Dreiser is navy blue.
All right. Yes.
So you explained you were workout buddies. Just kind of dive into that a little bit for us, please.
Yes. In the mornings, Mario would come over and type his Pitbull 0 to my truck, and we would work out. I had purchased a home knowledge gym from Sears many years ago and had it in my garage. It was enclosed. My son was playing football in high school and then on to college, and so we would work out in the mornings. Mario, when he was at home in Jacksonville, would come over and work out some mornings. We'd text each other in the morning, make sure I was up and going to work out. I think I was retired at that time, so I was working for Hewlett-Packard, and I was on a 100% travel schedule. So in between my traveling, we'd get together and work out at my house, and then he joined the Army at some point, and I didn't see him for years.
Okay. When he got back from the Army, did your relationship begin again, so to speak?
Yes.
And did you share experiences in the military with each other?
Yes, occasionally.
Back in 2020, let's turn back to 2018. Were you aware of who Shanna Gardner was before you found out that she got married to Mario Fernandez?
No.
Explain to the jury how you found out that they got married.
One day when Mario was at my home, he brought up a picture of him and Shanna, and I believe it was in Hawaii on a honeymoon or something like that, and said he'd been married for, I think he said 2 years, I think at that point. It was at least a year, and that kind of surprised us. So.
And why did it surprise you?
Well, I hadn't seen or heard from Mario in a while, and then to find out that he was married, somebody would consider a family friend, it was kind of shocking to find out that he had been married.
Again, with your relationship, was there an occasion on February 15th of 2022 that this defendant, Mario Fernandez, had sex with your wife? I think her name's Maria.
My wife's name is Maria.
Do you recall that situation?
I don't recall the date. I do recall the situation, yes, sir.
And that was based on your request?
That's correct.
Did you have to convince Mr. Fernandez to do that?
I did.
So he wasn't initially willing until you kind of pestered him for a while? Is that
correct?
Fair? Okay. And you would agree that that was recorded?
Either pictures or video, yes, sir.
And so whatever the pictures or video show about the date, you would agree that that's right?
Correct.
Okay, so if it does show February 15th, 2022, you would agree with it?
Yes, sir.
Did you do work for Mario Fernandez, the defendant?
I did.
What was the most Mario Fernandez ever paid you at a time?
I have no idea, but it was at the most hundreds of dollars to a couple hundred.
Did he ever pay you by check?
No.
What kind of work did you do?
I had a handyman business, and he would, I guess, subcontract me would be the correct word.
Was your handyman business registered with the state of Florida?
It was.
What was the name of it?
904 Handyman LLC.
And so the $200-300 you got was paid to you in cash. I think you said that.
You're correct.
Did you do work on the Potomac address?
I did.
The Henry Tenen, do you know who that person is?
I do, yes, sir.
And how did you meet him?
Henry was a tenant under Mario's rental property there. I had been working for a while to raise the shower head in the shower. Been there for a couple of days back and forth before I met Henry as I was departing the home the first time.
Is the reason you're raising the shower head because Mr. Tenen is...
He's very tall.
6'6", whatever he is?
Very tall, yes, sir.
Okay. And that's why you were doing that?
That's correct.
Did Henry Tenen ever work for you?
No.
He ever work with you?
No.
I want to talk a little bit about the defendant's issues that he had with Shanna Gardner's ex-husband. Did the defendant share issues with you that he had with Jared Bridegan?
Just two that I remember.
Tell the jury about it.
Mario had mentioned that there was some tension between him and his wife, Shanna, when he would have headaches, and I'd invite him over because we had determined earlier that a cigarette would clear his headaches, and I had cigarettes. He'd stop and get a beer for two of us sometimes and bring them over. We'd drink a beer while he'd smoke a cigarette, and just say that her ex had caused a lot of problem or stress between Mario and Shanna because she was in court over the children, and as soon as court would be over, it seemed like she would be called right back into court, if I remember that correctly. And the second was kind of related to that was, I think it was the boy in the family had like issues with elevation, flying to New York to see a specialist that he was required to see. I think that was it. As far as I know, that was the tension between him and Shannon, but those are the only two issues he ever spoke to me about.
Okay. And they were both related to child custody issues?
Correct.
Do you remember on January 25th of 2022 that the defendant came to your house?
No.
Would you have known what the defendant did after he left your house?
I have no idea.
And you have no memory of what y'all would have talked about?
No, none.
Did you become aware of the fact that Jared Bridegan was murdered?
Yes.
Tell the jury about that.
I heard it first on, I think it was Channel 4 News one morning or afternoon, and just in summary. Of course, I didn't know his name at the time or anything. And then sometime after that, it was a couple days or week, Mario was helping me, I believe, moving things to and from my trailer that I was working on. Big, great trailer I had, probably 10 miles from the home. And he had a pickup truck, and he would help me move things back and forth.
Who had a pickup truck?
Mario had a pickup truck. When I got in the truck one time, he had mentioned that Mr. Bridegan had been murdered or shot. And I think the words they used was, the kid's dad is dead or something to that effect. And I said, oh my God, is that the story that's on the news and everything? And he said, yeah. And that was pretty much, in a nutshell, that was it. That was about the end of the conversation.
So you didn't know anything about the name Jared Bridegan. He just referred to it as Shanna's ex. Is that fair?
Correct.
And so then you were able to put two and two together because you had seen the media stories of the case.
Yes, sir.
Okay. When did you become aware of the fact that Jared Bridegan was murdered with a 12-millimeter Glock firearm?
Never.
Even today?
You said 12 millimeter. There's no such thing as far as I know.
I misspoke. See, you're careful. Good. Misspoke. 10 millimeter.
10 millimeter, not until a couple of months ago. It was mentioned by Miss Stifler, I believe. Either her or her investigator Bennett mentioned the 10 millimeter.
But as you indicated that you purchased a Glock 10 millimeter firearm, correct?
Correct. One of many.
I'm showing you what's been entered into evidence as State's Exhibit 191. Mr. Biggerstaff, if you could review those last two pages of State's Exhibit 191 and indicate if that's you purchasing that 10 millimeter Glock firearm.
Without verifying the serial number or the concealed weapon permit, that seems like the purchaser of the dealer information I bought it from.
And it has your name and address.
It does have my old name and address, correct?
So it appears to be your purchase of that 10 millimeter Glock.
Correct.
you would only be able to verify if you had the serial number.
And my weapon, yeah, I'm not going to say weapons number. Yeah,
You're
serial
speaking
number.
in the
Yeah.
microphone.
Speak into the mic.
Yes, I'm sorry. The serial number would verify that it would be the correct.
I'm going to leave State's Exhibit 191 up here. I'm going to show you what's been entered into evidence as State's Exhibit 190. And I understand that it's not the best copy. What is State's 190?
It appears to be the handwritten inventory of 20 weapons that I surrendered in 2016.
So you recognize that.
Roughly, yeah.
And who filled that out?
Myself and my son. It's his handwriting, I believe.
And if you could go to the serial number column 3 of the Glock 10 millimeter, we're down to line 7. It's going to be the Glock 40 10 millimeter. Can you read off that serial number?
It would be B as in Bravo, B as in Bravo, G as in Golf, L as in Lima, 770.
And can you read off the serial number of the purchased firearm in State's Exhibit 191, which is up at the top?
It is B as in Bravo, B as in Bravo, G as in Golf, L as in Lima, 770.
So you would agree that this is the firearm that you purchased and the firearm affidavit that you turned over to your federal probation officer?
Correct.
So what you turned over to the federal probation officer was before you were convicted, correct?
That's correct.
So you were hoping that you would get those firearms back at some point
That's what they told me, yes, sir.
until you became convicted and you knew that would never happen.
That question, I'm sorry.
That's a question.
Yeah, that's obvious.
Okay. And as you sit here today, you cannot produce that firearm.
That's correct.
Your 10 millimeter Glock 40 firearm was functional?
Was functional?
Was it?
As far as I know, it was.
It was operational?
As far as I know.
You shot it?
I did shoot it after purchasing, yes, sir.
You had ammunition for it?
I, at one time, purchased ammunition for it, yes.
In fact, you had ammunition for all of your firearms, correct?
No.
Is there a purpose?
There's a purpose in this question, yes.
No, I mean, for the leading nature.
No, I can ask it.
All right, I'll sustain it then.
Just speed. Tell the jury what ammunition you possessed.
I have no idea what the hell I possessed back then. None.
Okay. Did you possess ammunition?
I had previously possessed ammunition. I used to have a locker which ATF searched. I used to have ammunition and guns in there, yes, sir.
Is a firearm able to be fired without ammunition?
It can be dry fired without ammunition. You can't injure anybody, as far as I know, without ammunition and no weapon, if that's what you're asking.
What happened to all your ammunition?
Ammunition and all the weapons were stockpiled in 2016, and I have no idea where that crap went. None of it. Excuse my.
No, it's you don't think these things are crap, do you?
Do I think they're crap?
Yes.
No, I was irritated about the whole situation by having to surrender my weapons, sir.
You would agree that the ammunition is not contained in the inventory?
No.
So you would agree there's no documentation that we have to show that you surrendered your ammunition?
As far as I've been told, there's no documentation to show that I surrendered anything. So that would be yes, correct.
So the crap you referenced was about the charge in your conviction, not the guns or the ammunition.
Word crap came from the charge, yes, sir. It's not.
Because you like guns.
Used to.
And you didn't want to get rid of them. Is that fair?
I did not want to get rid of them under the situation. That's correct.
And there was a point in 2022. I just want to make it clear for the jury. When was that inventory? When did you surrender all your guns?
2016.
And was there a point in January of 2022, specifically January 25th of 2022, that you missed your guns?
No.
Never.
No.
You, Stifler, can you find that search for me? You would agree that guns have value?
Yes.
Specifically, 20 firearms would have approximately how much value?
I have no idea.
Well, I mean, have some general idea.
No, I don't have a general idea. It's not my
Is it
business.
worth $5?
Sorry?
Would 20 guns be worth $5?
I have no idea.
Would it be worth $100?
I don't know. If you're asking for guns from a convicted felon, I have no idea what they cost.
No, I'm asking you, based on your knowledge and experience and lifetime of purchasing firearms, how much they cost.
I don't know.
How much did the Glock 10 millimeter cost?
I don't know that either. It should be on the receipt.
Can you give this jury any approximation of how much these things cost?
No.
You would agree that you are not a rich man.
Correct.
Could you have sold these firearms?
At what time are you asking? I'm not sure what time you're
At any time.
I could have sold them up to 2016, yes.
And let me be clear, in other words, before you were convicted of the crime, could you have sold them?
Before I had to surrender them, I could have sold them, yes.
Okay. Even after you surrender them, do you believe you could have sold them?
No.
And why not?
Well, I know better than that. I haven't been in JSO, sir, and worked on some of the things I worked on. I know how some of the systems and checks are done.
You would agree, Mr. Biggerstaff, that your son, Juan, I'll ask another question. Just try to get it. Who is Juan Bickerstaff?
It's my son.
And at the time, was he in law enforcement?
Yes.
You would agree that he helped you. I'll ask the question in a different way.
I'm sorry, you said at the time. What time are you referring to?
At the time that you surrendered your firearms.
2016? I don't know that he was. I don't think he was.
Was Juan Bickerstaff a prohibited person? In other words, could he have sold your firearms had you given them to him?
Yes.
And it was Juan Bickerstaff, the person that helped you compile your inventory list.
That's correct. I think he was law enforcement because of a situation where I transferred one to him in that whole stockpile.
You think you transferred him one of the 20 guns?
Yep. Yes.
And which one was that?
It was my backup JSO pistol. It was a Glock 40 millimeter.
Glock 27, 40 millimeter? It was 27 model?
I don't know the model number. I'm sure you do.
Yeah. Do you know anyone else that owns a 10 millimeter?
No.
I'm showing you what's been entered into evidence. The State's Exhibit 197. There's not a lot of room to put it there, so I'm going to have to, I guess, take it out.
Mr. Biggerstaff, don't get too far away from the microphone.
I handed him the paper, so he can stay there.
Pardon me.
Have you reviewed that?
Yes.
And we talked about this in your deposition. Do you remember that you did search on January 26th of 2022, 10 millimeter firearms?
No, like I told you then, I searched all kinds of things all the time. I believe I clicked on bookmarks from the look of this.
Okay. But you would agree with the record speaks for itself?
Yes.
Okay. And then showing you, did you also, and I think we talked about this in your deposition, search furniture with hidden compartments?
Yes.
You remember that?
Sure. Yes.
Okay. Now, do you remember making the statement that you missed your guns?
Yes.
Okay. So you do remember making that statement?
Of course.
Okay. And I understand you might have been speculating, but that may have been one of the reasons why you were searching for Glock 10 millimeter back in January. And I was right when I said the 25th. Those were in UTC, so it was the 25th. I'm sorry, let me go back to my question.
Please.
Your missing of the guns may have been the reason why you were searching for them on January 25th of 2022.
No, I think after looking at the furniture thing, I was looking for a way to conceal my substance abuse at home.
Okay. But you would agree that the record speaks for itself about whether you were looking at firearms as well?
Mr. Mizrahi?
I don't think that's a leading question. You agree with that?
I'm sure I clicked on, from the look of it, I'm sure I clicked on bookmarks.
Okay. Going back to your son, do you remember Juan Biggerstaff coming to your house? Strike that. Well, we'll do this now. Coming to your house on December 21st of 2022.
I don't remember the date, but I remember my son coming to my house, yes.
It was shortly before Christmas and the holidays of 2022. Do you remember that?
I was thinking it was Thanksgiving, but yes, I remember. Okay.
And do you remember talking about the case with him?
Not the case, no.
Do you now know that Juan Bickerstaff came to your house while you were wearing while he was wearing a recording device?
I knew that. Yes, I knew that.
You know that now, or you knew that then?
Well, again, based on my prior military experience and JSO experience, and not being an idiot, it was pretty obvious.
So back in December, and I understand you don't know the specific date, but back in December of 2022, you suspected that your son was wearing a recording device? Yes.
Correct.
No?
Sure.
Okay.
Yes.
Did he tell you he did?
No, sir.
And although you may have not been talking about the case, you did talk about the investigation where police officers came to your house and were asking questions about the 10 millimeter.
About weapons, and he asked in general weapons. I don't know that he asked about the 10 millimeter. He asked about where my guns were, who had them.
And what did you tell him?
A couple different things. In the beginning, I told him that I had no idea. He knew that I didn't have any idea. He kept pushing for saying they want to know where your guns are. They want to know who has them. So then I told him that somebody would get them to me by the 1st of January. And then I would make a call to ATF and tell them who had, or as soon as I knew who had them or where they were at, I would call ATF, something to that effect.
Okay, you've had the opportunity to listen to that recording.
That's correct.
And do you remember if he talked about starting to prepare for perhaps your arrest and helping his mother deal with that? Do you remember that's how the conversation began?
No.
Do you also remember that you told him that the only thing they cared about was the 10 millimeter?
I told him that?
Yes.
I don't remember saying that, no, sir.
And do you remember saying that it had been in your possession the entire time?
I don't recall saying that. Actually, I think that was one of the first things I said after I saw that he was pressuring me for more information.
Okay, so now you remember saying that the 10 millimeter has been in your possession the entire time.
I may have said that, yes, sir.
Was that the truth or a lie?
That would have been a lie.
To your law enforcement son?
That's correct.
Do you remember discussing that you felt law enforcement was concerned because of your relationship with Mario Fernandez. Do you remember that discussion?
No.
So the first thing you said is you've had it the whole time, but then do you explain to the jury what you remember about the second conversation where you said it was going to appear at the turn of the year?
I never said that in the beginning. In the beginning, I told him I didn't know where they were.
Okay. And then you said you had it the whole time. And then you said it was...
Somewhere during the conversation, I told him that I'd had them. Then I told him that somebody else had them, and that they could produce them by January 1st.
Okay, so those are the three things. First, you said you didn't know. I'm leading just to try to make it quick. Second, you said that you've had it the whole time. And then third, you said it's going to appear on January 1st.
Correct.
Did you tell your son that you were going to call law enforcement when it would reappear?
Yes.
And this conversation would have been before January 25th of 2022.
Before, no, 2022.
This would have been, after 2022. Sorry, I said it wrong.
Holy crap. Yes.
Do you remember telling your son that you told law enforcement that Steve from the Georgia Hunting Club had the gun?
I'm sorry, say that again.
Do you remember telling your son that Steve from the Hunting Club had the gun?
No.
Do you remember apologizing to your son that you had put him in this position?
Yes.
Do you remember telling your son that you wouldn't tell him why he had to wait until January 1st to find out where that gun was?
I remember saying something when he asked me why January 1st or something along those lines. I responded. I don't know how I responded. I don't know the words I used.
Was that a fair?
No, it's not fair. I don't remember.
Would you want to listen to that wire to refresh your memory?
You can try. The wire was pretty crappy. I helped you guys pick out some of the words before. But we can, if you want to.
Okay, well, we may do that at the appropriate time. Okay?
Okay.
Were you telling the truth to your son in this conversation?
Initially, yes.
And then what changed?
I wasn't telling the truth. That's what changed.
Do you remember when Detective Lamont came to your house?
No, Detective Lamont, I don't know. I'm terrible with names.
You remember when Jacksonville Beach scheduled a meeting with you and you said, what?
If you're talking about when I was working at the school, like 4 years ago, yes. Yes, I remember.
You remember scheduling it for the next day?
No, I remember being contacted. I remember they came to the house in the morning as I was leaving to go to work, and they asked me if they could come back in the afternoon, and I said yes. And then I think that afternoon they contacted me, asked me to go down to the station, which I did at nighttime in the evening. I think it was the same day. I don't think it was the next day.
Regardless, in the meantime, you met with Mario Fernandez.
No. That day? No.
In between when you were asked to meet with Jack's Beach and the time you met with him?
No.
Okay. Do you remember deleting things off of your phone in between those two events?
No, sir.
So if the records show that, they would be wrong.
I don't remember them. I delete stuff all the time, sir.
Okay. Did you ever receive a courtesy call from the defendant about Henry Tennant's arrest?
No.
No.
Not that I remember, no, sir.
Do you recall making a statement to law enforcement that Mario Fernandez contacted you and gave you a courtesy call to tell him he might get questioned?
Told me he had been questioned, that the new tenant at the home I was working on at Potomac might be questioned, and then I might be questioned as well.
Okay, so you do remember that?
I remember, yes, sir.
Okay. Who is Fred Barton?
Fred Barton was an acquaintance for at least a couple of years, retired sergeant from Jacksonville Beach Police Department.
And your relationship back in 2016, did you have a fine relationship with him?
I don't remember 2016. I don't know how it was. I don't remember.
You remember your gun cabinet going over to Fred Barton's house?
No.
It never did?
I don't recall it going to Fred's house. I can't say it never did, but I don't recall it.
What happened to your gun cabinet?
I don't know. That's where the ammunition was stored and the weapons, everything, family heirlooms, crossbow, compound bow, all that stuff was there.
And that cabinet is on the porch of your house right now?
No, it's down in a landfill somewhere. After ATF inspected it, I chunked it out in trash because it was a piece of junk.
Okay, so ATF did go to your house and see your junky gun cabinet.
That one, as well as another one I told them I had, wasn't a gun cabinet. It was just like a document safe in my closet. I showed them that one as well.
Okay, but what you put into a landfill was the cabinet that stored all your firearms and your ammunition.
Previously, yes.
And you never know where that went? How it got back to your house?
I don't think it ever left the house, or it had gardening tools in it.
So the inventory that you gave your probation officer listed 20 firearms. You agree with that?
No, I don't. It's 20 different weapons. They're not all firearms, I don't believe.
Fair enough. What did you do with them?
What did I do with them? Yeah, I inventoried them. We stockpiled them in the living room. I think I gave them the middle finger because I was so upset about having to surrender my weapons, and I left the room and went to bed.
Okay. Where did they go?
I don't know where they went, sir.
Do you think the probation officer took them?
Probation officer or JSO, whoever picked them up.
So is it your testimony that you think the JSO or the probation officer stole your firearms?
I don't think they stole them. I believe that was part of the process, either that or U.S. Marshals. Since I was on probation and had to interact with U.S. Marshals several times.
And your son Wong was there, was he?
Previously stated, yes, sir. He was there. He helped me with the inventory.
Do you think he took them?
Do I think my son took my firearms? No, I don't think he took those. Only the one that I told you about.
Glock.
The Glock 40 millimeter, yes, sir.
So the 19, you don't believe your son took?
If that's the 10 millimeter that you're asking me about?
Asking about all 19 other things documented on that list.
Oh, the other 19 things. No, sir. My son didn't take those. I'm sure of that.
But you don't know where they are or where they went?
I have no idea where they went. I have no idea where they are. No, sir.
And did you ever go to Fred Barton's house to drop off your gun cabinet and then pick it up a week later?
No, sir.
Are you aware of your son and his law enforcement duties in Texas had a burglary into his vehicle?
I'm sorry, say that again.
Are you aware that your son, while he was a law enforcement officer, had a burglary into his vehicle?
Into his undercover vehicle, that's correct.
You were aware of that?
I have been made aware of that, yes, sir.
And you're aware that he listed several firearms that were stolen?
No, I'm from Miss Stifler. I believe there was only one that I was told about.
Okay. Are you aware that he took more than one firearm of yours that he says you gave him?
No, I'm not aware of that.
Mr. Biggerstaff, Would you get in trouble if you possessed a firearm or ammunition at this point in your life?
Yeah, that's correct. It's against the law.
Your Honor, that's all the questions I have at this particular time.
All right, let me check in with the jurors. Is everyone okay? Okay, you may proceed. Cross.
Good morning, Mr. Biggerstaff.
Good morning, Mr. Reiser.
You doing okay?
I'm hanging in there, sir.
All right. You and Mr. Fernandez have had a relationship since he was in high school, correct?
Correct.
And when you were healthy, you worked out together. You said that, right?
That's correct.
And when he would go away on deployment, you weren't sending him care packages or anything like that. You weren't that close, correct?
No, sir.
And then if he came back, you guys would talk, work out, chat from time to time, correct?
Correct.
Okay. During those chats, did Mr. Fernandez ever talk nasty about his wife's ex-husband?
No.
Did he ever tell you he wanted to kill him?
No, sir.
Did he ever tell you he wanted to hurt him?
No, sir.
Did he ever seem really frustrated, like he was going to do something to him, or he was unhinged about his wife's ex-husband?
No.
Never got that impression, right?
No, the only frustration he ever shared was the tension between the two of them and over children, his new fatherhood.
And I want to ask you a question that the government didn't ask you. And if you don't understand my question, you tell me, because I'm going to try to make it as simple as possible.
Okay.
Did you ever give Mr. Fernandez a 10-millimeter firearm?
No, sir.
Did you ever give Mr. Fernandez any firearms?
Never. No, sir.
Did you participate in the planning of the murder of Jared Bridegan?
No, sir.
Did you help Mr. Fernandez in any way?
No, sir.
Did Mr. Fernandez ever tell you he participated in the murder of Jared Bridegan?
No, sir.
Did Mr. Fernandez ever admit to you that he had anything to do with the death of Jared Bridegan?
No, sir.
You told this jury that you don't remember what happened to your firearms. Is that my understanding?
That's correct.
And you don't remember going to Fred Barton's house. Is that correct?
That's correct.
And you don't remember what firearms Juan took. In fact, what your memory is that he took one firearm.
That's correct. Yes, sir.
Didn't you hear the government ask you a lot about history?
Correct.
You know, I don't recall them asking you about an injury that happened to you in 2022.
Yeah, I'm going to object to the form of the question.
I'll sustain it.
Were you asked any questions on direct about an injury that you sustained in 2022?
No.
Okay, why don't you tell the jury what happened to you in 2022?
I had a slip and fall injury on July 21st, coming out of a Circle K gas station. I'm sorry. I came out of a gas station with my hands full of products on my way to my son's, and his wife had, we just came back from Key West for the weekend, celebrating my wife's 50th birthday and my son's proposal to his wife. And they were going to show us both sides of the family, the venue that they were going to do their wedding in and see if it was available. And then we were all going for pizza. I went to a Circle K gas station because I'm a horrible cigarette smoker. I had to have my cigarettes and some caffeine. While I was inside, there was a 4-foot or so laminated poster that came out of the bottom of a frame that they use on the outside of the store to announce the breakfast sandwiches and such. It slid out of the bottom of the frame. I slipped on it. I slammed backwards, injuring my head and my spine.
Did that result in you being diagnosed with a traumatic brain injury?
Yes, sir.
And was that by Dr. Emis, a neurosurgeon here in town?
Correct.
Since the time that you have been diagnosed with a traumatic brain injury, is your memory as good as it used to be?
No, sir.
Would you agree that you don't have as good a memory as to things that happened before that?
Absolutely. I'm on medication for short-term memory loss even.
Currently, right now?
Correct, yes, sir.
Okay. And could that affect your ability to remember details from 2016 and 2017?
Absolutely, yes, sir.
When Mr. Fernandez would pay you for work that you did, you said it was $200 or $300. That's not total, correct?
I don't recall any amounts, to be honest. I was asked to throw a figure out there.
And you would get paid per job, correct?
Correct.
So you don't know. Mr. Fernandez may have paid you thousands of dollars over the years, right?
It could have been. It should have been documented in the invoice program that I used for my company.
And fair enough, you did fall into some substance abuse issues, correct?
Correct.
So you wanted to be paid in cash, right?
Correct.
Because that's how you would buy drugs on the street, right?
That's correct, yes, sir.
Okay. You're clean and sober now?
I am a little over 3 weeks, yes, sir.
Congratulations.
Thank you.
But during the time that Mizrahi asked you about conversations that you had with Juan Biggerstaff, were you using drugs at that time?
Yes.
Okay. You acknowledge that you bought a 10-millimeter firearm, correct?
Correct.
It was a bear hunting gun, you said.
A bear defense gun, yes, sir.
Did you give that gun to Mr. Fernandez?
No, sir.
Did you give that gun to anybody that you believe the intention was that it end up in Mr. Fernandez's hands?
No.
Did you give that gun to Henry Tenon?
No.
Have you ever seen that gun since law enforcement took it from you back in 2016-17?
No, sir, I have not.
All right. So let's look for evidence that maybe you still deal in firearms. You became a convicted felon in 2017, is that right?
Correct.
And today it's 2026, August. How many times have you been arrested for being in possession of a firearm?
0.
Objection, Your Honor.
Let me see it, sidebar.
Well, we're learning all kinds of things about Mr. Biggerstaff here. So he's had a slip and fall. He hit his head. He's got traumatic brain injury, short-term memory loss. He's only 3 weeks clean. Hey, it's better than 1 day, I guess. Better than 0. I have no idea what his substance is that he I have no idea. But we found out that there was that hint that Mario had relationships with Mr. Biggerstaff's wife, and that was confirmed by Mr. Biggerstaff. He doesn't know what happened to this firearm. He's digging his heels in. He's like, I don't know where it is. He knew that his son, Juan, was wearing a wire. And of course, he's going to say he didn't participate in Jared's end. Can you imagine if he was up on the stand? He's like, yeah, I knew about it. He got emotional there when he was talking about this slip and fall. It was his wife's 50th birthday. They were celebrating his son's engagement. Talks about a 4-foot poster coming out of the frame. That's kind of interesting. So his meds aren't as good. His memory isn't as good. He is on meds for short-term memory loss. He's also on gabapentin, he said, for the nerve pain. So yeah, basically his testimony is he doesn't know where this is. The cabinet is, he said he threw it out, even though the witness before him, Fred Barton, said that he brought it over. I don't know if you're going to weigh the who's telling the truth or not. If you're going to weigh the credibility of the witness, I would probably go with Fred Barton before I went with John Biggerstaff. So Fred said that he brought over this cabinet didn't open it up, didn't want to know what was inside of it, but was told that it was firearms. So, again, if we're assessing the credibility. So, okay, while they're at a sidebar, let's refresh the credibility of the like button. We're at 210 likes. If you can hear my voice and you're out there, you're not in chat, please take a moment to hit the like button. Thank you very much. Appreciate that, you guys. Let's see, we're at 210 likes. Let's see if we can get that 211 likes. Let's see how many likes we can get in the next few minutes while they're at a sidebar. So he was never arrested for possessing a firearm. That was objected to, and now they're at a sidebar. Oh, you know what I could do? I could come back here. Nope. I was hoping that they would show the court in that other frame. Let's see. Mike saying this is interesting. MMC 50s, how are you? I believe Fred, don't believe John at all. Again, if you're weighing the credibility. That sounds like they're coming back.
You may proceed.
During the course of this entire criminal investigation, law enforcement has made contact with you on a number of occasions. Is that correct?
That's correct.
They've come into your home?
That's correct.
They've searched your home?
Correct.
Did they ever find a firearm in this case?
No, sir.
Did they ever find a bullet or an ammunition in this case?
No, sir.
Have you ever been arrested as a result of this investigation for being in possession of ammunition?
No.
Have you been arrested as a result of this investigation into you still having a 10 millimeter? Have you been arrested for felon in possession of a firearm?
No, sir.
Okay. At some point in time in August of all of 2022, you were still doing handyman work for Mr. Fernandez? When you could, from time to time?
I believe so, yes, sir.
You were still fairly injured back then, is that?
Very, yes.
Your work was limited to what you could do?
Correct.
There was a time in August of 2022 where you did go to Potomac to try to do some tile work. Do you recall that?
I don't recall the time, but I recall trying to do some tile work in Potomac, yes.
Okay. And that's when Mr. Ordway was living there?
Is that the blonde-haired young man? And
white guy?
I don't know the names. Yeah, Caucasian male, yeah.
And you would meet Mr. Fernandez there to sort of go what work you should do and how to do it?
No, I think it was all via phone call and text at the time.
You were texting about tile work?
Correct.
And maybe you just don't remember, but if there was video of you and Mr. Fernandez at Potomac, you don't suggest that couldn't be true. You just don't remember.
Correct.
Okay.
I think that was more about the drywall when he was
other
present.
Renovation projects going
Correct.
on.
Yes, sir. Yeah.
So, Mr. Biggerstaff, also, well, let me back up. There was evidence that Mr. Fernandez, you were a swinger, you and your wife were swingers, correct?
Correct, we were.
Right. And Mr. Fernandez was not the only person that would sleep with your wife that you would videotape, correct?
Unfortunately, that's correct.
Did you give any of those other people a 10 millimeter firearm?
No, sir.
Did you give any of those people a gun?
No, sir.
Okay. Did you give Mr. Fernandez a 10 millimeter firearm in exchange for him sleeping with your wife?
No, sir.
Did you have to bribe him or pay him?
No.
Okay. It was just something that you wanted him to do. It was after he told you him and his wife separated, and he did it, correct?
That's correct.
Okay. Any deal that you were making so that you would give him a murder weapon and he would sleep with your wife?
Absolutely not. No, sir.
And this was something that you asked other men to do as part of the lifestyle you were living, correct?
That's correct.
Did he owe you a favor?
No, sir.
Did you owe him a favor?
No, sir.
Is there any other way I can ask you? Did you give Mr. Fernandez a firearm in exchange for the January 25th February 15th meeting where he came to your house?
No.
On January 25th, there's cell phone data that suggests that Mr. Fernandez came over. Is your testimony is you don't remember why he came there?
That's correct.
Did you give him a 10 millimeter?
No.
Did you give him any firearm?
No, sir.
So he's been to your house dozens and dozens of times, correct?
All three of my residences, yes, sir.
Could have been talking about, or could have been having a cigarette to clear his mind, right?
That's correct.
Could have been having a cigarette to clear your mind, correct?
Correct.
Could have been just chit-chatting like he had done dozens of times, right?
Yeah, he helped me a lot with VA information to get my VA stuff started.
And if a friend came over and stopped at your house sometime 6 years ago and there was no real purpose for it, any reason for you to remember that?
No.
And going back to the hidden furniture search, is my understanding is you were searching for hidden furniture so you could hide drugs from your wife.
Correct.
That's the only reason, right?
That's correct.
It wasn't to hide weapons from anybody, correct?
No.
And law enforcement has searched your house?
Yes, that's correct.
Has law enforcement threatened you in this case?
Yes.
How have they treated you?
At times, pretty ugly.
Have they cursed at you?
Yes, sir.
People in the state attorney's office, have they cursed at you?
Yes, sir.
Do you think they treated you fairly?
No, definitely not.
They told you that they wanted you to tell the truth and they would give you immunity, correct?
That's correct.
Did you ever accept?
No.
Did you ever bring a criminal defense lawyer with you?
No.
Did you ever plead the fifth and say, I don't want to talk, I'm just not going to answer your questions?
Never.
So you've gone and you've spoken to them when law enforcement came to your house, right?
Correct.
You've gone and spoke to them at their office per their request, right?
That's correct.
You sat down for an entire deposition where I asked you questions for hours, correct?
That's correct.
And you came here today to testify in this trial.
Yes, sir.
Have you ever told anyone that you gave Mr. Fernandez a 10 millimeter firearm?
No, sir, never.
They've told you they consider you a co-conspirator in this case.
That's correct.
But they just never arrested you?
That's true.
You know from being a police officer, it only takes probable cause to arrest you, right?
That's correct.
And nonetheless, with all the allegations and the threats and the cursing, they've never arrested you.
No, all the junk, nothing. No arrests.
Because you've never given Mr. Fernandez a 10 millimeter firearm, right?
That's correct.
There's no surveillance of you giving him a 10 millimeter firearm, correct?
Say again, I'm sorry.
There's no surveillance of that.
No.
When you were giving this conversation with your son, Juan, was this part of what you believed the harassment was, this wire?
Yes, absolutely.
And you suspected you were being recorded?
Yes.
And you told Juan that you didn't have any firearms?
That's correct.
And then he just kept pushing you and pushing you?
That's correct.
And that was at a time when you were still using drugs, correct?
That's correct.
Did you describe your mind as clear at that point in time?
No.
Okay. And your own son, you believe, is probably recording you and pestering you about a firearm that you never gave to Mr. Fernandez, right?
That's correct.
About a firearm that you hadn't seen since 2016, likely.
That's correct.
And you knew your son was law enforcement at that time, correct?
Yes, that's correct.
Did you want him to get in trouble?
Never.
Okay. When you said, I apologize for getting you wrapped up in this, did you mean the fact that he's there asking you questions and likely wearing a wire?
Yes, at the holiday time, absolutely.
Okay, so you certainly weren't apologizing for getting him wrapped up in some criminal activity you were a part of, right?
No.
Do you have anything to do with the murder of Jared Bridegan?
No, sir.
Objection asked and answered, Your Honor.
Well,
Wait, overruled. Go ahead.
did you have anything to do with the murder of Jared Bridegan?
No, sir.
In any capacity?
No.
So Mr. Mizrahi asked you, did you said something like the weapons will show up in January. Is something to that effect, is that right?
Correct.
Did they show up in January?
No.
Did law enforcement ever come back and say, give us the 10 millimeter?
No.
Have you been in possession of any firearms since the day that Magistrate Monty Richardson ordered you to surrender your firearms?
If that's the Middle District of Florida, then that's correct. Not one single firearm since then.
Right. And that was unfair to you because I've shown the jury that it was Magistrate Monty Richardson who signed the order making you surrender your firearms. So
Correct.
I represent that that's in evidence.
Okay.
That's the person or the judge. Have you been in possession of guns since then?
No, sir.
Ammunition?
No.
Weapons?
No, sir.
Mr. Fernandez helped bring tables and chairs to your son's wedding the day after the homicide?
I don't remember if that was him doing that or not. I have a big blank there on who helped me, but I'm assuming since you say that, the answer is yes.
Okay, so you don't dispute that he helped you?
I wouldn't dispute that, yes, sir.
And that was the kind of stuff you did for each other. He would help you do
Correct.
things. You would help him do things, right?
Correct.
And when Mr. Fernandez told you that day that Mr. Bridegan had been murdered, did Mr. Fernandez seem nervous?
I don't know if it was that day, but when he told me, he didn't seem nervous, no.
Did he make any admissions?
No, sir.
Did you think anything of it?
No.
Did you guys talk about what firearm was used?
No, we didn't. I don't think we ever talked about it again after that day.
After the Potomac tile work project, that was, I'm going to represent to you, somewhere around August of 2022, okay?
Okay.
Did you and Mr. Fernandez have a falling out over that project?
I think we ended on bad terms because of that project, yes.
And it was because Mr. Fernandez wanted you to work on a tighter schedule than your body was allowing you to do?
That's correct.
And you thought you made that clear, like, I'll do the project, but because of my physical condition, I need to do it on my own timeline.
Right.
And Mr. Fernandez got frustrated with you that it wasn't going as fast as he wanted it to.
Correct.
And then Mr. Fernandez took over the tile project?
I don't know what happened to it after that. I didn't go back, yeah.
Because you guys really haven't kept in touch, right?
That's correct.
So certainly, you don't owe anything to Mr. Fernandez right now, right?
No, sir.
He doesn't owe anything to you right now, right?
No, sir.
Part of your fall at Circle K, did you hire a personal injury lawyer?
After, did you say?
Yeah, after you fell.
Yes, I did, unfortunately, yes.
And was his name Randy Reap?
Correct.
Okay, so if you had searched for Randy Reap, also on the day you were looking at those thumbtack, whatever you described it on Google, that's because that was your lawyer at the time?
That's correct.
Mr. Mizrahi mentioned things like you don't have a lot of money. You would agree you would search for all sorts of things you couldn't afford, correct?
That's true, yes, sir.
Yachts, right?
Yes.
Villas in France.
Yes.
Flour tortilla recipes.
Correct.
How to make the best chocolate chip cookies.
Correct.
Military bases in Charleston.
Yes.
You also looked at a 9mm firearm at one point, right?
Correct.
Would it be fair to say you probably have looked at thousands of things on the internet?
Yes.
Because when you were injured, you weren't very mobile, were you?
I haven't been very mobile for 6 years. That's correct.
And a lot of what you do is on your phone.
That's true.
Any rhyme or reason as to sometimes what you're looking at or why you're looking at it?
No, what I'm watching on TV usually generates my searches.
And if you had looked for a 10 millimeter at one point in time, would you agree you wouldn't have had to do that if you still owned one?
That's a true statement. Yeah.
You could have gone to wherever it was and looked at it if you still owned one, right?
Right.
But you didn't do that because you didn't own one, right?
Correct.
And in those particular searches, you would acknowledge that that you never searched anything to do with firearms that had anything to do with Mr. Fernandez, correct?
That's correct.
May I have one moment, Your Honor?
Yes.
Should I get up and say, did you give? Yeah. We have no further questions. Thank you.
You're right.
Sure.
Mr. Biggerstaff, you mentioned that the state of Florida offered you immunity. Remember that line of questioning?
Yeah, I do, yes, sir.
And who was that, me?
You, correct. You and Mr. Stifler, yeah.
We're both assistant state attorneys, right?
That's as far as I know, yes, sir.
Well, your conviction, was that in state court or was that in federal court?
Federal court.
Did you, in the course of this investigation, ever sit down with a federal prosecutor?
Are you asking? Okay.
All right, so we're on redirect now. He never sat down with a federal prosecutor. That's what caused the objection and sidebar. Not sure why that would cause a sidebar, but I got cat hair up my nose. So the state offered him immunity, but okay, I guess he's asking, did the feds ever offer him immunity? Not sure why the feds would be offering him immunity. For a state level crime. Yep, they're love bites, I know. Yeah, I was petting her and then she's like, she didn't draw any blood, thankfully. Surely not. Yes, he is eavesdropping. He said he could read the lawyer or the court reporter's notes, but she's moved her computer. You can't hear with the white noise. It is so loud. The white noise is so loud. It'd be almost impossible to hear. Even him sitting as close as he is, it would be almost impossible to hear. Selective amnesia. Shirley says, yeah. Well, it's up to the jury to weigh the credibility. And well, let's see. I'm not sure whose side he's really with because the defense seems okay with him. The state, I guess the state's proving that he's not very reliable or not very credible. But he was offered immunity to testify. So, does he really help anybody? Has he moved any needles for you guys? I mean, whose side is he really helping here? I mean, he said on both sides, I haven't done anything. I haven't done anything wrong.
You may proceed.
So Did you ever meet with the federal prosecutor with regard to this case at all?
I don't know. There was at least one probable federal somebody in my home that didn't provide credentials. So I don't know who it was.
That was an ATF agent, perhaps?
I don't know. They were with an ATF agent, yes.
When the talk of immunity came up, it was just me and Ms. Stifler.
No.
Who else was there?
Jacks Beach homicide, police detectives, an agent from ATF, and some female. I don't know who she was.
It's your testimony that an agent from ATF was present when we discussed immunity with you?
Correct.
Okay. That's all the questions I have here.
Anything further? No, Your Honor. May the witness be excused. All right, Mr. Biggerstaff, you're excused.
Thank you, ma'am.
Thank you.
Thank you.
Take your time. The next witness, I'd like to take a break, or is the next witness short?
It's appropriate to do that.
Okay. Members of the jury, we're going to take 15 minutes, okay? And then we'll come back for the next witness. Can I see the lawyers at sidebar for scheduling?
All right, so they're going to take a little break now. Hey, Shax, how are you? Good to see you. Good vibes only. Good to see you. Thank you for the gift there. Shirley, to me, it shows the types of people Mario associated with. Renee, I'm curious as to why he received immunity. Well, he's never been arrested in this, in relationship to this, in connection to this. He's never violated any of his not, of having a firearm. I don't know if you can hear that. It's Paulie. Well, I guess he could be, if they did prove that he provided the firearm, then he would be, yeah. He could be held responsible for that. He would be held responsible for that if they could prove that. MMC says he helps the prosecution because we know he is lying. Treasure Hog, his credibility is suspect. Camilla says this channel is our little... Well, there. This channel is our little corner of peace. Let's keep it that way by avoiding language that glorifies darkness. I agree with that. Thank you, Camilla. Thank you for getting us to 237 likes, you guys. Appreciate that. If you are just coming in new to the stream, please take a moment to check that you have hit the like button. And we appreciate your support. So far today we heard from Kim Jensen. She did a proffer at the beginning of the stream. Then we heard from Fred Barton. He kept this cabinet for John Biggerstaff, and then right after that we heard from John Biggerstaff. And he's been on the stand for the majority of the day. About over an hour or so? Yeah, hour and a half or so. Hour and 20 minutes he's been on the stand. So, Diane, how are you? Welcome in. Thank you for joining us. Check says, I don't see why he has a reason to lie. It would hurt his immunity. Debbie, thank you for the 5 Trial TV Live gifted memberships. Appreciate that. See if you got anybody in chat. Doesn't look like it. Downey Lynn, how are you? So good to see you. Thank you for joining us. MMC says, I love how he says he hurt his back when he fell, and then he says he was carrying tables with Mario. I thought it was chairs. I think Mario helped him with chairs. Did he say tables as well? I know he was setting up for his son's wedding, and I thought it was chairs, but it could have been tables as well. I definitely... big blank on who helped him bring chairs to his son's wedding. I mean, it could have been tables. I don't remember the tables part. I definitely remember the chairs part. Kathy, he wasn't lying, but left out what he forgot. Hellrider, sounds like no solid evidence against him. But why was he offered immunity? Right? Those are good questions. Debbie again with the 10 Trial TV Live gifted memberships. Awesome. Thank you so much, Debbie. New members, come on down. Please join in the chat. If you just received a gifted membership, please come on. Please come on in. Excuse me, Juan could be. He's on the list. Excuse me, he's on the list for the defense, actually. He's actually on the list of the defense. Yeah, we got John and Juan are both on the list for the defense. I don't know if Juan will be next, or we could hear from an ATF agent, but these are all people on the defense. Looking at the defense list here. See if anybody else. I don't see anybody else. Nobody else has testified that's on the defense's list here. So the defense was going to call him. The defense was going to call him. Yes, let's all hydrate. Remember to hydrate. Paralegal Mandy, hello, how are you? MMC says, in Florida, if you are subpoenaed, you get offered immunity. Jenny G, yes, gifting like Robin Hood, you get the handle of Robin Hood. Absolutely. Kimber saying, your support is totally amazing. We appreciate you so much. To Debbie. Shirley says, I would always question the honesty of an addict. 3 weeks sobriety isn't long enough to undo old patterns of behavior, self-serving untruthfulness. All right, so let's just kind of review quickly here. We had a proffer of Kim Jensen. She is a longtime friend of Shanna and Jared, and she was on the stand before the trial actually started. She was on for actually quite a while. Looks like they might be coming back. Let's see if I can get anything happening over here. Nope. And basically, they were talking about children witnessing, or the fact, not witnessing, sorry, having a child's parent
deadline, that if you all want to object to that procedure, okay, because I don't want that situation that happened before I thought there were no objections filed and then somebody came in there objecting. So I'm going to set aside the deadline so that you all can object if you need to. But based on her case, I don't know how many media outlets would be interested, and it's limited space back there. So I'm also amending the order to say that I need you all to let me know that you want to participate in the individual voir dire, because I don't have enough room back there, and if I don't have enough room, then I need to find another place to do it, okay? So I'm just giving you all a heads up. So if you want to, when the order gets filed today, it's going to be filed today. If you want to transfer it to your counsel, you can, so that they know that there is a deadline for them to object. There's a notice requirement that y'all want to participate or not, okay? So I can make arrangements to have, the only thing that I'm excluding are the videotapes, the videoing of the jurors. So it would be the same procedure, just no cameras back there, so because they're disclosing sensitive information related to their finances and family and medical situations, okay? You're welcome.
Well, that's interesting. Individual voir dire or voir dire. Not sure how much space we have for the media. Interesting. Interesting. Paralegal Mandy, we know you're with us. You just got a gifted membership from Debbie. Thank you so much for that, Debbie. Paralegal Mandy, you were just with us. Good job, Debbie. Deadeye Debbie. So Hellrider, this may, they think it's going to be over by Wednesday or Thursday. Well, not over. Let me rephrase that. The state is going to be done. It seemed like the state and the defense said they'd be wrapping up Wednesday or Thursday, which is what they're supposed to be doing, because when they first went into this, they said the 27th is when they were going to end, which is Thursday, because Shanna Gardner starts her jury selection on Monday. So they have to be wrapping up. I would think they'd be wrapping it up pretty soon. I'm trying to figure out who else. They still have to talk about the finances. They still haven't really talked about the checks. They touched upon them, and they found the checks in Henry's I think it was glove compartment of that blue truck, but they haven't really talked about where they were issued from, how they were issued. I know Aaron was able to find those checks, and we looked at them. Let me see if I can. Let's see. We looked at them last week. Let's look at them again, because I'm hoping that they have to talk about the checks. They've established that Mario knows Henry. They've established that Henry has no connection whatsoever to Jared. So to me, this would be another thing, is these checks. They have to talk about that. And I think it was Detective Johns. They said they were going to bring him back. So here are the checks in question. Written out to Henry from First Choice Home Rentals, signed by Mario Fernandez. So there's the landscaping and cleaning, keeping up with the roof, Kickstarter, good luck. So that's the $2,000, $3,000, and $5,000 from March 28th, and February 4th, out of Navy Federal. So I'm hoping that they bring in somebody. It might be that detective, Mr. Johns, Detective Johns, right? Chris Johns. I think they said they were going to bring him back to talk about the financials. So I'm hoping that they do that. All right, let's see. Who else? What else do we have going on here? Sandra, welcome to Rabbit Ears. Thank you so much. Chris, why we did not cash them? I think he did. I think that's what they found. I think that's what they found in Henry's truck. That they were not canceled. That's not the right word. They cashed them. I think that's I think that's what they found. I think that's what they showed like on day 1 or 2 when they located the truck, whichever day that was the testimony. I can't remember right now. So I'm pretty sure he did. Dina, are we going to see jury selection? We'll do. We're not going to do each day, but we'll do what we did for Mario, where we'll show it. Aaron's going to record it, and then because a lot of it is like the first 2 days. As you remember for Mario, judge just introduced the jury to the process, and then they're off. So we're not going to just sit around for 2 days. So what we'll do is we'll do what we did last time with Mario. We'll just we'll capture it, and then we'll show it again like on a Friday or something, or Friday or Saturday, depending on how long it is. She's supposed to be starting on the 31st, and then her trial is supposed to start the following Tuesday, which would be the 8th. Is that the following Tuesday? Let's see. 4, 5, 6. Yeah. So she's supposed to start on the 31st. Labor Day weekend then is that Monday, and then she starts on the following Tuesday, which would be the 8th. So we'll go ahead and we won't show it day by day because, like I said, it's there's a lot of dead space, if you will. So we'll record it, and then we will show it. We'll show it like on a Friday. So yeah, we'll definitely watch it. Don't worry about that. Let's see. What the Healer, Daryl Brookins and Nicole Roberts. Not familiar with that one. Send us an email. So we can check into that. That's info@trialtvlive.com. Let's see here. Dina, yes. Yeah. No, it's we'll do like we did last time. That was fun. We had a really educational, insightful look into the jury process. So we'll do that again. Thank you, Jenny. There's the email. If you guys want to communicate with us, please send us an email, info@trialtvlive.com. Just make sure that. Let's see. Good vibes only, thanking our mods. So, just kind of review. Let's see, anything of importance that stood out. Let's see, we were talking about the proffer for Kim Jensen. If you guys haven't seen her law enforcement interview, it's pretty amazing. Grizzly has the first one. We watched the second one a while ago. It's pretty eye-opening. She definitely drops a lot of information on both Jared and Shanna and Mario. Shanna would never do anything to hurt the kids, including, end Jared's life, which I thought was kind of interesting. All right. Be good. Yeah, you stop hunting the kittens. Stop it. Debbie with some more Trial TV Live gifted memberships. Thank you so much, Debbie. Oh, Gizla has both. Okay, so Aaron says Gizla has both of the interviews. So thank you for that. So yeah, if you guys have not seen them, Grizzly has both interviews, which we've watched. Very eye-opening. Cat emergency. Well, no, it's just Super Bowl. Being Super Bowl, yes. Why? Or why? Why do you hunt the kittens? They're just little kitties. Well, actually, they're not. They're over a year, but Super Bowl being Super Bowl. Yes, good girl. Thank you, Debbie. Really appreciate your support. Did you get anybody in that one? I don't think you got anybody. But welcome in new members. If you just got a gift of membership and you're coming in, welcome in. Queen Huntress. Yes, that she is. She is the Queen Huntress. Yeah, we're at 34,692. So we're at 34,692. So we have 408 to go. We have 408 subscribers to go. So thank you for helping us get there. Appreciate that. Well, actually, you're gifting memberships. We then have to have people subscribe. But yes, thank you. That's we're at 34,693 subscribers. So let's see. Let me just kind of get back to, we had proffer from Kim Jensen, and then Fred Barton. I thought he was the manager for Allied Security. He was retired from the Navy. He seemed pretty reliable, or credible, I should say. I thought his testimony was pretty credible. He dated John Biggerstaff's wife while John and his wife were still married. What was her name? Like Marie or something? I forget. They said what her name was. I can't recall it right now. He had no problems with John. Everyone was okay with the arrangement. He was asked to hold an item, which was the metal cabinet / firearms cabinet. That was at his house until his son was going to pick it up the following Friday. John's attorney told him to get rid of any firearms if John was convicted. So he was arrested, but it was prior to him being convicted. He stored it in his closet in his bedroom. Kids would break into his bedroom, so he locked it. He's got to talk to those kids of yours. He never looked inside the cabinet. He does say he has a firearm, though. He never heard of Mario, Shanna, Henry, or Jared. And then under cross, he never opened the cabinet. He has no idea how many or what kind of firearms were in there. John and Juan retrieved the cabinet. He never saw or spoke to them after that. Really? What are you doing? All right, hold on. Cat's knocking things down. Cats being cats. Yeah, right? Okay. Bama Green Eyes, how are you? Welcome in. Good to see you. All right, so then John Biggerstaff got up. We found out he was convicted in 2017, which we found out about. We didn't actually know, they didn't say what he was convicted of, but he was convicted of trafficking. Maybe his wife, I don't know, or other people. Well, we know that he was taking photos and or videos of other people. So thank you so much, Debbie. Appreciate your $50 contribution. Thank you so much for your support, Debbie. Really appreciate that. Thank you. You are so very, very kind, Debbie. Thank you so much. CJ Sunshine, good morning. Happy Monday to you. Catastrophe. Well, they just knocked over a little drive. Nothing too spectacular, but knocking things over. All right. Don't you guys know I have to focus on the stream? Come on now. All right, let's see. So he was in the military. He was in the Navy. He says he got this 10 millimeter because he's in a hunting club in South Georgia, and he says there's bears there. So I guess that's what they suggest. That's what they suggest would take out a bear, would be a 9 millimeter. He talks about his financial issues. Oh, and then this was when he stops testimony. He's like, he looks over at the judge and says, Your Honor, if I may. And they sent out the jury. He basically said, as a cryptologist, he saw the court reporter had their screen open, so he could read, and he did say he could overhear the side guy.
Thank you. All right, both sides ready?
State's ready.
Okay, Mr. Holman.
In the courtroom, Your Honor.
Thank you. All right, welcome back, members of the jury. Everyone may be seated. The state calls its next witness.
State calls Juan Biggerstaff.
Juan Biggerstaff, please. Good morning, Mr. Biggerstaff. Walk all the way forward, please. Please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir. Head to your right. Watch your step. You may proceed.
May it please the court. Please state your name for the record.
Juan Biggerstaff.
What do you do for a living, sir?
I'm an independent contractor selling roofs.
How long have you been so employed?
2 months.
And what did you do? Yeah. We do some of these questions to make sure that you project your voice and things. Previous to being a contractor with roofs, what else did you do?
I was in law enforcement.
How long were you in law enforcement?
About 8.5 years.
When did you resign your law enforcement position?
March of this year.
March of 2026?
Yes.
Were you under investigation at the time you resigned?
Yes.
I want to turn your attention to February of 2022. Were you employed in law enforcement in February of 2022?
Yes.
And were you living in Texas?
Yes.
Is that a suburb outside of Dallas?
No, it was in Dallas.
You were in Dallas?
Yes.
What police department did you work for?
Irving.
Which is a suburb of Dallas?
Yes.
Okay. So you're living in Dallas but working in Irving?
Correct.
Is that where the stadium used to be, the Dallas Cowboys Stadium?
That's correct.
So, do you know a person named Mario Fernandez?
Yes.
How do you know him?
He was a family friend of ours.
And do you see him here in court?
Yes.
Could you say where he's seated and what he's wearing?
He's seated to my right. He's wearing a blue suit.
Is he the person closest to the jury or furthest from the jury?
Furthest.
May the record reflect the witnesses identified the defendant.
Yes.
Who is John Biggerstaff?
It's my father.
I want to turn your attention to when your father got in trouble with the federal government. Do you remember that?
Yes.
Were you working in law enforcement when that happened?
No.
Well, how short after, when he got in trouble, did you become employed with law enforcement?
I became employed with them September of 2017, so about a year.
Okay. And do you know where that was in relation to his conviction as opposed to when he was indicted?
No.
Around the same time, maybe shortly thereafter?
Yes.
Okay. At that time, obviously, you were not a prohibited person?
Correct.
And did you help your father in the preparing of the federal affidavit relinquishing his firearms?
Yes.
Tell the jury how you went about doing that.
We collected the firearms that were in the house at the time. Just went by serial number and make and model of all the firearms, and then transported them from the house day of or day after to my sister's apartment.
The jury has already seen this, but just for consistency in the evidence, showing you what's been entered into evidence as State's Exhibit 190, is this handwritten affidavit that you and your father filled out?
Yes.
Whose handwriting is that?
Mine.
And that's lists 20 firearms or items that he was surrendering?
Correct.
Describe for the jury how those firearms were transported.
I took them in my vehicle, which was a Ford Focus at the time, and they were in various bags and gun cases.
And what did you do with them?
I dropped them off at my sister's house, or apartment.
What is your sister's name?
Stephanie Atkinson.
And that was her name at the time? 2016?
Ooh. Yes, I believe she was married in 2016.
And how long did the firearms remain at your sister's house?
Several months. They purchased a house, and at that time is when I went and picked them back up.
Bless you.
So this is, and just for the jury's orientation, this is in 2016?
2016, early 2017.
Before your father was convicted of the crime.
I don't recall the actual conviction date, but I think so, yes.
And if you don't know, that's fine, but if you remember, it was while he was on pretrial release that he had to collect his guns.
Correct, yes, that's right.
And then he was convicted later in 2017.
Right.
Okay. So after the guns were in your sister's, what happened?
So when she purchased the house, she no longer wanted the firearms in their house. I went and picked them up, and I kept them with me. Separated several for myself, kept the rest in my vehicle until I left for Texas later that year.
Which guns did you keep for yourself?
There was a Smith & Wesson 9mm, a Glock 27, it's a 40 caliber, a .243 bolt action rifle, and a Benelli shotgun.
Was one of the guns that you did not keep a Glock 40 10mm firearm?
Yes.
What happened to that firearm?
That was left at Fred Barton's residence.
Explain to the jury how that occurred.
Fred Barton was a friend of my parents, and they had kind of like a gentleman's agreement to leave the guns at Fred's house when I was leaving for Texas.
And when would that have been, 2017?
Yes.
Describe for the jury who went and how the guns were transported to Mr. Barton.
So myself and my wife were in one vehicle. My parents were in my dad's truck at the time. I transported the guns in the same cases and bags that they were in, walked them inside of Fred Barton's house, and I want to say I left them in one of his closets, and then we continued west.
Are you familiar with a gun cabinet that your father owned?
Yes.
Kind of a cheap one?
I don't remember, yeah.
Do you remember if he later on kept gardening tools?
I do not know that.
Did you transport these guns in a gun cabinet?
No.
So they were in just bags?
Yes.
And you put them, you believe, inside of a closet?
Yes.
Did Mr. Barton inventory them in any way? Did he look at them?
Not that I recall, no.
And your father was with you when this happened?
Yes.
What happened after you dropped the firearms off at Fred Barton's house?
I drove to Texas.
When you dropped off the firearms at Fred Barton's house, did you inventory that there were 16 firearms that were dropped off?
No.
You know if that 10mm was dropped off?
Yes.
So you do know that for sure?
Yes.
And you kept the 4 that you've already indicated?
Correct.
I want to fast forward now to December of 2022. Was there an occasion where you became, in your law enforcement duties, wore a recording device to go speak to your father?
Yes.
And was that done pursuant to law enforcement's request?
Yes.
Did that make you feel uncomfortable?
Yes.
Why did you do it?
That's a good question. I had a order from my department that I had to follow just standard operating procedures to be cooperative in criminal investigations.
So pursuant to your law enforcement career, they're like, if they ask you to do this, you should do it.
Yeah.
And talking to your dad, I'm going to go through some of the things that y'all talked about. But before that, did he know that you were being recorded?
I did not tell him no.
That would have been a violation of wearing the recording device.
Right.
It was supposed to be surreptitious or undercover.
Right.
And you did. Did you work as an undercover police officer back in Texas?
Yes.
So you were familiar with that policy?
Yes.
can't tell the people that you're recording them.
Right.
So did you begin the conversation with telling your dad or asking your father the question that should you be preparing your mother for something that's going to happen with regard to this 10 million?
Yes.
And what did your father say?
I believe he responded no.
Did your father indicate anything about the 10 millimeter?
In regards to 10 millimeter, no. Just that the guns would show up January 1st.
Did you remember if your father told you that the authorities only care if the 10 millimeter matches the 10 millimeter involved in the murder that they were investigating?
Yes.
Do you remember your father telling you that he had the 10 millimeter the entire time?
Sorry, I do not recall.
Yeah, you had an opportunity to listen to the wire before. Would you like to listen to that again?
No, it's fine. If that's what is transcribed, then yes, that's what happened.
Do you remember your father saying when they knocked, the 10 millimeter was here?
Yes.
Do you remember your father telling you that it was here and it will appear later?
No, I'm going to object.
Grounds.
Hearsay. He can't testify to what his father is telling him. He can testify to what he tells his father.
What's your response?
It's impeachment, Your Honor.
I'll overrule the objection.
You remember your father telling you that the 10 millimeter firearm was here, meaning with him, and would appear but just cannot yet?
Yes.
Do you remember your father telling you that he did not know where it was at the current time?
Yes.
Do you remember your father telling you that it would appear after January 1st?
Yes.
Do you remember your father telling you that he did not know who had the gun, but they would appear after January 1st?
Yes.
You remember your father telling you that he told ATF that Steve from the Georgia Hunting Club had the gun?
Yes.
Do you remember telling your father telling you that he felt bad to drag you into this?
Yes.
Do you remember your father promising that when that 10 millimeter reappeared that he would turn it in?
Yes.
Mr. Juan Bickerstaff, I'm just going to say your first name just to clarify from your father. You kept 4 of the firearms. How come you didn't sell the other 16?
Never crossed my mind.
Could you have?
Yes.
Were those 16 other firearms, were they valuable?
Yeah.
What about the ammunition?
As far as being valuable?
Well, no. Just what happened to it?
I don't know.
As you sit here today, do you know what happened to that 10 millimeter Glock?
No.
Did you ever go back to Fred Barton's home and take the guns out of his closet?
No.
Did you have any idea if your father did?
No.
I'm going to fast forward to June of 2023. Were you the victim of an auto theft / burglary?
Yes.
Tell the jury about it.
I had a early 2000s GMC Yukon that was a pool car, meaning it was one of the worst cars to have in the department. I had it parked outside of my residence, and I had just gotten out of training for the day. I left my belongings in the car, getting ready to go on vacation with my wife. Came back from like a 3 or 4 day vacation, saw the car was gone, Immediately contacted Dallas Police Department, and while I was on the phone with Dallas Police, I noticed that my car was stopped at the end of the street, abandoned, and several of my bags were stolen out of the car.
So the car was taken from your home, and how far away was the end of the street?
Maybe a quarter mile.
And you were able to see that, I guess, while you were on the phone?
Yes.
And what was stolen?
My department issued Glock 31, which is a .357 SIG, and my Glock 27, which is a .40 caliber, and ammo and other police paraphernalia.
When you provided the serial numbers for those firearms, did you make an error?
Yes.
Tell the jury about it.
So when I was waiting for Dallas Police, I referred back to that inventory and just unintentionally copied down the incorrect serial number, which happened to be for the Glock 10mm, not the Glock 27.
I understand those are on lines 7 and 8?
I believe so, yes.
I'll approach just to make sure. State's Exhibit 190. Counsel is correct. It's the Glock 27 is line 6, and then the Glock 40 10mm is line 7.
Yeah, correct. Yes.
Now, you would agree that this State's 190 is lined.
Yes.
And you filled it out.
Yes.
When you reported the 2 firearms that were stolen, you were aware, or were you aware, I guess is the better question, that the 10mm firearm was important to police?
Yes.
Because you had actually worn an undercover recording device to talk to your father about that 10mm.
Right.
And you, based on your training experience, are stolen guns and reporting them accurately important?
Yes, sir.
And you would agree that you did not report it accurately?
Correct.
And the serial number that you put down was to a firearm that you knew police were very interested in locating?
Yes.
You know why your father would lie to you in that recorded?
Objection, Your Honor, second.
I agree. It's.
Rephrase that, please.
Do you know of any reason why he would lie?
No.
In that recorded conversation with your father, did he also tell you things about immunity?
Yes.
What did he say?
That he didn't believe in the immunity that was offered, and he thought it was BS.
That's all the questions I have now.
Cross.
Good afternoon, sir.
Hello.
Good to see you again. Congratulations.
Thank you.
Try to get you out of here pretty quickly.
Appreciate it.
Now, Mr. Biggerstaff, I'm going to State asked you most of the questions that I'm going to cross-examine you on, so I'm going to just try to be brief with you. In 2016, when you wrote that inventory, that was all the firearms and any other weapons you understood your father to have. Is that correct?
Yes.
From 2016?
Yeah.
And you actually took possession of all those firearms in like a duffel bag and in gun cases?
Right.
Was not in a cabinet of any time when you delivered it?
No.
Now, I know the state asked you, just trying to get you to project your voice, asking you questions about how long you've been in Jacksonville since you left Texas, and I understood that was since March?
Correct. No, I've been back since April of this year.
You resigned your position with the law enforcement office out in Texas?
Yes.
You were not fired?
Correct.
And to be a law enforcement officer, you took an oath?
Yes.
To to uphold the laws and the Constitution?
Yes.
Okay. And I believe Mr. Mizrahi asked you, I'm fast forwarding a little bit, to when you wore a wire. The reason you cooperated was because that was policy of your own department.
Correct.
So it would be in violation of that policy to lie to other law enforcement.
Correct.
No dispute that at some point your dad owned a Glock 40 Gen 4 10 millimeter.
Right.
I think a lot of people call it like a bear defense gun.
Sure.
But you're familiar with it. You've seen it before.
Yes.
And in 2016, that was one of the firearms that you put on that inventory list.
Yes.
I believe it was number 7 on that list that Mr. Mizrahi just showed you.
Yes.
To your knowledge, is that the last time your father saw that firearm is when you sat and completed that inventory?
To my knowledge, yes.
Have you ever seen him in possession of it again?
No.
One of the firearms you kept was the Glock 27 that was stolen out of your vehicle?
Correct.
And that was item number 6 on that list, correct?
Yes.
Okay. And the jury's seen that list and they're going to take it back in evidence, but that was just handwritten right above the Glock 10.
Yes.
When the state asked you about when you retrieved those firearms from your sister and then took them to Fred Barton's house, your father was with you. Or, excuse me, you retrieved them from your sister, put them in your car, correct?
Yes.
Kept them in your car for a number of months?
Yes.
Okay. Any idea whether or not your father had any access to that car?
He did not.
Okay. And then on your way out of town, who helped you move to Texas?
My now wife and my parents.
Okay. Like driving a U-Haul truck and...
We drove my vehicle, Ford Focus, and my dad's pickup truck.
Okay. And if I understood your testimony, literally on the way out of town is when you dropped those remaining firearms off at Fred Barton's house?
Correct.
You walked them inside and put them in a closet?
Yes.
Okay. Did your father go with you?
Inside the house?
Yeah, did he go in the closet with you?
If I remember correctly, he was inside of the house already, but...
Did you see him have access to those firearms?
No.
Okay. And certainly it'd be a violation of his pretrial release or his supervised release if he had been convicted at that point.
Correct.
You then drive to Texas. You become a law enforcement officer out there. I believe it was in 2018 is when you actually got into patrol. Is that accurate?
Correct.
Okay. And at that point, you're just a police officer in Texas. You would come back and forth from time to time to visit family?
Yes.
Okay. Any time coming back and forth that you ever saw those firearms?
No.
Okay. Ever see your father with a firearm?
No.
You guys ever go shooting or anything during that time period?
No.
That would also be a violation of, at that point, his supervised release.
Correct.
And you as a law enforcement officer during this time period would somewhat be required to report him if you saw him in possession of a firearm. If you saw him breaking the law while you're a police officer, you'd be required to report him under those policies that you mentioned earlier.
Yes.
Safe to assume you never reported him because you never saw him in possession of a firearm.
Correct.
In February of 2016, did you come back to Jacksonville?
Yes.
Why?
I was getting married.
Okay. Do you recall when you actually got back in town?
It was the morning or afternoon of the 16th.
Okay. Did you come to learn that that was the same date as the homicide of Mr. Bridegan?
Yes.
Okay. When you came back in town on February 16th, did anybody give you a 10 millimeter?
No.
Did you see your father on February 16th?
Yes.
Did you see him approximately around 8 or 9 o'clock that evening?
Correct.
With your mother?
Yes.
And your mother doesn't drive at night, does she?
No.
Okay, so your father had to drive your mother to your sister's house that evening?
Correct.
And you saw him that evening?
Yes.
Didn't appear nervous or anything out of the ordinary?
No.
No indication anything was wrong with him?
No.
Did you see Mr. Fernandez in the days after February 16th?
Yes.
Okay. Tell the jury about how you saw him.
Mario had offered to help, or my dad asked him to help pick up some chairs and tables to set up for a rehearsal dinner that we had.
And do you recall what date that was?
That was the 17th, I believe.
Day after you got back in town?
Yes.
Okay. Did he appear nervous or looking over his shoulder?
No, I only saw him for maybe 5-10 minutes, but no, he did not.
Otherwise, he just helped set up like you understood he had agreed to do.
Right.
How long did you stay in town?
Full week, I believe.
Did your father or anyone else give you a 10 millimeter to take back to Texas with?
No.
Okay. And then at the end of the week, you just went back to Texas?
Correct.
Continued being a law enforcement officer?
Correct.
Later that year, did you come back to Jacksonville?
Yes.
In 2022?
Yes.
And at that point, had you been interviewed by the ATF?
Yes.
They interviewed you in Texas?
Yes.
Were you truthful with them?
Yes.
Did they ask you about the 10 millimeter?
Yes.
Did you tell them the same thing you've told the jury this afternoon, that you did not see the 10 millimeter?
Correct.
And did you also get interviewed by the ATF here in Jacksonville?
Yes.
Was your story the same? You
Yes.
had not seen it?
Yep.
And again, that's part of the policies in which you have to follow as a law enforcement officer, is your truthfulness with other law enforcement agencies.
Correct.
And as Mr. Mizrahi mentioned, in December of 2022, you agreed to wear actually 2 recording devices.
Yes.
One in your pocket and then one that was like a cell phone.
Right.
Okay? And these were things you were familiar with from your own law enforcement experience.
Yes.
Okay? My understanding is they maintained observation of you to make sure that you couldn't call your father to say you were on the way over there, in order to tip him off that you were wearing a wire.
I don't know that to be true.
Okay. Did you tip off your father you were wearing a wire?
No.
Okay. Didn't write any notes or anything to say, hey, Dad, I'm wearing a wire, don't say anything?
No.
Okay. Did he mention Mario Fernandez at all during your discussion with him?
Not that I recall, no.
Your dad told you a whole bunch of different things during that conversation.
Yes.
Some inconsistencies as far as so-and-so has the firearm, or I don't know where it is, or it's going to show back up.
Right.
In essence, 3 different stories about this firearm.
Yes.
Now, your father had, my understanding, a traumatic brain injury in 2020, or somewhere around that time period?
Yes, yeah.
Did you notice that he had some difficulties after that accident?
Yes.
Did you come to understand your father also had some substance abuse issues?
Yes.
That combined with the brain issues, you noticed a big difference in your father?
Yeah.
Kind of his cognitive abilities?
Yes.
And his physical abilities?
Yes.
After you finished, we'll just call it that recording session in December, did you turn over that recording to law enforcement?
Yes.
Did you get an opportunity to listen to it before you gave it to them?
No.
Did you get an opportunity to listen to it when you were with them?
No.
You just went back to Texas and continue on your law enforcement?
Yeah.
State asked you in June, when you were back in Texas, your vehicle got stolen. This was your undercover vehicle?
Correct.
And the Glock 27 that was stolen, was that the one that was given to you by your father?
Yes.
With the serial number that was listed on number 6 on that handwritten inventory?
Yes.
And as you told Mr. Mizrahi, you just simply put the wrong serial number, correct?
Correct.
Did you refer to the inventory for that number?
Yes.
Okay. And you did not put it was a Glock 10 millimeter that was stolen. You would agree with that?
Correct.
And at the time, you were living in Dallas.
Yes.
So you reported your stolen vehicle to the appropriate agency because you were in Dallas.
Yes.
But you also notified your agency that your vehicle was stolen.
Yes.
At some point, you came back to Jacksonville and you were interviewed or met with the state attorney's office again. Is that correct?
Yes.
And during that subsequent meeting, it had become clear to you that law enforcement did not believe your position on the 10 millimeter, correct?
Correct.
Someone had actually filed some sort of a complaint with your agency that they didn't believe you were being truthful.
Correct.
Ultimately, they put you on administrative duties as a result.
Yes.
No one actually found that you were being untruthful, but because of that complaint, they placed you on administrative duties.
Yes.
You understood that the people sitting at this table, Ms. Stifler and Mr. Mizrahi, didn't believe you.
Correct.
They said as much.
Yes.
And during one of those meetings, they actually offered you immunity in the event you wanted to tell a different story.
Yes.
Did you accept that immunity?
No.
And you know what immunity is from your law enforcement experience, correct?
Yes.
And whether or not that included federal authorities sitting in the room or otherwise, you were interviewed by ATF multiple times.
Yes.
And by state law enforcement.
Yes.
Do you stand by every statement you've given to them?
Yes, I do.
You told the truth every time?
Yes.
Certainly don't want to have a negative impact on your new family by being untruthful with them.
Correct.
Mr. Bickerstaff, did you have any involvement in the homicide of Jared Bridegan?
No.
Do you have any evidence that Mr. Fernandez had any involvement in that homicide?
No, I do not.
Do you have any involvement with disposing of a firearm?
No.
You consulted with an attorney out in Texas during your administrative duty time period?
Yes, employee attorney. Yeah.
It was an employment lawyer, correct?
Yeah.
Do you have any other information that would actually implicate Mario Fernandez in this homicide?
No.
I have just a moment, Your Honor.
Yes.
I said congratulations at the beginning of your testimony. It's because you had a baby last week.
Yes, sir.
I noticed you had the armband on.
Yeah.
Your Honor, I don't have any further questions.
Okay. Thank you. Redirect.
Yes. Mr. Juan Bickerstaff, do you love your father, John Bickerstaff?
Yes.
Do you love your mother?
Yes.
That's all the questions I have, Your Honor.
May the witness be excused.
You may.
Yes, Your Honor.
Okay. Thank you. All right, members of the jury, I appreciate your patience in pushing into the lunch hour. He will be the last witness before the lunch break. Please leave your notepads on your chair, follow the communication over the lunch recess, and I'll see you we'll call it 1:30. We'll come back, okay?
So interesting, he got a pat on the shoulder there, pat on the arm as he walked off from Mr. Drescher, which is the defense. All right, so 1:30. We were breaking until 1:30. Let me just put that up for you guys. Aaron is going to be feeding the cats.
Everyone may be seated. Is there anything that we need to take up before we take the lunch break? Okay, thank you. Court's in recess. What? There was something?
No, I just didn't hear him. I looked at him and I said, I'm so ready to die, I'm not even wearing my mic.
Okay. All right, thanks.
Ed, it was the defense. Did he shake hands? He shook hands. I know he got a pat on the side there, pat on the arm. Did he actually shake his hand? Did he shake his hand? He walks off. He walks past. No, he didn't shake hands. He went to go shake his hand, but then Mr. Drescher patted his arm. So that was the defense. He's on the defense. What do you call it? He's on the defense witness list, so that's why, you get out of there. All right, hold on. So they're coming back at 1:30. Let me just change this. So 1:30. We'll get some kitty cam going for you guys. Aaron is preparing food right now. Let me just put this up. Oops. All right, 1:30. So Juan Bickerstaff, that was the son of John Bickerstaff. And something doesn't jive. There's some stories that aren't coming together. He says that, Fred said that they brought over this metal cabinet, never opened it up. And then Juan says that they, let's see. So first of all, he took them to his sister's house. Sister bought a new house, and she wanted them out of there. So then he was leaving for Texas in 2017. He knows that 10 millimeter was dropped off at Fred's. They literally were on their way out of town. They dropped off at Fred's house. He said they were in various bags and gun and firearm cases. Did he say anything about the cabinet? He didn't really say anything about the cabinet, right? I don't think he said anything about the cabinet. All right, if he said something about the cabinet, I didn't quite catch that. But then he explains he had an undercover vehicle and it was stolen from his house, and then it was recovered, or he saw it just down the street, maybe a quarter of a mile. Several bags had been stolen, so that was the 31, the Glock 31, Glock 27. So when he was saying that it was stolen, he wrote the wrong serial number from the 10 millimeter, and not the 27. So he didn't report them stolen. He didn't report them. He reported them inaccurately. So we knew about that. We heard all about that. And then under cross, let's see. He came back February 16th to get married. We found out about that, or we knew about that. He didn't accept immunity. So he had immunity also. He did not accept immunity. Yeah, that's Rafa. He's howling in the background. Aaron's feeding them. So they're eating right now. So we'll get some kitty cam going for you guys in a bit. Let's see. Yes, that was Rafa. If you heard him in the background, yeah, that was Rafa. That was Rafa in the background. Yes, that was Rafa in the background. Kitty cries and shadow watching TV. Nice. Thank you, Debbie, for all the gifted Trial TV Live memberships. That's just amazing. I couldn't keep up with all the gifts you were you were giving us. Thank you. Thank you so much for that. Shadow's looking for Kitty. Kaylee, Rafa has a wonderful voice. Yes. All right. So they're coming back at 1:30. So we have quite a lot of time here. I'll get the cat set up for you guys. We'll play some music for you guys and enjoy your lunch break. And let me put myself up here. We'll play some music for you guys. And here we go. Let me rewind it. All right. Enjoy Kitty Cam, and we will see you in an hour.
be the same. I am lonely, I only got myself to blame. All of this time I'm wasting, searching for a way out of my skin. Seems like I get left behind at every turn. I'm sick of living this life. taking a dirt nap. Don't need no urn, I'm feeding the worms. Don't call me lazy, I'm pushing up daisies. I met the reaper, now I'm one big sleeper. I don't give a crap, I'm taking a dirt nap. No, don't give a crap, I'm taking a dirt nap. Don't give a shit, yeah, I already kicked it. Ready to close them, I got my toes up. Leave me alone, I'm nothing but bone. Oh, it's a lock, got my name on a rock. I made up London, now I'm 6 feet under. I don't give a crap, I'm taking a dirt nap. No, I don't give a crap, I'm taking a dirt nap. Don't give a shit, I already kicked it. Everybody saying what they wanna be when they're young. They wanna know what you do when you have your fun and never stop to flee. The time will come, so run, 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 run. You run, run, run. You run, run, I don't give a crap, taking a dirt nap. I don't give a crap, I'm taking a dirt nap. I don't give a crap, I'm taking a dirt nap. I don't give a crap.
Living fast, so we set the pace. Junebug, darling, couldn't be replaced. Underneath that moonlit sky, hey, we got lost in each other's eyes. Oh, Junebug nights, electric thrills, two hearts racing, chasing the chills. Hey Junebug, remember those nights dancing under streetlights felt so right. You blew my mind, yeah, you stole my soul. Nowhere to hide, nowhere to go. Junebug, Junebug cake. Give me those Junebug shakes. Fireflies under Tennessee skies. Rebel hearts beating in the summer night's disguise.
sitting on a throne. I've never tried to tell you what to do. I got a full house Spain, why don't you play along too? Isn't it the best for you? Isn't it the best for you? You made it clear now is not a good time. The queen of clubs is always in her prime. Back and forth with a girl like you. I know love is fleeting, but this moment can be so, so true. Isn't it the best for you? Isn't it the best for you? Broken dreams pop from TV screens. Sit and wish your lives away. You'll never guess who won the lottery. Yeah, it wasn't me, I guess again. But still I'll play your stupid games. Download an alternate reality. I will live there every day. I will waste away here comfortably, sinking into my chair. I'll fake the same smile every day. Nothing's secret when we're all sharing. Close strangers watching you. A wall is painted and what could have been. It's too late, what can you do? Electric reflections of myself. Why are they so damn ugly?
Welcome back, everybody. Welcome back. Hope you guys had a good break. Live trial is going to be kicking back in about 10 minutes. Hope you guys had a good break out there. Hope you enjoyed whatever it is you were doing, lunch, dinner, breakfast. Hope you enjoyed our kitty cam. So we had 3 witnesses on the stand today, Fred Barton and the 2 Biggerstaffs, John and Juan. I think I tired out Rafa, which is good. So I'm trying to figure out who else can we hear from? Maybe ATF? Are they going to bring in the ATF? They have ATF on the well, this is the defense. Defense was going to call in some ATFs. A couple ATF. We already heard from one ATF agent, Stengel. Just looking at the defense witness list here. I don't recognize any of these names. Padilla sounds kind of familiar though. James Padilla, expert witness. I mean, at this point, it's the financial guy, which I think is going to be Chris Johns. I think that's going to be Detective Johns. I think they talk about bringing him back in. Debbie, thank you. Welcome back. When you were playing with your kitty, Shadow was watching. She loved Kitty TV. Nice. Jenny G, yes. The jury was very attentive. Let's see. Pipeline is asking. Let's see. Hopefully the jury notices. I've never seen a live court case like this, but I've heard and learned that juries can indeed be very thoughtful. Yeah, no, they were taking notes. Pipeline, they were taking notes. They were they were doing like a ping pong match between the stand, the question, the stand, the question, the stand, the question. They were all taking notes. They are very, very attentive. Camilla says, Oreo, you're late, Aussie. Loved Puppy Bowl. Nice. Grampy, you've been admitting for years that you can be overly skeptical and scrutinize everything. Oh my God, you're half Miss Jensen. Forks and facts, yes. Ready to hear the financial person and the inmate. I don't know if we're going to hear from that inmate. I don't think we're going to hear from Mr. Ponder. I think on Friday, I think the defense was like, he brings nothing to the table, and he was, I don't think we're going to hear from Mr. Ponder. But the financial person, because I'm pretty sure they said it was Detective Johns was the one who was the, was it Leslie Butler? I think it was Leslie Butler. She's the one that said that would be Detective Johns was the one. Yeah, I think she said on Friday. I think she said it was going to be Detective Johns was more the financial side of things. All right, looks like we've got some people coming back into court. Oh, you know what we could do? Let me see if we can. Can we come back here? I guess they're. Oh, there's another inmate. There's another inmate? I thought they were. I heard Ponder's name today. I didn't know there was another one because they said something about Ponder. I heard his name. I heard his name. Pipeline. That is incredible to know. Thank you very much. I never have known if not for this channel and you. Oh, thank you. Glad that we're here to help. Yeah, Debbie, that's what I'm pretty sure it was Miss Butler, Lindsay Butler said that. Because they asked her a few questions about the finances, and she said, no, that's going to be Detective Johns. All right, I guess I can take this off. We can. Looks like they're coming back into court. As they do every day, they put on Mario's tie and his belt. And they do that off camera every day. He's got his belt there. Mr. Hill has the belt in hand. Richard, good to see you. Let's see. Jury may lean towards listening to Dad Biggerstaff as there are at least 3 prior or active duty military members on the jury. Grampy, you wanted to hear Mr. Ponder testify so bad. Yeah. I'm almost positive at the end of the day, defense was like, yeah, no, he doesn't bring anything to the table. Let me see if I can find that real quick. It was Friday. Let's see. Javelle Ponder, 8 times convicted, 6 counts of child. Yikes, what was that about? Judge, I don't weigh his credibility. You've already ruled on this issue. At the end of the day, judge said that could have been asked in 3 questions. The ruling stands. State's trying to get you to reverse your ruling on Kim Jensen. That was Kim Jensen. Let me see. I don't weigh his credibility. Yeah, I don't have it specifically, Dwayne, but I know I'm almost positive. Defense, Mr. Drescher said, there's nothing, can't put much credence on his. Yeah, I can't find specifically my note, but. All right, Debbie, thank you again for the gifted memberships. Let's see. Grizzly Trout TV Live Grandma says, woo, caught up over lunch. Awesome. One thing, how did the older man after the traumatic brain injury hurting his back do tile work after all of that? Right. Then there's that. And we saw him get out of his car. Or a truck. Was it a truck or car? Can't remember right now. And remember that poll camera that defense showed like all day, it seemed like? Yeah, that's a good question. I'm sure the jury is writing that down as well. Yes, Grampy. I got my water right here. Got my water, got my mug. Make sure you guys hydrate. Jill and Villain got the gifted membership. Welcome back in, Ladybug's mom. Great to see you again. Maybe he was just analyzing if the tiles looked good. Yeah, he was a handyman, right? He had a handyman. He was a handyman. So he had a business. So did he say when he hurt himself? It was when his wife was turning 50 and his son was engaged. Yeah, and then we see him on the poll camera in like 2022, right? And he seemed fine. So his son got married the day after Jared was taken out. So that would have been February 17th. So Aussie Gardner for 14 months. So happy to be part of the crew. Thank you, Aussie. Thank you for your 14 months. Thank you, Aussie. Appreciate that. Got Manners, welcome back in. Good to see you. Hey, Gina, how are you doing? Always great to see you and your Pink Floyd. Jennifer King, how are you doing? Any chance you have a decision on the guilt? It's tough. This one there's a lot of doubt. There's a lot of doubt, but the one thing that the state has going for them is that Henry did not have any connection to Jared. So Mario was the only connection between Henry and Jared. His cell phone was off during the time that this happened. Henry's cell phone was off as well. So that's obviously suspicious. What else is going for the state? He paid Henry, but we have to see that still. That still has to come into evidence. We still have to. We've heard about it. We've seen it on our end. These 3 checks. So the connection between Henry and Jared is huge. All right, here we got coming back. We'll talk about it later.
Thank you. Good afternoon. Thank you. Good afternoon. Both sides ready?
State's ready.
Mr. Dreiser, Mr. Hill? Okay. All right, let's bring in the jurors, please. Thank you. All right. Welcome back, members of the jury. Everyone may be seated. All right. How was lunch today? Okay, good. All right. So we are ready to continue with the evidence. State of Florida, call your next witness.
Chris Johns.
Chris Johns.
Good afternoon, Detective. All right. Will you please raise your right hand to be sworn in?
Detective, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
You may proceed.
Thank you, Your Honor. So, jury knows you. We don't have to go through any introductions. You've been brought back primarily to discuss the financial records that you obtained during the course of your investigation. But there was one thing we forgot to ask you, and that's State's Exhibit 199. Detective, have you had the occasion to go to the Potomac address, Mario Fernandez's former rental house, to see how it looks today?
Yes, I have.
And I'm showing you it's been entered into evidence of State's Exhibit 199. Is that a fair and accurate depiction of how it looks today?
Yes, it is.
And I think in the top left-hand corner of the picture, it says the Google Earth image is approximately March of 2025.
That's correct.
So State's Exhibit 199 would have been after Mr. Fernandez sold the home.
Yes.
So now we can go to some of the financial records you obtained. How do you, as an investigator, go about obtaining financial records?
Through a subpoena issued by the State Attorney's Office.
And when you receive those records, do you also receive an affidavit saying that these records are made in the normal course of business?
Yes.
Okay, so what we're going to do is, first of all, State's Exhibit 171. We'll give the jury an idea of how these records are contained. I've opened up State's Exhibit 171, and it should be on everyone's screen now. I hit the right button, but I didn't. So when the jury looks at the tenant financial records, we see two different folders come up. Can you explain that to the jury what those are?
One of them is a Credit One bank credit card, and it's just the credit card statements, and I think the application information. The other folder is his PNC Bank subpoena return, which is his bank account.
Okay, if we open up the Credit One, is this what you refer to as his credit card history?
Yes, sir.
I think it's all pretty self-explanatory, so we don't need to go through that. But let's look at the PNC bank records. We see two different folders when we click on those. Is there overlap contained in those records?
Yes, there is.
Why do we have overlap?
It was just the time period that was requested on the subpoena, and so it was the return of it.
So is there any reason for the jury to spend their time on the June 1st, 2022 to December 31st, 2022 files?
No, the first folder basically covers the time period that we reviewed and then up until the time that he was arrested.
So that would be the 1/1/2022 to August 18th, 2022.
That's correct.
Okay. First thing we're going to look at is that certification. Is that what you refer to as you received from the records custodian?
Yes, sir.
Yeah. The jury can see that published. So we will now go to 1/1/2022 to 8/18/2022. Do we see some redactions in these?
Yes, sir.
Is that like for things like Social Security numbers?
That's correct.
Okay. Of course. There it is. Of course, this Adobe looks completely different from mine Adobe. There we go. So looking at page 22 of State's 171, what is the jury looking at here?
This is a statement for his checking account at PNC Bank.
And if we scroll down on page 22, Can you, for the record and for the jury, indicate what the beginning balance and ending balance was of Henry Tenen on his bank statement for the dates of 1/7/2022 to 2/4 of 2022?
I believe
Well, I guess let me show that for the jury. Is that 1/7/2022 to 2/4 of 2022 the period of the bank statement?
Yes, sir.
All right, and then scrolling down to the balance summary.
The beginning balance is 52 cents, and the ending balance is negative $2.38.
And how many deposits and other additions were there in the bank account?
There was a total of $250 in deposits, and there were deductions in the amount of $252.90.
And we see an average monthly balance. Could you read that for the record?
The average monthly balance on the statement is negative $66.17.
And were there additional charges and fees, like overdraft fees, that were included?
$36 for the statement.
Do these statements also contain banking and debit card withdrawals and purchases?
Yes.
Let's go now to the period 2/5 to 3/4. And do we see that at the top of the statement on page 24?
Yes.
And then going to the balance summaries, can you again show the jury the ending balance, the deposits, and the ending balance?
The beginning balance was negative $2.38. There were $703.50 in deposits, $643.80 in deductions, giving an ending balance of $57.30.
Okay, and we also see significant overdraft fees.
There were a total of $144 in overdraft fees.
And again, we see the debit card withdrawals and purchases.
Yes, sir.
Okay. So now going to 3/5 to 4/6 of 2022, beginning on page 26, what is the balance summaries?
The beginning balance was $57.30. The deposits were $11,518.95. Deductions were $4,601.79. Gave an ending balance of $6,974.46. Bring his average monthly balance to $941.36. And there were $180 in overdraft fees.
So going to the deposits and other additions on page 27, do we see 3 significant check deposits?
Yes.
And can you put the dates and the amounts?
On 3/28, he deposited a check for $2,000. On 3/29, he deposited an additional $3,000 check. And then on April 6th, he deposited a $5,000 check.
And do these checks end up matching the business check stubs that were found in Henry Tenen's truck?
Yes.
Do we also see cash deposits?
Yes, sir.
Okay, we'll get to those in a little bit. And again, we see the banking card withdrawals and purchases.
That's correct.
Do we see work that corresponds to Henry Tenen's truck on 4/4 of 2022?
Yes, sir, we do.
Discount tire, as well as advanced auto parts on 4/4. Do we see those?
Correct, yes.
So we're going to fast forward to page 39. That's not page 39. This is. Yeah, we're looking at page, 38 going into page 39. Do we have the pay period several months later?
Yes, July 8th through August 4th.
And what are the balances?
The beginning balance is $204.63. There were $829.84 in deposits. There were $1,336.39 in deductions, with an ending balance of negative $301.92.
And this would have been the balance shortly before Mr. Tennant's arrest.
That's correct.
So now if we would go ahead and fast forward, do these records contain the check deposits and or the deposit slips of cash that Mr. Tennant did?
Yes.
So turning first to page 44, what are we looking at here?
That is a check, like an electronic check for a credit card payment.
Let's see here, make it look a little bit bigger.
I'm sorry, that's an Advance America payment.
I need to make it bigger. So this was paid to Advance America as from Henry Tennant. In other words, he owed them money for advances.
That's correct.
And that was the amount of $100 done on July 29th of 2022.
Correct.
Okay. And then we're going to go to page 50. It's smaller. What is the jury looking at on page 50?
This is a paycheck for Mr. Tennant from Monessen Pallets.
And can you state what the amount is?
$364.37.
In reviewing Mr. Tennant's bank records, were his payments from Monessen Pallets typically in this amount range?
Fairly consistent amount.
And did they also always include cents? In other words, they weren't flat numbers, like 100 or 200.
That's correct.
And will we see some of these deposits in his bank records?
Yes.
Did you give the date of January 28th of 2022?
No, it's dated January 28th, 2022.
That's okay. The jury can read that. And does it say in the memo what the pay period was?
Yes, the pay period is January 16th, 2022 to January 22nd, 2022.
So about $364.37 for a week's worth of work.
Yes, sir.
And do we see that corresponding deposit?
Yes, sir.
Okay, looking now at page 250, in reviewing these records, did you also notice that Mr. Tennant was making cash deposits?
Yes, sir.
Do you have any idea where that cash came from?
No, sir, I did not.
So looking at page 52, do you see a cash deposit February 11th of 2022 for $250?
Yes, sir, that's correct.
And remind us about when the homicide was?
It was the 16th of February.
Do we see the corresponding deposit check?
Yes, sir.
On 2/18 of 2022, do we also see a cash deposit?
Yes, sir, we do for $340.
And do we see that corresponding deposit check?
Yes, sir.
Or slip? Looking now at page 56, what is the date and deposit here?
It is March 14th, 2022.
And for how much?
$520.
Okay. User error. All right, if we can go to page 56, what are we looking at here?
That's a deposit ticket for $520.
And then page 58.
It's another deposit ticket for $150 on March 18th.
Then on March 28th of 2022, is this the deposit slip for the $2,000 check?
Yes, sir, it is.
And on page 60, what is that?
That is a check written to Mr. Tennant for $2,000 from First Choice Home Rentals, LLC, on March 28th, 2022.
And for how much?
$2,000.
And for what?
According to the memo line, it's for landscaping and clearing.
The person that writes the check puts that information on.
Yes, sir.
in reviewing the records in this case, did you find any invoices from Henry Tenen charging for $2,000 worth of landscaping and clearing?
No, sir, I did not.
And who signed the check?
Mario Fernandez.
And then on the same day, there's another check on page 62. Please read it for the record.
Also from First Choice Home Rentals LLC to Mr. Tenen for $3,000. It says keeping up with the roof, also signed by Mario Fernandez.
Again, did you see any invoices corresponding to that?
No, sir.
And is that the deposit slip for the $3,000 on page 63?
Yes, sir, that's correct.
Then the next check is 4/4 of 2022 on page 64. What are we looking at here?
Also, the third check written by First Choice Home Rentals LLC, dated 4/4/2022, made out to Henry Tenen for $5,000. The memo line says Kickstarter, good luck, and it's signed by Mario Fernandez.
So for the period of time that you looked at Henry Tenen's bank records, were these payments different from the payments he received for his normal job at the pallet company?
Yes, sir.
Were they significantly more money?
Very much so.
And do we see the deposit on page 65?
Yes, sir.
And just to show the jury some of the deposits for his work at his pallet company, we're looking at page 66 is a deposit slip for 2 different checks.
Yes, sir, that's correct.
And do we have pictures of those checks on page 67 and then 68?
Yes, sir.
First 67, again, this is from Monison Pallets, and we talked about that non-round figure of $367.
88 cents, yes.
88 cents. And again, do we have a pay period listed there?
April 10th, 2022 to April 16th, 2022.
And then again on page 68, please put the amount, the date, and then the pay period.
The check's dated 4/15/2022. It's for $483.79. And the pay period is April 3rd, 2022 to April 9th, 2022.
And then we also see some cash deposits.
Yes, sir. A cash deposit for $700 on May 11th.
Again, you don't know where that cash came from.
No, sir.
More cash deposits. Let's go ahead and go to 75. So we see, we'll have to go through each cash deposit. The jury can find that there are several cash deposits.
Yes, sir.
And then go to some more of the checks. On page 77. For the record, just put those items of information on the record.
It's a paycheck from June 10th, 2022 for $365.19. The pay period is May 29th, 2022 through June 4th, 2022.
And then page 80.
This paycheck is dated July 8th, 2022. It is for $324.93. And the pay period covered is June 26th, 2022 to July 2nd, 2022.
Now, Detective, could some of the cash deposits be situations where the legitimate work that Mr. Tenen did was deposited and taken out and then redeposited?
Yes, sir.
We just don't know where the cash came from.
That's correct.
Okay. We are now going to look at Mr. Fernandez and Ms. Gardner's financials. So when we open up their financials, do we look at 3 different folders?
Yes, sir, that's correct.
Explain to the jury what the 3 folders are.
the Navy Federal return, which was, I would say, their primary banking institution. And then Mr. Fernandez had some accounts at USAA. And then there was also an account at ViStar, which I believe he might have been associated with, but I don't believe that to be his money. I believe it was his mother's.
And these three are going to be in States Exhibit 170. So let's look at the Navy Federal, since that's the primary one that we're going to be looking at. Do we see that certification in the first Adobe file?
Yes, sir.
And I'll start with, what is Navy Federal Beached Bank 904?
That is a small cookie business that they owned.
And then do we have a Fernandez checking and savings account in the third Adobe?
Yes, sir.
We also have a First Choice Home Rental in the fourth.
Yes, sir.
Do we have a Shanna Gardner checking and savings in the fifth?
That's correct.
And then the Shanna Gardner Irrevocable Trust in the sixth.
Yes, sir.
So we'll begin first by going through the First Choice Home Rental, because we have First Choice Home Rental checks that were deposited in Henry Tennant's account that we just saw.
That's correct.
So, page 2, what are we looking at here?
This is the membership application for Navy Federal Credit Union for the First Choice banking relationship, and it lists the two owners of this LLC.
And who are the two owners?
Mario Fernandez and Shanna Gardner.
Is there a percentage of ownership listed?
According to this application, it shows that Mario Fernandez is 60% and Shanna Gardner is 40%.
Okay. So we are going to go, and certainly all of these are in the record, so I'm only skipping things for time's sake. Page 46, this is going to be for the time period of February 1st, 2022 to February 28th, 2022.
Yes, sir.
Explain to the jury what they're looking at in the business checking and the business savings account of this LLC.
This is a statement for the period that you stated, 2/1/2022 through 2/28/2022. Unlike a lot of banks, credit unions you have a main account number, and then you would have what they refer to as shares, which are just the sub-accounts of your main account. In this case, you're looking at one, which is the business checking account, and then the other, which is just the business savings account.
And the previous balances, and then show what's deposited.
The total previous balance was $4,206 for both accounts. The total deposits were $56,201.67. Withdrawals were $601.33, and then the ending total balance for both of those sub-accounts is $59,806.61.
And then we'll see on page 47, obviously there was a lot of money deposited. Does it say on 222 and 228 where those $5,000 and $50,000 deposits came from?
I know at least the $50,000 one came from Mr. Fernandez's account.
So from his account into the LLC?
That's correct.
So we see here a transfer from checking for Courtney Thomas. What is this?
That would be a rent payment, I believe.
And do we see that reoccurring on a monthly basis?
Yes.
And is that for the Sandalwood property as opposed to the Potomac property?
That's correct.
Do we have evidence in the Potomac property that rent was approximately $700?
I think it was $800, but I'm not sure.
780,
Yeah.
somewhere in that range. Okay. Do we see on page 50 that there were some legitimate payments made for the care of the Potomac home?
Yes, sir, that's correct.
And please show that to the jury.
You need my, sure.
Should I stop? No, I was just wondering what was going on.
Okay. Mr. Mizrahi.
So we're looking at, get We're looking at page 50. If you could show the jury the payment to Bueller Air.
Yes, sir. Right there on March 3rd, there's a $14,000 payment right there. And that was for Bueller Air Conditioning.
And do we also see payments for items from the Home Depot?
Yes, sir. That's correct.
Do we also see that $2,000 and $3,000 checks that correspond to the checks written to Henry Tennant?
Yes, sir.
And your review of these records was the balance of over $55,000 unusual for this LLC?
Yes, sir.
And although unusual, there was a large expenditure to Bueller Air.
Yes, sir. That's correct.
Was the amount that was deposited well in excess of the $14,000 to Bueller Air?
Yes, it was.
So we're fast forwarding to, well, too fast. Going back to page 53, which is on a separate statement, do we see that $5,000 check on 4/7 made to Henry Tennant?
Yes, sir.
Am I underlining it on check 29?
Yes, sir. That's correct.
We also see a check 30. It was $240.
Yes, sir.
Did Mr. Tennant also deposit cash amounts in $240 increments sometimes?
Yes.
And that $5,000 that we see on 4/7, what was the memo line of that $5,000?
I believe it said Kickstarter, good luck.
Okay, going now to page 59. Do we see transfers that reduce the balance in this account directly to Mario Fernandez?
Yes, sir.
And just, I guess, point the dates out and circle them for the jury.
Looks like June 16th, June 23rd for 5,000, and then an additional for 5,000. And then there's another one for 500 on the 24th.
I think the $500 was a reoccurring one as payment for like his doing this work.
Yes, sir.
And then going to page 72. What are we looking at on page 72, specifically the October 14th?
There was a cash withdrawal for $10,000.
And below that, do we see a transfer to from checking back into the account?
Yes, sir.
In reviewing all of these records, do there appear to be a lot of money moving around?
There was, yes, sir.
And in your training experience, could you figure out really a reason why all this money was moving around?
No, there was no what seemed legitimate reason for it.
Grounds.
Lack of foundation and speculation.
I'll sustain as a foundation.
Well, let me just ask the question because you kind of add it on sometimes. Did you see any reason why any of this should be happening?
I'm going to object to his opinion as to the reason.
Let me see it at sidebar.
All right, so all the we're seeing all the finances now. So Henry Tennant was severely overdrawn, ending balance of $301 at one point. He made $364 a week from the Monessen pallets. So what's that? 3 times 4, $1,200 plus like maybe $1,400 a month he was making. And then March 28th, $2,000, 29th, $3,000, April 6th, $5,000. Paid for by First Choice Home Rental, which had Mario has 60% ownership and Shanna 40% ownership. I wish they would go back to some of those, some of his, like, he went through $10,000 in like a month, because then he was, let me see. There were no invoices found. They didn't find any invoices for any of his, landscaping, clearing, keeping up with the roof. Let's see what else. So Mario had 60%, Shanna had 40%. There was a $50,000 deposit into the Navy Federal, which that came from Mario. Then, there were some payments for care of the Potomac home. So there was a $14,000 payment to Bueller Air and some Home Depot payments. But there was nothing of him buying roofing supplies. Not that Henry's going to go out and buy, a lawnmower, because that should be bought by the landlord. So doesn't seem to be any evidence that Mario bought supplies for Henry to do landscaping, clearing, keeping up with the roof. So what does keeping up with the roof mean? Replacing some shingles? Cleaning it? I mean, I don't know. You would think you'd have to buy something. You'd have to buy some kind of supplies. What about all that tile? Where'd that tile come from? William, hello to anybody I missed. Monday, a lot of work to get back to. No problem. So, and then...
You may proceed.
Thank you, Your Honor. So we left off on page 72. Do we see a cash withdrawal for $10,000 and then a transfer of $5,000?
Yes, sir.
We're going to now, do these records also contain the checks?
Yes, sir, they do.
And we're going to start those on page 117. So explain to the jury what they're looking at on 117.
This is a check written to Tri-H Construction for $2,000.
And is there in the memo line or 4-line information?
Yes, it lists the White Horse property address, and I can't read the rest of the memo line there.
It may say
agreement draw, I think.
I'm not really sure.
Agreement draw or agreement draw, something like that.
And the White Horse is the Sandalwood address?
Yes, sir, that's correct.
And then on page 118, what are we looking at here?
Also a check to Tri-H Construction for $16,300. And it says siding repairs, and it also gives the White Horse Road address.
And both of these checks are back in one of them doesn't have a date on it. Maybe on the other part of the check it does. Yeah, they're both in 2021. Is that fair?
Yes, sir.
And then on page 119?
Another check to Tri-H Construction for $2,573.99. And it says for siding and electrical.
Page 120?
This check is dated October 14th, 21 to Current Electrical Contractors Incorporated. It's for $317 and is also for the White Horse property. It has an invoice number there.
It has an invoice number, okay. Okay, and then on page 121.
This is the $2,000 check that we saw with Mr. Tendon's records. It says for landscaping and clearing.
Page 122.
Another check written to Mr. Tenen for $3,000, and it says keeping up with the roof.
And 123.
A check dated 4/4/2022 for $5,000, and it says written to Mr. Tenen, and it says Kickstarter, good luck.
And do we see a check on page 124?
Yes, sir. This one was written April 5th, 2022 to J.B. Cornwell, I believe. $240. Dirt AS, I'm not sure.
And then on page 125.
Check written on 4/22/2022 for $7,494. Written to Current Electrical Contractors Incorporated, and it lists the Potomac address.
Page 126.
Check written on June 30th of 2022 to J.B. Corwell for $425. I believe it says Store 57.
I think, Detective, if you look at for deposit only, it may be J.B. Coxwell.
Oh, sorry. Yes, J.B. Coxwell.
They're a contractor with an operating account.
Yes.
Page 127.
June 30th, also to J.B. Coxwell for $200. It says for fill dirt for the White Horse Road address.
128.
Current Electrical Contractors Incorporated for $158. And it says invoice 2864-A.
So let's look at the third one, which is Mario Enrique Fernandez's accounts. And do we see his information as well as a family member, which is his brother?
Yes, sir.
And I'm fast forwarding now to page 59. What are we looking at for the statement period 4/8 of 22 to 5/27 of 22?
Yes, sir.
Is there an interesting deposit?
There is a transfer of $45,000.
So what was the beginning balance and what was the ending balance?
The previous balance, or the starting balance, had been $49,804.69. And the ending balance was $2,000.1543.
We're into page 151. Yeah. 4/28/22 to 5/27/22. If we fast forward in those accounts, on page 151, turning your attention to 813, what do we see on in 813?
There was a cash withdrawal of $2,250.
Turning now to the next page. This is going to be page 152. And again, we're looking at a statement period now because we're jumping between different checking accounts in July of 2021. What is this?
It's a bank wire that was received for $382,894.34.
And did your investigation lead to where that came from?
That was the sale of the house that Miss Gardner owned prior to marrying Mr. Fernandez.
And we can see that that money remained in the account for some period of time?
Yes, sir.
And then turning to the next statement period, going from August to September of 21, we still have a large portion of that money remaining in that account.
Yes, sir.
Do we have large withdrawals?
Yes, sir.
And showing you page 156, do we see one of those large withdrawals on 9/13?
Yes, sir, for $150,000.
Now, during the course of your investigation, were you able to determine what Mr. Fernandez's employment was during the period of time that was relevant to your investigation?
I believe during the time that we were looking at these bank statements, he received money from the VA.
In addition to any monies he was receiving from the VA, did he have some rental properties?
Yes, sir, he did.
Which I think you said totaled about less than $2,000?
I believe during the period we looked at, there was a total of $31,500 in rental payments.
Did your investigation lead to where this money is all coming from?
Most of the money that was transferred into this account would have derived from the trust.
And whose trust is that?
Ms. Gardner's.
In your investigation, I think the jury's already heard that her parents were very wealthy.
Yes, sir.
Just look at a couple more of these. 176. Do we see a large withdrawal during the period of time of 1/28/22 to 2/27/22?
Yes, sir. There was a large withdrawal of $36,500.
And then page 180, which is the same period of time, 2/28/22 to 3/27/22. Do we have a large transfer to checking?
Yes, the $50,000 transfer.
Fast forwarding to page 265, I know the jury has already seen the fact that these accounts contain checks. What are we looking at on page 265?
That is a check that was written to Mr. Fernandez from Mercedes-Benz of Jacksonville for $35,000.
And did your investigation lead to what that was for?
I believe it's for the sale of the Tesla.
And finally, on page 277, what are we looking at there?
That is a check to Mario Fernandez from Shelley and Sterling Gardner for $75,000.
What was the date of that?
I believe it was 12/21.
I'll go back to it. Just for the record.
Yeah, December 21st, 2021.
And is there anything on the memo line?
No, sir.
So I want to spend just a minute on the beach baked. Is Mr. Fernandez also listed as the named person on that account?
Yes, sir, he is.
And does it list the 1511 Marsh Inlet Court address?
Yes, sir.
And does it also list Ms. Gardner as well?
Yes, it does.
So just to show the jury, are there any large amounts that are either deposited or written checks on this account?
No, they're usually fairly small amounts, less than $1,000.
Is that consistent with what you learned about the home baked goods account business that Ms. Gardner ran?
Yes, sir.
So just for example, on page 8, we're talking about balances that range between $500 and $1,700?
Yes, sir.
And on page 10, 500 to 1100.
That's correct.
All right. Now, we're going to look at the irrevocable trust. Before we go into what's contained in the bank records, did you also review the trust documents in this case?
Yes, sir, we did.
And what did the trust documents say about Jared Bridegan?
That Miss Gardner could resume being in charge of her trust once she had no further legal entanglements with Mr. Bridegan.
We'll look at that in a minute. This is Bridegan. It's definitely here. I just forgot to read the page down. All right. Let's look at who was the trustee of the irrevocable, Shanna Gardner Irrevocable Trust.
Mr. Fernandez.
And do we see that here contained on page 1?
Yes.
Skip to page 25. Can you explain to the jury the statement period 7/18/21 to 8/27/21 what they're looking at?
Yes, it looks like there was one sub-checking account and then 3 sub-savings accounts. And the total balance, or the beginning balance for the statement period would have been $181,195.93. Ending balance for the entire of the sub-accounts was $179,713.46.
And the identical balances in the 2 savings accounts, would that correspond to the accounts that were designated for AB and LB?
Yes.
Guess we need to go to the beginning of the trust. Do we have an ending balance of 12/28/20 to 1/27/21?
The ending balance was $218,655.88.
Looked at page 52. What are we looking at here? First of all, let me put the dates. 4/28 of 2022 to 5/27 of 2022.
Yes, sir.
What are we looking at here?
The beginning balance was $251,026.15. And then the ending balance was $12,202.61.
And what happened from the 2021, early 2022 statements until April and May of 22? What had changed?
Miss Gardner had opened up another account, and I believe they were separating, so they were transferring out all the remaining assets.
Was there a need for an irrevocable trust anymore?
No.
And we see on that 5/2 transfer of $120,000?
Yes, sir.
Page 68, which is going to be September of 2022, what are we looking at?
This is the Shanna Gardner Irrevocable Trust statement, and it is $0.
I'm showing you what has been entered into evidence as defense exhibit number 3, subsection C, page 25. Can you read that into the record?
Furthermore, and notwithstanding the foregoing, when our daughter Shanna shall have no further legal entanglements with her ex-husband, Jared G. Bridegan, she may elect to serve as the trustee by delivering a signed and notarized document to the trustee then in office.
So we look at page 72. Do we also see a corresponding check to Shanna Gardner in the amount of $75,000 that corresponds to the date and time that Mario Fernandez received that $75,000 check?
Yes, sir.
So now I want to look at Ms. Gardner's checking and savings account. And we're going to go first, page 38. If you could just explain to the jury what they're looking at for the statement period 12/20/21 to 1/19 of 2022.
She has two sub-accounts, a checking and a savings, with a total previous balance of $1,245 and an ending balance of $1,120.63.
And do we see those everyday checking things that she's paying for and things like that?
Yes, sir.
And then from 1/20/22 to 2/19 of 2022, similar type balances?
Yes, sir.
And then 2/20 to 3/19, do we have similar type balances?
Yes, sir.
And then 3/20 to 4/19, similar balances?
Yes, sir.
Then 4/20 to 5/19 of 2022. What's changed?
There was a significant increase in the balances.
Can you show the deposits for the jury and say what they are?
So the previous starting balance was $3,246. And then there was a total deposit in the amount of $233,419.09. And then withdrawals of $15,511.80, giving her an ending balance of $221,147.01.
And do we see those 50, 45, and 120,000 figures in different parts of the other accounts?
Yes, sir.
Are you familiar with the $10,000 threshold?
Yes, I am.
Explain that to the jury.
If you take a cash withdrawal or do a wire in the amount of in $10,000 or more, they're required to do a currency transaction report, which basically reports to FinCEN or the Treasury Department any large movement of money.
That's all the questions, Joe.
Thank you. Cross-examination?
Yes, ma'am.
You need a moment, Mr. Mizrahi?
Other than dropping my pen, no. Don't.
You can take a few trips.
It's evidence. You need this?
No.
This is your notebook.
Yeah, I don't need it at the moment. Thank you, though. Okay. afternoon.
Good afternoon, sir.
Good to see you again. Let's talk about a few things first, globally. Shanna Gardner's family is extremely wealthy, correct?
Yes, sir.
Hundreds of millions of dollars in yearly revenue, correct?
That's what's been reported.
You have no reason to believe that's not true, right?
No, sir.
And Shanna Gardner's parents gave Miss Gardner and Mr. Fernandez money, correct?
Yes, sir.
And through your investigation, you were able to learn that it wasn't just those two $75,000 checks. They got regular and reoccurring money from the Gardner family, correct?
Yes, sir.
Yeah. So although you just talked about two checks, since the moment Mr. Fernandez married into that family, he started getting money, correct?
I can only go and report what is the time period that was reviewed, which those are the only checks that were received, but I have no reason to believe that they did not receive other funds.
They got money wired to them, correct?
Well, the wire that I saw was from the sale of the house.
No, but there was in all of the records you reviewed, they got money wired from the Gardners to themselves, not just checks, correct?
I actually don't recall seeing a wire from them.
You're not suggesting to this jury that they got two checks for $75,000?
No, their lifestyle was funded by the Gardners.
Right, and let's back up a little bit. Let's back up. Jared Bridegan was married to Shanna Gardner, correct?
Yes, sir.
And he didn't work when he was married to Shanna Gardner, did he?
As it was reported, that's correct.
He lived off of the Shanna Gardner trust money, correct?
Yes.
That the Shanna Gardner family paid their children for all sorts of reasons, educational reasons, and as part of their trust fund money, right?
Yes, sir.
Okay. And you pointed out a big transfer from the sale of the home of $382,000. Do you recall when I asked you on direct examination how much Mr. Bridegan got when Miss Gardner sold the home?
I don't recall the figure, but there was an amount he received.
About $390,000 that Mr. Jared Bridegan received, correct?
Yes.
Okay. So no different that Mr. Bridegan received hundreds of thousands of dollars via the Gardner family, right?
Correct.
Okay. So in this trust, you were able to learn that not only did Shanna Gardner get money, the Gardners also gave their other children money, correct?
Yes.
Okay. So there's no disagreement that the extremely wealthy Gardner family gave their children money, right?
No.
And did you make sure that it was clear, and I will if you didn't, the $75,000 checks dated 12/21, Shanna Gardner got $75,000, right?
$75,000 went into the trust and $75,000 went into Mr. Fernandez's account.
Right, from the Gardner money.
Yes.
And the purpose of the trust was so that her money was protected, right?
Yes.
And you said that you were a financial planner here in town. You have your own business, right?
Yes.
So you certainly are aware that wealthy people give their children money, right?
Yes.
For tax reasons, right?
Various reasons.
To lower their inheritance tax, right?
There's several reasons, yes.
There are dozens of reasons why really wealthy people start trusts for their children, right?
Yes.
So let's just globally talk about a few more things. That trust document that says that Shanna Gardner can be the trustee of her own trust if she so elects, if she doesn't have any entanglements with Jared Bridegan, does it say anything about Mario Fernandez?
No, it does not.
So in fact, if she has no entanglements with Jared Bridegan, she gets to control the trust, right?
That's correct.
Mr. Fernandez is already in control of the trust, right?
Yes.
He is the trustee, okay? Right?
Yes.
Okay. So let's now talk about what Mr. Fernandez had prior to the homicide. I'll stand here. Can you publish this? me zoom out. Can you see this, Detective?
Yes, sir.
This would be from the same records that you were talking about from states 170, right?
Yes, sir.
Okay. This is a Navy Federal account, right?
That's correct.
This is Mr. Fernandez's personal checking accounts, right?
I can't see the titling, but the top.
Okay, sorry. There we go.
Yes, sir.
Ms. Gardner's not on this account, correct?
That's correct.
This is just his money. He can do whatever he wants with it, right?
Yes, sir.
And this is the month.
I believe it's on December 28th at the top. But...
Yeah, December 28th to January 27th. This is before the homicide, right?
Yes, sir.
Mr. Fernandez had access to $212,000, correct?
Yes, sir.
He wanted to do anything he wanted with that money. There's no trust that dictates what he could do. That is his money, right?
I mean, I don't know what a divorce attorney would say about that, but otherwise, yes.
They weren't getting divorced, right? So you're married, happily married people. You can just go and take whatever money you want out of your account, right?
Yes, sir.
You don't have to call a divorce attorney to do that. That's your right to do whatever you so choose with the money in your account, right?
That's correct.
You may come home and your partner may be a little upset with you, but certainly there's no law that he couldn't have done whatever he wanted with that money, right?
Correct.
Okay. Okay, let's go to the next month. This is Mr. Fernandez's checking account, correct?
Yes, sir.
Same a statement I showed you before, except for this is the next month, 128 to 227, correct?
That's correct.
He still has $158,000 available to him, correct?
Yes, sir.
Okay. This is the following month, right? Same accounts?
That's correct.
This is after the homicide, 228 to 327, and he had $158,000. The ending balance was $96,000, correct?
Yes, sir.
All right. And that was his own personal checking account.
That's correct.
Now, you suggested to the jury that he transferred $50,000. You recall that?
Yes, sir.
He transferred it to himself, correct?
He transferred it to the LLC.
First Choice Home Rentals.
Yes.
So it didn't come from the Gardner Trust, right? So if it was ever suggested to this jury that Mr. Fernandez transferred $50,000 a week after the homicide from the Gardner Trust to himself, that would not be true, would it?
I think it's a mischaracterization in the way you're stating it.
No, I want to make sure it's crystal clear. If it was ever represented to this jury that Mr. Fernandez transferred $50,000 from the Shanna Gardner Irrevocable Trust 1 week after the homicide to himself, that would not be true, would it?
At least part of those assets would have come from the trust, yes.
What assets came from the trust, Detective? I just showed you that Mr. Fernandez had $212,000. Then the next month he had $196,000. He had plenty of money in his own personal checking account, right?
Yes, that would have come from the trust.
We just talked about that on 12/28 he deposited $75,000 from the Gardners, right?
Yes.
It didn't come from the trust, did it?
Overall, I'm saying the amount of money that he was only making $37,000 a year.
We have to be really careful with our words.
I agree.
Money goes from the trust account to, and I'm going to walk you through it. We're not going to guess, trust me. We're going to go through every single trust account record to see where that money went. But I'm asking you a very basic financial question. You can transfer money from the Shanna Gardner Trust to Mr. Fernandez. He could do that if he wanted to, correct?
Yes, he was the trustee.
That did not happen. That $50,000 did not come from the trust account. did it?
No, that specific transaction came from his account.
Right. And let's say on December 28th, Mr. Fernandez got $75,000. That could have come from the irrevocable trust, hypothetically, right?
Yes.
But it didn't. And this is why I want to make sure that words matter. Shanna Gardner's parents, Shelley and Sterling Gardner, wrote him a check for $75,000 at the end of the year, right?
Yes.
That's where that money came from.
The assets are commingled.
They're not.
They wrote him a $75,000 check, and he did transfer $50,000 from his account.
Okay. We're really going to figure this out together. The Gardners live in Utah, right?
Yes.
And they're private wealth clients of Chase Bank, correct?
Yes.
Because you know that because it says it right on the check. $75,000. This is an example of the two checks that the Gardners gave them, right?
Yes, sir.
You're saying it was commingled, it all came from the same place. This came from a checkbook as a Chase private client from Shelley and Sterling Gardner, right?
Yes, sir.
From their bank account, right?
Yes, sir.
That did not come from the irrevocable trust, correct?
No, that check was, the check that you just showed me was deposited into the trust.
Right. And the identical check, with the exception of it saying Shanna Gardner, it said Mario Fernandez, right?
Yes.
And that came from the Chase private wealth management banking account of Sterling and Shelley Gardner, right?
Yes, sir.
So that didn't come from the irrevocable trust, right?
That specific $75,000, no, it did not.
Okay. And in addition to all the other money that Mr. Fernandez had, you're saying, well, it's all commingled. It came from the irrevocable trust. Isn't that what you're trying to say?
Yes.
Well, $35,000 of it came from Mercedes-Benz of Jacksonville when he sold his Tesla, right?
Yes.
That didn't come from the Shanna Gardner irrevocable trust, did it?
I mean, you'd have to go back and look and see. You'd have to have a much larger picture of knowing where the Tesla was purchased from.
The check came from Mercedes-Benz of Jacksonville, right?
For an asset that was sold to them, but we don't know how that was purchased.
You don't know. So you can't say it came from the Gardner irrevocable trust, can you?
You're correct, I can't.
Right. Because you know for sure it came from Mercedes-Benz of Jacksonville, right?
Yes.
So let's talk about two things that we know for sure. $75,000 came from the Gardners personally, not the trust account, right?
That's correct.
And $35,000 came from Mercedes-Benz, right?
Yes.
So that's $110,000 right there that we know for a fact did not come from the Gardner Trust, right?
It would depend on how the Tesla was purchased. There's no way to know that with the records that we currently have.
You're saying that whenever he bought the Tesla, when did he buy the Tesla?
I don't remember exactly when it was purchased.
So you don't even know if he was married when he bought the Tesla, do you?
Off the top of my head, no.
So you're trying to insinuate that possibly it could have come, this asset could have come from money that was given to him through the trust account for an asset that you don't even know when it was purchased, right?
I'm just saying that that is a possibility versus just saying that the Tesla was his outright, and so the money that he got from Mercedes-Benz was his and did not originate from the trust or the Gardners.
Well, let's circle back.
Okay.
Let's go to the trust. No. Let's go to the trust account.
Mr. Dreiser, could we take a break?
Sure.
Would that be too disruptive to you?
No, it's fine.
The jury will take 15 minutes, okay?
No.
All right, we're going to take a break. Let's see here. Let me just make sure that judge isn't going to come back.
All right, please let the record reflect that the jury's left the courtroom. Everyone may be seated. The court will be in recess for 15 minutes, so we'll come back at 3 o'clock.
All right, taking a break. All right, so right now they're going through all the money. So this is what we've been waiting for. Is this proving anything? I mean, Mario had money before he met. Well, actually, we don't know if he. Well, that's what the defense is trying to get at. We don't know where that money came from for the Tesla. All right. So the only thing that I know for sure is that Mario wrote 3 checks to Henry Tenen for work that we can't confirm he did. We do know that Henry was overdrawn, was in not very good shape with his bank accounts. And then he's given $2,000, $3,000, and $5,000 checks. And then he basically went through that in like a month or two. But the interesting thing is Mario wrote other checks to construction, Tri-H Construction, and he always put, he would put what it was for. Not that he didn't for Henry, but he did work with other construction companies. He wrote multiple checks to all these other construction, all these other contractors. They talk about Shanna being, once she's finished with entanglements with Jared, then she would get access to her trust again. Jared didn't work. I don't know if I knew that. I'm not sure if I knew that, that he didn't work. So he didn't work when he was with Shanna. So everybody's just kind of, well, Mario did work. Mario brought in, he was making $35,000. Wait, how much was he making? No, get out of there. Come on, get. He was making $37,000 a year. I think it said. Stop it. No. Come on. Oh yeah. Mario was making $37,000 a year. So he had income coming into the marriage. So Jared got $390,000 from the house sale. Shanna got 300 and something. She got a little bit less, $382,000. So, $8,000 less. There was a $75,000 check written to Mario, and from Shanna's parents on the same day. So they wrote Shanna $75,000, which went into the trust, and they wrote Mario a $75,000 check. Now, I think Green Eye Cat, you were asking if how did that play into the time frame? That was before. So Jared, his homicide was February 16th of 2022. Those checks were written December 21st of 2021. So basically 2 months before. Apparently they had a business, Beach Bake, which was a cooking, I guess cookies, maybe pastries, something like that. Let's see what else. So, I mean, it's Mario was okay, I'm trying to just go with facts here. Mario was the only one. Let's see, fact number 1. Let's do a game here. Let's play a game. We did this with Blaze Taylor. Let's play a game. Fact 1. This is the biggest fact for me. Fact 1. Jared did not know Henry Tenen. Fact 2. Mario did know Henry Tenen. All right. I guess fact 3, but that, let's see. Fact 3, Henry let's see, who knew, I guess who knew Jared's route on the night of? We're pretty sure it was Henry. Well, let's just say, you know what? All parties agree it was Henry. I'm not going to say who knew. I'm just going to say Henry knew. All right, Henry knew. Henry knew Jared's route on the night of. So who could have told Henry? Fact 3. I guess this is a question. Who could have told Henry? See, that's where I think it's Mario. That's where I think it's Mario and Shanna. Those are pretty damning. Jared did not know Henry. Mario did know Henry. Henry knew Jared's route. Who could have told Henry? The only person that could have told Henry was Mario. So to me, that's Mario. All right. Fact 4. No evidence of. I'm going to these checks. There's no evidence of Henry doing work, contracted, for the checks, right? So he gets $10,000, and there's no evidence of him actually doing the work. What else? Hey, Janice. What else? Hello, Riker. Pipeline said Henry had 52 cents in his account prior to the homicide. His average account balance was negative, so the 10,000 is a huge outlier. It's a strong tale. Right, and I have no problem with Henry getting money, receiving money for work done, but there's no evidence that he actually did that work. There's no evidence that he did that work. So those are pretty big. So I'm trying to think of, if you have reasonable doubt. Jared didn't know Henry. There's no other connection between Jared and Henry other than Mario. And then Shanna. So I'm trying to just think of, if you have reasonable doubt, how do you respond to that? For those out there that have reasonable doubt, or for those out there that have doubt that the state hasn't proven anything, tell me how do you explain Henry being there that night, 20 seconds ahead of Jared's car? How do we explain that? How do we explain that? Show Riker, yeah, she threw up, so I don't know. She's kind of just floating around. She just yacked all of her lunch. Honey clay pot thing is the jury putting all this together? Well, that's the thing. That's the thing. Mia, exactly. Where are the receipts from said purchases for the work? Yeah, that's a big one. Alexa Rose, no doubt there. Hellrider Shanna gave up the route. Thank you, Debbie, for the gifted memberships. Welcome in, everybody. Irish Techie, he got the money for the new pallet business he was starting according to the defense. Sure. And that's the Kickstarter. That's the $5,000 for the Kickstarter. But he was also given $2,000 and $3,000, respectively. So there should have been something. There should have been something. Either he purchased it or Mario purchased, a push mower. Shears. He was doing roofing work. There should have been like shingles. There should have been some kind of receipt. There was no receipt. Crispy Dino Nug. Yakety yak, oh meow back. Nice. Lazy boys, how come we don't make millions and millions of dollars? answer that. I'll get in trouble with YouTube. Purple Hazy, I agree. Why and how would Henry be their only common sense reason linked to Mario? I mean, I'm trying to give him the benefit of the doubt. I mean, he's innocent until proven guilty, you know. So I'm trying to like find an avenue to give him an off ramp, but that's a hard one. That's a hard one to get over. That's a hard one to get over. And then we go to the 9mm firearm that was used, and Mario has a connection with John Biggerstaff, and John Biggerstaff had that. I mean, that's just yet one of those other connections. Oh, here, let's put that into our little fact machine here. Fact 5. Mario knew John. Fact 6. John owned a 10mm. Did I say 9mm? I meant to say 10. John owned a 10mm. Fact 7. 10mm was used. I mean, these are going to add up. I mean, this is like the what do they call it? When all the evidence, what do they call it? I'm drawing a blank right now. You guys know the term. The totality of evidence. Something along those lines. I mean, when you add all these bricks up, it builds a wall. Yeah, I mean, I'm trying, you know, right? You try, you know, I try to find. I mean, I'm seeing more right now. I'm seeing like these coincidences are just. No, there's nothing direct, and we knew that. We knew that going in. Most trials are circumstantial anyway. It's rare that you have, you know, even something caught on camera, you know, is considered circumstantial. DNA is circumstantial, you know. Totality of circumstances, is that what it's called, Kaylee? Thank you. Yeah, I knew it was totality of something. Totality of evidence, something like that, yeah. Pipeline. I thought the defense answered the Tesla sales fund source question very well. The defense lawyer was trying to insinuate that the funds came from Mercedes. What do you think? Well, we're kind of in the middle of it still, Pipeline. We're still in the middle of it. That's where we took the break. We took the break because the defense is saying that the detective is trying to insinuate that Mario bought the Tesla from funds from Shanna, and we don't even know that yet. So that's why the defense was. That's why Mr. Dresser is like pushing back as he should have. He should have pushed back. He's like, you don't know where that money came from to get the Tesla. It could have come from Shanna. But we don't know. We don't even know if they were married yet. So, he definitely sold the car, and he definitely got money from Mercedes, the $35,000. But we don't know. But the detective was trying to say he bought the car with funds from Shanna. So that's where the pushback was coming, and rightfully so, because that hasn't been established. We have no idea when he bought that Tesla. So for him to jump to that conclusion, I happen to agree with the defense on that one. I'd be like, well, you don't know that. You're making an assumption. So until we actually know that, we won't. Show me that actually happened. G-Wig, thank you. Let's see. Let me get to your question. Thank you for that. Appreciate your support. Isn't Henry Tenon saying he's innocent? I guess he will not be a witness in either case. He pled guilty, and then I think in April, he switched it. He recanted. I have the date up here. I think I have it in here. He pled guilty. He changed his plea. Oh, I don't have the date he changed it. I think it was like March or April. He changed it because he announced he had given false testimony in his earlier sworn statements and no longer wished to cooperate or testify against his co-defendants. So he did plead guilty at first. He was going to testify. He recanted, and that's why they separated. That's one of the reasons. I think that is the reason why Mario and Shanna separated. They were going to be tried together, but then Henry recanted, and then they severed their trials. Let's see. Is that Maracha or Mary or Maracha? A very sloppy hit work on Mario and Shanna's part. Thank you for that comment. Sally, age is just a state of mind. It all depends on what state I am in and what day. Today I'm feeling all of my 70 years. Aw, happy birthday. Did we say happy birthday to you? I forget. Anyway, happy birthday. Alexa says it had to be Shanna's parents, otherwise Mario would have had to pay back on the loan he took for the Tesla. Yeah, he was able, so he owned it free and clear, right? So he owned it free and clear, otherwise he wouldn't have gotten back the $35,000. That's true. That's true. When you own something, you get the sale of the car. You don't have to pay. Yeah, you're right. You wouldn't have to pay back. Like if he owed, well, maybe, well, here's the thing. Maybe he did pay down. I don't know how much Teslas are, but maybe he had paid down and that was the value of the car. So maybe he had paid enough that he was able to get back some money. Or maybe he still owed and then he, interesting. Yeah. Now I'm like talking myself out of that. All right, Hell Rider, go grab some lunch. Enjoy your lunch. Bill of sale for that $75,000, Kathy says. Yeah, we don't know why the parents gave them both $75,000. Right? That we don't know why. We don't know why. Iris Techie says, I'm surprised Henry doesn't testify for a deal. It seems they have him 100% regardless of the other conspirators. He was supposed to. He was supposed to testify that he was, yeah, he pled guilty and he was going to testify, and he's recanted. He's recanted. Kathy, Shanna won't testify for her husband. I'm thinking their defense is going to be it was all Mario. I'm going to go out on a limb and I'm going to say that I'm going to go out on a limb and say that Shanna's defense is going to be it was all Mario. She had nothing to do with it. It was all about the kids. She would do anything to not hurt those kids, and I'm also using that, that's what Kim said too. If you watch those interviews, which I believe, I do believe that Shanna was all about the kids, and she wouldn't do anything to hurt those kids, even if it meant taking out their father. I am on board with that. Mary James says, hello, have been watching silently while you work. Have to add, Mario said on the phone he kicked Henry out because he couldn't pay rent. Yes, why give a non-paying tenant Kickstarter money? Weird. Good point. Very good point. That is a very, very good point. Another great point is John Bickerstaff said he had a traumatic brain injury. He's in serious pain, and then he's out doing this tile work. Oh, sounds like they're coming back. So explain that to me. Make that one make sense. That's an odd one too.
Welcome back, members of the jury. Everyone may be seated. Mr. Dreiser, you can continue.
What's the number? Question. Working through some bank records, trying to figure out money, correct?
Okay.
You've reviewed lots of stuff in order to make findings as to where you think money came from, right?
I don't understand the question.
You had access to review lots of documents so you could try to get a better understanding of how the Fernandez family, the Gardner family, and the Gardner wealthy family out in Utah, how they move money. That was part of the job of you trying to figure that out, right?
Not necessarily, no.
What have you been testifying to for the last hour and a half?
I received bank statements for a specific period of time that show a picture of a certain thing, but what you're describing is much larger than what was actually done.
Okay. May I approach, Your Honor?
Yes.
I'm showing you what's been labeled and admitted in evidence as Defense 2. This will help us figure out where the money came from. Do you know that Mr. and Mrs. Fernandez had a prenuptial agreement?
No, I've actually not seen this.
No one showed you their prenuptial agreement?
No.
So you're seeing it for the first time?
Yes.
Okay, and one of the disputes that we were just trying to reconcile is whether the Mercedes-Benz money from the Tesla, you were saying, well, it could have circulated back through money that came from the trust. And I was saying, well, you don't know that. And then you answered how you answered. Do you remember that exchange?
Yes.
Okay. In a premarital agreement, you've seen those through your work, right?
Yes.
In premarital agreements, people put some of their assets that they owned before the marriage.
That's correct.
You're not unfamiliar with that policy, right?
That's correct.
Sorry. You agree with me? I'm still reading from the premarital agreement, right?
Yes, sir.
And then this is where Schedule 1, Mario's separate property is. You see that?
Okay.
Do you see it?
Yes.
It says Mario's motor vehicles, correct?
Yes, it does.
And what does it say that Mr. Fernandez owned before he even got into the marriage?
A Toyota Tacoma valued at $32,000 and a Tesla Model S valued at $47,000.
Okay. And the $35,000 that came from Mercedes-Benz was because he sold that Tesla S, correct?
Yes.
So now we know that that did not come from the Shanna Gardner trust or anything to do with the Gardners, because we know it was a premarital asset before he even met Ms. Gardner, correct?
Yes.
I just need a moment in between. I want to keep these papers organized, Judge.
No problem.
All right. So you testified that Mr. Fernandez, in the month of April, moved. He had about $4,000 or $5,000 in first choice home rentals in the month of March, right?
Okay.
You said that.
Can I see the statement you're referring to?
Sure. It's the month before the $50,000 gets moved. It had a balance of $4,000, $5,000, $6,000, $7,000, right?
Somewhere around there, yes.
Okay. And then Mr. Fernandez transferred $50,000 from his own personal account into first choice home rentals, right?
Yes.
But then we also know that that month he bought a $15,000 AC unit for the Potomac address from Bueller Air Conditioning, correct?
Yes.
So he had to transfer money into first choice home rentals or the check would have bounced, correct?
Yes.
And you don't know if Mr. Fernandez knew exactly how much that AC was going to be, right?
I would imagine that there was some type of talk about price prior to, but...
Maybe an estimate, right?
Yes.
Okay. And you don't want to bounce a check ever, right?
No.
Especially if you have plenty of money in one account, there's no reason not to move over to another account to make sure you cover your costs for that month. That's just good financial planning, isn't it?
Yes.
And he also wrote Mr. Tenen $10,000 worth of checks the next month, correct?
Yes.
So besides the $15,000 approximate payment to Bueller and the $10,000 that he paid to Mr. Tenen, that's $25,000 right there, right?
Yes.
And then you said later he moved another 2 payments of $5,000 back to the original personal banking account, correct?
They were transferred back, yes.
Right. So when you said, I don't know, I can't think of a reason why he would do that, he overpaid himself from one account to another account to cover monthly expenses. He excess paid what the monthly expenses were, right?
I wouldn't characterize that, no.
How could you characterize it any different? He put $50,000 into an account, and he didn't spend $50,000 that month, did he?
No, he did not.
So he overextended additional funds that weren't needed. You agree with that?
Typically, when you deposit funds from a personal account into a business account, you're making a contribution to your company, and you would receive, we're getting into taxes here, but basically the basis of your company would increase, so you would keep that money the way it is.
Or you could move it back.
Or you could move it back.
And then you just adjust your bookkeeping for the month. That's all that is required there, right?
Yes.
You don't pay taxes monthly. So if he overpaid the account to cover expenses and then he moved the money back, he just moved it right back from where it came from, correct?
It would be unusual to do that, but yes, that's correct.
Unusual to you?
To most people who have a business and conduct different books for their business, yes.
And you know that from your training and experience as a police officer, or from your financial planning?
From my financial planning and the tax firm that I own as well.
Okay. And with that information, you think that because he moved excess funds and then moved them right back to the very account, there's something suspicious about that?
I didn't say it was suspicious.
Oh, it's just unusual.
Unusual.
Not suspicious.
Your words.
Not suspicious.
It is an unusual transaction.
That you characterize as not suspicious.
It's unusual.
Nonetheless, when you do all of the things that we're just talking about, there's a complete bank record of it, right?
Yes, there is.
Nothing is hidden, because all you have to do is subpoena the bank, and it showed every single one of these transactions, unusual or not, correct?
Correct.
Okay. So, around the same time period, there is the Shanna Gardner irrevocable trust, right?
Yes, sir.
This is the trust account, also from States 170.
Yes, sir, that's correct.
Top left corner, the Shanna Gardner irrevocable trust.
Yes, sir.
This is prior to the homicide, 11/28 to 2/27.
Yes.
This has an ending balance of $178,000.
Yes, sir.
Identify for me anywhere in this statement. Would you like me to bring it to you?
No, that's all right. I can see that.
Identify for me anywhere in this statement where Mr. Fernandez transferred one single penny to himself.
Well, that's just the balances there.
That's why I asked. You want to see the whole statement?
Sure. There are two transfers of one for $1,800, one for $1,500 that are transferred to a checking account. Unfortunately, the way that these statements are drafted, it doesn't say which account that it went into.
Okay. Except you've already told this jury that those two accounts were designated for AB and LB, the ones that you just read that from, correct? You asked, Mr. Mizrahi asked you, and you said the two sub-accounts were designated for AB and LB, correct?
I understand what you're saying. I'm just saying the statement does not show which account the money was transferred into. It just shows that there was a transfer of $1,800 and one of $1,500.
Detective, do you still stand by that the accounts that you're referring to are for LB and AB?
You're asking two different questions. No. Your initial question was, do I see any transfers on this statement?
No. I asked you, see any transfers, one single penny to Mr. Fernandez was my question.
And as I'm saying here, and I'll gladly show you, there are two transfers, one of 12/1 and 12/15, to a checking account. It does not state which checking account they were transferred to.
You're talking about the highlighted?
Yes.
So you're acknowledging to me that you should show me. I highlighted them and sent them to you, correct?
Yes, you did.
Fair enough that I probably know that they're on there?
Yeah.
Can I see it? So let's show the jury so they can see. Back to the same statement, the highlighted portions that I sent over to you. In that particular month, there are 2 transfers, $1,800 and $1,500, and you're saying that you don't know that those are for the benefit of LB and AB?
According to the document that you're showing me, it does not state the account that they were transferred into.
Any reason to believe they went to Mr. Fernandez?
I don't know where they went based upon the document you're showing me.
Okay, so as you sit here today as the lead detective in this case, you don't have any evidence that one single penny went to Mario Fernandez?
No, sir, that is not at all what I said.
Okay, tell the jury, what evidence do you have that one single penny went to Mario Fernandez?
Are you talking about the totality of the...
No.
Are you talking about the statement? What are you referring to?
This $1,800 and this $1,500. If it went to Mr. Fernandez, you have all of Mr. Fernandez's accounts, detective. You would know exactly if it went into Mr. Fernandez's accounts, wouldn't you?
By looking at other statements, yes.
Do you have any reason to believe that that went into Mr. Fernandez's accounts?
I don't know.
Okay, so the answer is you don't know if any money went to Mr. Fernandez, but can we at least agree if it did, it would be less than $4,000?
Based upon the one statement you're showing me, yes.
I'm talking about, one statement, just this month, right?
Yes.
Okay. This is the next month, correct?
Yes, sir.
Irrevocable trust, 12/28/127, right?
Correct.
This is the month that the balance goes up, right?
Yes, sir.
It doesn't go down. It goes up, meaning there was more deposits than withdrawals, right?
That's correct.
This is the next page. We don't have to guess why it went up. This was the month that the checking account recognized the $75,000 check that Ms. Gardner got from her parents, right?
That's correct.
Okay. May I approach, Your Honor?
Yes, you may throw out.
Can you show me on this statement, the following month, where one single penny went from this account to Mr. Fernandez?
There is not one.
Would you agree with me? This is the next month. Shanna Gardner, irrevocable trust. Can you see that?
Would you mind pulling it down just here for me? Yep, thank you. Yes.
128 to 227.
Yes, sir.
I haven't skipped any months, have I?
Nope.
You see the balance?
Yes, sir.
253,000.
Yes.
Bless you.
Can you tell the jury if there's any evidence that Mr. Fernandez got one single penny from the irrevocable trust?
Well, there are no withdrawals. You can tell that right here.
There are no withdrawals, so you know that Mr. Fernandez did not get one single penny.
There were no withdrawals, correct.
Right. So the answer is he got $0, 0 pennies.
On that statement, that's correct.
Okay. I've shown you 3 statements so far. One statement, there was a $1,500 and an $1,800 withdrawal, and you don't even know where that went. That's where we're at, right?
Based upon the statement you showed me, that's correct.
Do you think that there's a part of the statement I didn't show you?
The statement does not state where the transaction went to.
Right. So you don't know. I didn't mischaracterize that, right? Right? You don't know where that $1,500 and $1,800 went, right?
Based on the statement, no. I answered the question at least 3 times.
That's why when I said you don't know, I thought you would just agree with me. So now you're at the next monthly statement, Detective. Shanna Gardner, irrevocable trust.
Yes.
228 to 327. I think that's the one we just looked at. Must be a duplicate. Nope. I'm sorry, this is right. This is the month of the homicide, correct?
Pull down the statement for me a little bit.
Oh, I'm sorry, this is post the homicide. The last statement was during the homicide, correct?
Yes, sir.
All right, so we're on track. I haven't skipped anything. Shanna Gardner's irrevocable trust, 228 to 327. You see it?
Yes, sir.
Show the jury, please, if Mr. Fernandez got one single penny from the irrevocable trust.
There is a $1,500 transfer. There again, the statement does not indicate what checking account it was transferred into.
Okay. So if he did get a penny, it's $1,500, and you agree as you sit here, you have no idea whether he got it or anybody else in the world got it.
The statement doesn't state what checking account it was transferred into.
Okay. But you have all of Mr. Fernandez's checking accounts for that exact same time period, right?
Yes, I do.
So you would be able to find out in 2 seconds if that went to Mr. Fernandez, couldn't you?
Yes.
It's the next month. Shanna Gardner, irrevocable trust, 328 to 427. You agree with me?
Yes, sir.
Didn't skip a month?
No.
Can you please tell the jury if there's evidence that Mr. Fernandez, the month after the homicide, received one single penny from the irrevocable trust?
There was a $1,000 transfer into a checking account.
You don't know who got it, right?
Not without looking at the corresponding statements.
Even if Mr. Fernandez got every single checking transfer that you've identified, we're not even close to $50,000, are we?
No, sir.
We haven't even breached 10,000, have we?
No.
And this is the irrevocable trust. Irrevocable trust dated 428 to 527, correct?
Yes, sir.
And you told the jury that Mr. Fernandez and Ms. Gardner had separated at this point?
I believe so, yes.
And where did all the money go?
The money that is in the $257,000 accounts went to new accounts for the kids, just under Ms. Gardner's name. And I know there's a distribution of the rest of the assets, but I couldn't tell you exactly where from the statement.
Any reason to believe that Mr. Fernandez got any of it?
I don't recall exactly how much he got.
The vast majority, like hundreds of thousands of dollars, all went to Ms. Gardner, correct?
Yes, sir.
Any evidence that Mr. Fernandez ever got $50,000 from the irrevocable trust?
Directly?
This time period?
No.
Certainly not a week after the homicide. We've gone through all those statements, right?
Yes.
You haven't been able to identify that Mr. Fernandez moved $50,000 from the irrevocable trust to himself 1 week after the homicide. That's for sure. You have not been able to do that as you sit here this afternoon, correct?
Not based upon those statements, no.
Are there any other statements that I'm not showing you of the irrevocable trust, Detective?
No.
And again, this is the following month of the irrevocable trust, 528 to 627. And now it's down to about $10,204.
Yes. Sorry.
And that's consistent with all of the money being transferred to Ms. Gardner, correct?
Yes.
never goes back into the irrevocable trust account at Navy Federal. The money never gets back in there, correct?
No.
And it never goes to Mr. Fernandez, correct?
The statement you showed, no.
There are no statements that show the money ever going to Mr. Fernandez, correct?
No.
And you know that because you showed the jury that Miss Gardner would regularly have like $2,000, $3,000, $4,000 in her account when she was in the marriage to Mr. Fernandez, right?
Yes, that's correct. It was a small amount.
Right. And then after Mr. Bridegan died, now we're talking big money, right? Tens of thousands, hundreds of thousands of dollars got transferred from the account that Mr. Fernandez controlled to Ms. Gardner herself, right?
Yes.
And you have no evidence that Mr. Fernandez was ever on any of the accounts that Ms. Gardner set up when she moved, right?
That's correct.
And you also know that when Mr. Fernandez got arrested, okay, Ms. Gardner had about $500,000 in her bank account, correct?
Something about that, yes. So she had access, not necessarily in her account specifically, but yes, she had access to a significant amount of money.
Way more than she had when she was married to Mr. Fernandez, right?
Yes.
And Mr. Fernandez, in all of his accounts added up when he got arrested, he had about $70,000, correct?
I thought it was closer to 80, but about there.
I'll give it to you, $80,000. Significantly less money that he had during the course of the marriage, correct?
That he had access to.
That he had access to, right?
Yes.
So Mr. Fernandez didn't get richer, he got poorer, right?
Yes.
Because he's divorcing and separating from the Gardner family. He's no longer getting annual gifts, right?
I would not have a way of knowing that.
You do have a way of knowing it because you reviewed their bank records. He no longer got any annual gifts from the Gardners, detective, correct?
I don't know what he does and doesn't get anymore.
Okay. But you do know what went into his bank account, and you know he had substantially less money at the time he got arrested, correct?
Yes.
And he was living with his brother in Orlando, nowhere near Mrs. Gardner, correct?
Yes.
So now let's talk about the checks that Mr. Tenon received, right?
Okay.
There were 3 of them. You agree with that?
Yes, sir.
And they were checks that were at the end of March, and one was in early April, right?
The checks were all given to him at the same time.
Well, they weren't cashed at the same time.
That's correct.
Right? So you weren't there when the checks were exchanged, correct?
I wasn't, no.
Okay. And just because the check stubs were in his truck, you don't know that they were given to him at the same day. You're just making that assumption, correct?
It would be highly unusual that the 3 check stub would still be intact and the checks were not given to him all at the same time.
Unless, as you know, owning your own business, managing other people's businesses, that you can rip one check out, then a second check, and then when the 3rd check comes, you just tear all 3 out and hand it to him. You know that's exactly what can happen, right, detective?
I have never seen that happen before.
Of course you haven't, but in this case, you weren't there when Mr. Fernandez ripped the checks out?
No, it was not.
And although they're on different dates, not one single one of them was cashed the same day, correct?
I think 2 were cash. Excuse me, I apologize. 2 of them were deposited the same day. I think one of them went on hold, and then the other one was deposited later.
Okay. So at that time, let's just get some perspective here. The homicide was February 16th, 2022, right?
Yes, sir.
This is a murder for hire, a solicitation. That's what the jury is trying to figure out here, right?
Yes, sir.
Okay. What evidence of checks or payments do you have that Mr. Fernandez paid Mr. Tenon in November of 2021?
I'm sorry, can you repeat that question?
Yep. What evidence of payments do you have that Mr. Fernandez paid Mr. Tenon any money in November of 2021?
There were statements made that indicated that one of them was a payment.
You have 3 payments in March, 2 payments in March and 1 in April. I'm asking you of November of 2021.
There was no payments made that I'm aware of.
No payments from Mr. Fernandez to Mr. Tenen in November of 2021. Will you agree with me?
Yes.
There are no payments that you have any evidence of between Mr. Fernandez to Mr. Tenen in December of 2021, correct?
Unless there was some cash exchange, there's no evidence of that.
You don't have evidence that the cash was exchanged, do you?
No.
What evidence, and you have no evidence, that any financial transactions occurred between Mr. Fernandez and Mr. Tenen in January of 2022, correct?
That's correct.
Okay. So that's the 3 months preceding the homicide, right?
Yes.
And then there's 16 days in the month of February. You have no evidence that Mr. Fernandez paid Mr. Tenen one single nickel in the 16 days preceding the homicide, do you?
Correct.
Okay. So far, you've agreed with me that Mr. Fernandez hasn't paid Mr. Tenen one single penny prior to the homicide, correct?
Unless it was a cash payment. That's correct.
You have no evidence of, right?
Correct.
So now there's the second half of February, and you have no evidence of any payments that Mr. Fernandez gave Mr. Tenen post the homicide that month, correct?
That's correct.
Then the next month is March. In the month of March, that's when there's all sorts of media articles about this case, correct?
Yes, sir.
The blue truck is released to the media, I think you told this jury March 9th, correct?
That was a little later in March, but it was in March.
Sometime in mid-March, right?
Yes.
That's when, if you were Mr. Tenen and you owned a blue truck, you could be on notice, if you were watching the news, that they may be looking for you, correct?
That's correct.
And it's that same month that Mr. Fernandez writes a check to Mr. Tenen, correct?
Yes, sir.
And you would agree with me that a check has got to be the most identifiable form of payment that almost exists on planet Earth, right?
Yes, sir.
You have to write your name on it. You have to sign it. It comes from your account. It goes into the person who deposits its account. All the information we have is right there for anyone to look at when you write somebody a check, correct?
That's correct.
And then there's memo lines on the check. And the memo lines are for keeping up with the roof on one and landscaping clearing on another, correct?
That's correct.
And you know, as the chief or the lead investigator in this case, that Sonny Fong, 11 months after the homicide, called Mr. Fernandez, correct?
Yes.
And in that call, he asked if he knew Mr. Tenen, and he said that he did, right?
That's correct.
He didn't deny knowing him, right?
No.
Mr. Fernandez's phone records indicate that he's having communications with Mr. Tenen in January and February and March, correct?
Yes, sir.
Okay. So in the conversation, Mr. Fernandez acknowledges, I paid that guy to do some work for me, right?
I believe you made some kind of comment about him, yes.
I mean, it'll stand for itself, but as the chief lead detective in this case, you've heard that call. It's in evidence, right?
Yes, sir.
And Mr. Fernandez says, I had him do some tree work for me, right?
Correct.
That's on the memo line, right?
Yes.
He said, I had him help me with the roof, right?
Yes.
That's on the memo line, right?
Yes.
No one in law enforcement has any reason to believe that Mr. Fernandez knew he was being recorded on that line, correct?
That's correct.
Everyone has spoken to Mr. Fong in this case, and he's testified. He said he had no reason to believe he was being recorded on that call, right?
That's correct.
So Mr. Fernandez would have to, 11 months after the homicide, on an unrecorded phone call, or a recorded phone call that he's unaware of, he just happens to identify exactly what he paid Mr. Tenen for via check?
I can't say why Mr. Fernandez said that.
But you do know that Mr. Tenen did legitimate work for Mr. Fernandez. Your investigation revealed that fact, didn't it?
It was stated that the work was done, yes.
At that time, in March, Mr. Fernandez had he had access to hundreds of thousands of dollars, correct?
Yes, sir.
$5,000 isn't a great deal of money to Mr. Fernandez at that time, is it?
No, sir.
And in that period of time, he writes him a check, Kickstarter, good luck, right?
That's correct.
You learned through your investigative efforts that Mr. Tenen wanted to start his own pallet company, right?
There were some records that indicated that.
Okay, and I'm going to represent to you that it's in evidence that a week before Mr. Fernandez wrote those checks, Mr. Tenen Googled business plans Did you know that?
I know there was some Googling of that. I don't remember the exact time frame.
Ms. Day, we went through the notepad where he wrote in his business plan. We already did that exchange, right?
Yes, sir.
Okay, I'll show you the Google in a minute. I just got to find it. It's not in ours. Maybe it is. Give me 1 second. And it was no secret that Mr. Tenen wanted to start his own pallet company, right?
I don't know whether he actually wanted to start a pallet company or not.
He wasn't making a whole lot of money in the pallet business, was he?
No, he was not.
It's not uncommon that a person who isn't doing well financially would want to do better financially, is it?
No.
Mr. Tenen had decades of experience in the pallet business, correct?
I don't know specifically how much. I would say that he had some experience in the pallet business.
You went and interviewed people at Modison Pallets, didn't you? You and your team?
My team did, yes.
Yeah, and he was a good employee, wasn't he?
Yes.
And he had been there a long time.
Yes.
Fair to say Mr. Tenen knew a few things about pallet work.
That's probably true.
Okay. And then it just happens to be that on the poll camera footage, a pallet truck pulls up to the Potomac address and stops. We went through that exercise, didn't we?
Yes.
And then when you took photos of the Potomac address, when you guys searched it, there was stacks of pallets next to the house, weren't there?
I don't recall that. I'm not saying there wasn't, but I don't recall it.
I'll show you pictures in a second. And Mr. Tenen's business was taking older pallets and fixing them to make them reusable. That's what he did at Modison Pallets, correct?
Yes.
I'm showing what's defendant's 58, already put in evidence. Take a second to look at all the Google searches. Mr. Tenen was Googling business plans the week before he received those checks?
Yes.
And then the other part of your investigation was revealed that Mr. Tenen in January, in January of 2022, Mr. Tenen didn't have a lot of money in his account. You went through that and you showed the jury that he would even have overdrawn months, correct?
Yes, sir.
Okay. So that would be consistent with a person who has to go to their landlord and say, I can't afford to live here anymore, right? His bank accounts reflected that he could not afford to pay rent to Mr. Fernandez, right?
I would say the bank accounts afforded that he probably would have a hard time paying his rent.
Okay, so we agree. And that was the time that Mr. Fernandez said, again, on the Sunny phone call, I tried to work with him, but he just couldn't come up with the money, so I had to get a new tenant. So that's consistent, correct?
Yes.
Now, you know that there are ways that you can pay somebody via implied payments, meaning you don't actually pay them money, you give them value. You're aware of that, right?
Yes.
In your world, in the fancy business world that you come from, that's called sweat equity, right?
Something like that, yes.
Okay. In this case, we know that Mr. Tenen was having a hard time paying rent to Mr. Fernandez, correct?
According to what Mr. Fernandez said on the call, yes.
And according to Mr. Tenen's bank records, they're consistent with that, correct?
Yes.
You told the jury that you think the rent payment was around $800 to live at the Potomac address, correct?
Yes.
So if you didn't want to write checks, if you didn't want to have any cash exchanges, you could just let someone live at your house for free, and every month you'd get $800. That's another way to pay somebody, correct?
I don't understand the question.
If Mr. Fernandez wanted Mr. Tenen to do something illegal for him, he could have just said, why don't you stay in my house and don't pay me rent, and every month it'll be as if you got $800. That's another way to pay somebody, correct?
I mean, hypothetically speaking, yes, I guess he could do that.
But that didn't happen in this case. Mr. Tenen left, put his stuff in the garage, and Mr. Ordway moved in, correct?
And Mr. Tenen was still basically living there?
From time to time, but he also stayed at his girlfriend Peanut's house. You learned that during the investigation, didn't you?
He pretty much stayed at Potomac.
I showed you, and I'll do it again if I have to, but you remember when I showed you the address of what Mr. Tennant had put on the pawn shop receipts after he had moved out of Potomac?
Yes, sir.
It wasn't the Potomac address, was it?
No.
It was Peanut's address on Old Kings Avenue, correct?
Yes.
So he wasn't using the Potomac address anymore after he moved out. He was using Peanut's address.
According to the one slip, yes.
Okay, now we've gone through the month of March, and those checks, and then early April, there's the $5,000 check. That's the $10,000, right?
Yes.
No checks in May, correct?
No.
No checks in June, correct?
No.
No checks in July, correct?
No.
No checks in August, correct?
That's correct.
And Mr. Tennant gets arrested in August.
That's correct.
And there's not a single jail call that you're aware of that you've heard where Mr. Tennant is griping that he never got paid to kill Jared Bridegan, correct?
Correct.
So it's your theory that although you learned that he does legitimate work for Mr. Fernandez, that there's $10,000, that's what he got to kill Jared Bridegan, correct?
Yes.
But you also learned that he did tree work and landscaping at his house, right?
There were conversations of that.
And you saw it. You saw work being performed at the house, correct?
Not by Mr. Tennant.
I mean, I showed you a video of him coming out and unloading boxes from his trunk, right?
Yes, there was a video of him unloading boxes.
But do you think Mr. Fernandez pays Mr. Tennant to kill somebody, and then he calls up and he's like, come outside and unload the truck of my car? Don't you think Mr. Tennant would own Mr. Fernandez at that point?
I can't speak to Mr. Tennant's mind or what he did or didn't do as far as that's concerned.
If it was represented to this jury that Mr. Tennant should be dead to them, Mr. Tennant's not dead right now, is he?
No.
He's very much alive, isn't he?
Yes.
May I have a moment, Your Honor?
Yes.
And I don't know if you want to take, when I am done, I'm going to need like 2 minutes to repack, organize those documents. There was a $10,000 cash withdrawal from Mr. Fernandez's accounts you talked to the jury about?
Yes, sir.
And then to show that Mr. Tennant would get cash, he would deposit cash into his account, correct?
There were cash deposits into his account.
Any reason to believe there's a single transaction where Mr. Tennant deposits $10,000 worth of cash?
No, sir.
$9,000 worth of cash?
No, sir.
$8,000 worth of cash?
No, sir.
$7,000 worth of cash?
No, sir.
$6,000 worth of cash?
They were all smaller deposits under $600.
That you have no idea where they came from, correct?
No.
Mr. Tennant was a handy guy, right?
Yes.
Not making a lot of money at Modison Pallets, correct?
That's correct.
So if he went around and he did odd jobs for people and got cash, that wouldn't shock you?
No.
Okay, so that's where that money could have come from, correct?
I don't know where the money came from, unfortunately.
Yeah, you certainly don't know that it came from Mr. Fernandez, right?
Correct.
And there's no huge increase. Let's say the month that the $10,000 cash withdrawal, did you get any evidence that all of a sudden Mr. Tennant did something that was financially out of his reach, like went to Vegas for the weekend?
No, sir.
Went to the Keys?
No.
Took and bought himself a new car?
No.
Not a single thing that would match that a person didn't deposit cash, but all of a sudden got a huge influx of cash. You have no evidence to believe Mr. Tennant got a huge influx of cash, did you?
No.
In fact, what you do know is that Mr. Tennant owned a Ford F-150 that was blue in color, that was previously owned by his father, and he couldn't even get the timing belt fixed because he left it at Jimmy Jones's house and didn't have the money to get it fixed, correct?
That's correct.
I don't have anything further, Your Honor. I just need a minute to clean up.
Okay. Any redirect of the witness? Okay. And just give him a moment.
I will. Mr. Dryshaw, I need defense 2, please. Thanks, John.
I passed the witness, Your Honor.
Right. Thank you. So, Ms. Rahi?
Detective Johns, could you explain to the jury how what they have seen is just a small snapshot of the potential financial records or financial transactions that would exist in the entire world with regard to these people?
We only collected a few months period of time that was around before and after the homicide, and it does not paint a full picture of the amount of financial benefit that someone would have received during the course of their marriage.
And are there ways that people can make financial transactions that would not appear in bank records?
Yes.
Can you hand each other things of value?
Yes.
Jewelry, cash, anything else?
All kinds of things that are worth something that could be sold later that aren't going to be recorded.
The bank accounts you did receive were the bank accounts that we were able to find out about in subpoena.
Yes.
Could there be other bank accounts that we never found out about?
Yes.
So it's just a small snapshot of the financial records.
That's correct.
Okay. Because the defense asked you questions about there was only the $10,000 in checks, but we also see that Mr. Tennant deposited, although not $10,000 worth of cash, hundreds and hundreds of dollars worth of cash.
Yes, that's correct.
And certainly it's possible that he did handyman jobs, and it's certainly possible that he got it from Mr. Fernandez. We just don't know.
That's correct.
The defense asked you about jail calls, and are all inmate calls recorded?
I'm not sure.
Are you aware of the fact that the jail tells the inmates if they use jail calls that their calls are monitored and recorded?
Yes, that is true.
So if a defendant got on the jail calls after being told that they're being monitored and recorded and said, I'm upset I didn't get my payment for murder for hire, that person would be potentially confessing.
That's accurate.
Okay. During the review of all the records in this particular case, did you see any other $5,000 checks that this defendant wrote to any charitable organizations?
No, sir.
Any investments in any other Kickstarters?
No, sir.
Anything that could be classified as trying to help another person?
No, sir.
He saw payments to himself and to his business interests.
Correct.
Defense asked you lots of questions about whether or not the defendant got any money from the trust account. But the defendant, did he get money directly from the Gardners, meaning the parents, his in-laws?
Yes.
And that was, we know, at least $75,000 because we saw that check.
That's correct.
Okay. He also got over $300,000 from the marital home.
Yes, sir.
That's a lot of money.
It is.
Let's go over with what the defense counsel spent a lot of time discussing was a prenuptial agreement. Do you remember that?
Yes, sir.
is the title of this agreement?
It is a post-nuptial agreement.
Not pre,
Correct.
post.
Yes.
What's the date that the parties were married?
I actually don't remember the exact date.
Oh, it's on there.
Oh, sorry. April 13th, 2018.
April 13th, 2018. Let's look at page 12. The execution of that document?
October 15th, 2019.
That's way after their marriage date.
Yes, sir.
Do we have any idea what cars were transferred in the first 18 months of that agreement? Or 14 months, 16 months?
No, sir.
Could have been the Tesla.
It could have.
Mario's bank accounts. Can you read those into the records? That was written in the post-nuptial agreement?
USAA $1,463.37, and then 2 Navy Federal accounts, one for $3,552.32, and the other for $4,000 to their 3 or an 8, 44.22.
Sure. And then back to that page 1 of defense 2. Can you read into record the incomes of Mario Enrique Fernandez and Shanna Gardner?
Mario Fernandez is indicated that he's self-employed and makes approximately $28,000 a year. And Shanna Gardner also indicates that she's self-employed and makes approximately $36,000 a year.
I think you explained this, but I want to give you an opportunity to make it more clear. Why, in your opinion, did Mr. Tinnen receive the 3 checks on the same day, even though he deposited them on separate days?
My objection is to improper opinion.
Okay.
I think this is directly in response to cross-examination questions.
Respond to the objection, though. What's the foundation for the opinion?
Well, he crossed him on whether or not it was the same day. He crossed him. I mean, he crossed him on this.
I'll allow you to rephrase then.
Explain to this jury how the check stubs were recovered in Henry Tennant's Fiat truck.
The check stubs or the checks in general are a business style printed page check. There's 3 checks to a page typically, and there's stubs. The stubs were found intact inside Mr. Tennant's truck.
And those have been made in evidence, so the jury will get to see it. We talked a little bit on cross-examination about the surreptitious phone call between this defendant and Mr. Fung.
Yes, sir.
And nowhere in that call does the defendant indicate that he gave $5,000 to Henry Tennant as a Kickstarter.
No, sir.
That's not mentioned.
No.
That's all the questions I have.
Anything further for this witness?
Very briefly in response. Is that okay, Your Honor?
Okay.
In that post-nuptial agreement, Mr. Fernandez, it was stated that he made $36,000 a year when they signed that post-nuptial agreement. Is that correct?
$28,000.
$28,000?
Yes, sir.
You agree with me that would be $28,000 more than Jared Bridegan made during the course of his marriage to Shanna Gardner, correct?
Okay. I'll sustain it.
No further questions?
Do you want to be heard? I'll hear you at sidebar.
Okay, thank you.
$28,000 was $28,000 more that Jared brought in. Oh, there's some little low blows going on here. Do we really care that Jared didn't make money when he was married? I mean, I don't know. I guess some people would, that sounds like, I don't know. Shanna maybe had a big heart. She didn't care if her husbands were working or not. I don't know. I hear exasperation in everybody's voice. I hear with the defense. I hear with the witness. Certainly with the state. I think everybody's getting a little exasperated with each other. So Mario had a prenup, but then they showed the postnup. So I guess they had both. Wait a minute, they did have both because he had $28,000 a year. Shanna made $36,000 a year. Was that the prenup or the postnup? Getting confused. Was that the prenup that they showed, or was that the postnup? Parties were married April 3rd, and then it wasn't finalized until like a year later. October 15th, 2019 is when it was notarized. Okay, so that was a prenup.
And then back to that page 1 of defense 2. Can you read into record the incomes of Mario Enrique Fernandez and Shanna Gardner?
I'm not sure if that was the prenup or the postnup. Paul asked Mr. Mizrahi if he's related to the fashion designer. Do they spell their names the same? Yeah, they spell their names the same way. I mean, it is a unique name. It is a unique name. Could be a cousin. Can you imagine if that was his brother? If I get a chance to ask him, I will. If I get a chance to ask him, I will. All right, so they just spent the entire afternoon going over the finances.
One moment. So just for the record, I'm allowing Mr. Dreiser to rephrase his question. Go ahead.
In the postnuptial agreement, Mr. Fernandez did in fact have an income, correct?
Yes, sir.
And when Jared Bridegan was married to Miss Gardner, he did not have an income, correct?
I'm not aware of any jobs he did or didn't work.
You already answered my question earlier. You said you knew that he did not work when he was married to Miss Gardner.
I know that the Gardners provided income and education expenses for their children and their spouses.
Thank you. No further questions.
All right. May the witness be excused, or you want to?
I have to ask one more question.
Okay, go ahead.
Were you aware that Mr. Bridegan was in school during the marriage and learning?
Yes, sir.
That's all the questions I have.
May the witness be excused.
Yes.
No recall?
Oh, he is subject to recall.
Okay. Stay in contact with the lawyers.
Yes, ma'am.
And call your next witness.
Your Honor, the state rests.
All right. Members of the jury, the state of Florida has rested its case. That's going to require me to have a meeting with the attorneys outside of your presence, and right now we'll call it 4 o'clock. So we're going to recess for your purposes for the evening, okay? We will come back tomorrow again at 9 a.m., all right? So leave your notepads on your chair, please, and follow the communication rules. Have a nice evening. All right, everyone may be seated. Please let the record reflect that the jury's left the courtroom. Mr. Dreiser.
Your Honor.
Oh, Mr. Hill, sorry.
Good afternoon. Your Honor, on behalf of Mr. Fernandez, number one, we would renew all previously filed motions with no additional argument to those motions, but this time we would be making motions to count 1 and count 2 for a judgment of acquittal. And if I may, I'll take a few minutes with these. As the court is well aware, judgment of acquittal is pursuant to Rule 3.380. If the close of the evidence for the state or at the close of all evidence in the case, the court is of the opinion that the evidence is insufficient to warrant a conviction, it may, on the motion of the prosecution or the defendant, enter a judgment of acquittal. And as the the court is well aware, that standard changed in 2020 pursuant to Bush v. State 295, Southern 3rd, 179, out of the Florida Supreme Court. Whether the state presented competent, substantial evidence from which a rational trier of fact could find the existence of the elements of the crime beyond a reasonable doubt, viewing the evidence in the light most favorable to the state. So I want to start with count 2, the solicitation, Your Honor. The state is required to prove the defendant commanded, encouraged, hired, or requested another person, in this case Henry Tenen, specifically from November 1st of 2021 to February 16th of 2022, requested Henry Tenen with the present intent that the other person actually carry out the offense. As the state has in their case, it's not necessary for the defendant, Mr. Fernandez, to do anything in furtherance of the offense. However, to solicit means to ask earnestly or to induce another person to engage in that contact. So the definition of earnestly means a serious manner, not lightly, casually, or flippantly. The statute requires, there is no affirmative defense that we have alleged. However, it does require an affirmative communicative act, a command, encouragement, hiring, or request directed at another person. I would point out that the state has not submitted any evidence to the jury of that affirmative communicative act. There's been no testimony that Mr. Fernandez has said a word of encouragement, a text message, an email, or any other act that would actually support that he solicited Henry Tenen. And I'd point to several different cases that specifically are on point, which is in order to show the present intent, and that would be the Florida Bar versus Marable, 645 Southern 2nd, 438.
Slow down. 645 Southern 2nd.
Yep, and I'm going to email those cases to you at this moment, Your Honor, as well as to the state. In that sense, so you'll have electronic copy of all case law. Bear with me, Your Honor, I'll give you that exact citation. That was 645 Southern 2nd, 438, 1994. And it was Marable, M-A-R-A-B-L-E, which establishes that present intent is required, meaning that Mr. Fernandez would have to have the present intent in addition to the solicitation and the communicative act in order to be found guilty and sustain a conviction for solicitation to commit a capital felony. In addition, Palumco, P-U-M-B-L-A-N-C-O, v. State, which is 111 Southern 3rd, 249 out of the 5th DCA, and that was 2013. In addition, State v. Gaines, 431 Southern 2nd, 736, 4th DCA, 1983. That actually established what's considered the Gaines standard. In order to support, there has to be a present intent. In that case, a particular person, their conviction was overturned when they expressed a desire for this to happen in the future, but they did not actually formalize that solicitation. And the court found that that person did not have the present intent for the crime to actually have occurred. Additionally, Your Honor, Jones v. State, 908 Southern 2nd, 615 out of the 4th DCA, which is 2005, requires guilty knowledge or mens rea on behalf of the defendant. I would just point out that there's been no witness who has testified, number one, of any evidence of the actual earnestly requested solicitation by Mr. Fernandez to Henry Tennant during the time period alleged, and simply having that relationship in and of itself with Mr. Tennant is found to be insufficient to sustain that conviction. There's no evidence of encouragement. There's no evidence that Mario Fernandez hired Henry Tennant to commit this homicide. Even in the light most favorable to the state, the checks that have been presented by way of Detective Johns and Miss Lindsay Butler are post the time period of which the state has charged Mr. Fernandez. There's been no testimony that those were actually for the homicide. There's been evidence submitted that Mr. Tennant completed legitimate work by way of the recorded phone call and the poll cameras that are in evidence as well. Additionally, with regards to count 1, as a principle, murder in the first degree, there again has been no evidence of the intent. There has to be a communicative act to show that Mr. Fernandez had an intent for this crime to occur. Having a not positive relationship, if the state were to rely on the interview of Mr. Fernandez, where he clearly states that him and Mr. Bridegan didn't have the best relationship, that in and of itself is not sufficient evidence to submit to the jury that Mr. Fernandez had the intent that Jared Bridegan be murdered. Additionally, the second element, as a principle, that the defendant did some act or said something, again, a communicative act, or did some act that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. There has been no evidence at all to establish Mr. Fernandez's intent. Nothing to be submitted to this jury, either for the solicitation or for the murder in first degree as a principle. As the state conceded, Henry Tennant is who they believe to have actually committed the homicide, not Mr. Fernandez. That is why they have submitted the principal instruction. Again, simply having that relationship with Mr. Tennant does not carry the day. With regards to element 2, we have heard no evidence of any incitement, cause, encourage, assist, or advise the other person to actually commit the crime. And I would draw the court's attention to a case that's so close to being on point. It's in essence a man killing the husband of the woman he was having an affair, and that's Williams v. State, 314 Southern 3rd, 775. That is a first DCA case from 2021. That proof of a relationship alone with the perpetrator is not enough. There must be proof of some overt act or words uttered in furtherance of the scheme that led to the murder, and where no such evidence exists, a motion for judgment of acquittal must be granted. Under Penny v. State, which is 421 Southern 3rd, 476, out of the second DCA of 2025, in order to be a principal in a crime, one must have a conscious intent that the crime be done and do some act or say some word which was intended to and does incite, cause, encourage, assist, or advise another person to actually commit the crime. The one other point I would establish is that v. Coxwell v. State, 397 Southern 2nd, 335, 1981, establishes that both the principle for first-degree murder and solicitation both require the same communicative act in order to establish the intent, as well as with count 2, the actual solicitation. This means that solicitation charges and the principal liability charge both require the same proof of the communicative act. The act of counsel, procurement, or instigation. Where the state has submitted no evidence of that act, both charges fail simultaneously. The absence of any evidence of the communicative act, therefore, is fatal to both the solicitation charge as well as the principal liability charge. There's been no evidence submitted. I would argue contrary evidence that Mr. Fernandez had any motive to commit this crime, much less any intent that was submitted into evidence. There has been no testimony whatsoever to establish the intent element, certainly no evidence of communications that support the intent or an overt act. And mere association with or proximity to the perpetrator is insufficient to establish principle. Applies to both murder as well as, by principle and solicitation. In every Florida case, a solicitation conviction has been sustained. There has been some form of evidence of the communicative act. I draw the court's attention to Castro v. State, 939 Southern 2nd, 306, 4th DCA 2006, where an ex-husband sought to have the ex-wife murdered by a hitman. The defendant communicated with an undercover FBI agent, recorded conversations, communicating desire and intent to have the ex-wife killed. Robinson v. State, 267 Southern 3rd, 567 1st DCA 2019. Defendant clearly and repeatedly expressed present intent to commit first-degree murder. Hudson v. State, 368 Southern 3rd, 70 1st DCA 2019. Jail phone recordings providing victim's address to gang members and relief the victim had died. Those three cases are where the convictions had been sustained because of the communicative act that was recorded or ultimately testified to.
I might be familiar with the Hudson case.
That might have been your case. I didn't see that in the footnote. You won't have to read that one, I suppose. Okay. By contrast, there has been no evidence of any communicative act by the defendant to Henry Tennant, who is charged in this case as far as the solicitation. There has been no evidence that Mr. Fernandez asked earnestly as required by the statute. No competent, substantial evidence. Maybe evidence that the defendant learned after the murder, but no evidence of prior knowledge or conscious intent. And one further argument, Your Honor, is that the state is prevented from inference stacking. The state is seeking to simply stack inferences and may get up and argue that this is somehow putting pieces of a puzzle together by way of circumstantial evidence. However, the Florida Supreme Court ruled in Baugh v. State, 961 Southern 2nd, 198 in 2007, its well-established evidentiary principle bars a criminal conviction when the fact finder must draw an inference from another inference rather than from admitted evidence, and it remains in place even after the JOA standard was changed by Bush v. State. This is not assembling pieces of a puzzle via circumstantial evidence, Your Honor. Based upon that argument in the case law, we would move for a judgment of acquittal on count 1 and count 2.
Okay. Can you give me just a moment? I'm trying to catch up. Did you send that?
I sent it to you.
You sent it to my judicial assistant?
I did, Your Honor.
Can you send it to me?
I can.
Thanks.
Yeah, I mean, the defense doesn't have to put on
the Williams case.
Sorry.
That's a duck hunting case.
It is, Your Honor. Your Honor, admittedly, I don't have your email address, but your JA just indicated she received it.
Okay.
I'll ask her.
I don't know. Well, she'll send it then. Thank you.
I'll give Judge Kite credit. She's actually reading through. Usually judges are like, yeah, no. Yeah, no. I'll give her credit for at least to read some case law. Usually with these JOAs, judgment of acquittal, usually the judge is pretty quick in deciding, no, let's let it go to the jury. But she is taking the time to read it. So I was going to say, if the defense does not put on a case, then they're going to be in closings tomorrow. We'll be in verdict watch. I was planning on going Wednesday. Hi, Houdini. Hi, girl. Ruth Ann, yes, the state does get to argue, yes. Yeah, the state should, yes. The state will have a chance to argue, of course. Lazy Boys, I've only seen it in the Alec Baldwin. That's the only time I've seen it too. I know some of you have seen it other times. All the trials we've covered, I've never seen a judge. I think it was Alec Baldwin. I think that's the only time I've seen it. Judgment of acquittal. It's basically the defense after the state rests. The defense says the state did not prove their case. Our client should be allowed to go free. So it's judgment of acquittal, and it's when the defense after the state rests. The defense says they didn't put on a case that proves that my client did it. They should be allowed to go free. Kimbers, yeah, that's the only one that I've seen. It's the only one that I've seen. Got manners. Yep, there's going to be 2 more. Shanna's coming up. Her jury selection starts July 31st. Her trial starts September 8th. I will definitely be there for opening statements. And then Henry is, I think, in March 2027. I think that's when it is. K-Girl says judgment of acquittal was also granted in Michael Turney trial. Yeah, we didn't cover that one, so I'm not sure. Yeah, I'm sure it's happened before. I'm just trying to think of trials that we've covered, and it's always been denied. And now we wait. Dobb says, this is close for you. We know he's guilty, but once Tennant backed out, it puts the state at disadvantage. The only tie to Bridegan is Mario to Tennant. There's Pammy. How are you? Yeah, I agree. I hate to chat when I'm watching something that's not current. Brad says, and often they don't tell you whether they're putting on a case until the next morning. Yeah, that's true. Because they're going to talk to Mario. They're going to talk to Mario, see if he wants to testify. They're going to review their case. Do they even need to put on a case? Yeah, they won't. They probably won't unless they know for sure that they may want to converse with each other. And do we even need to put on a case? They have a huge witness list. I showed you their witness list. This is their witness list. This is the defense witness list, and it's 1, 2, 3, 4. Wait a minute.
Okay, I'm ready to hear from the state.
4 pages.
Yes, Your Honor, I appreciate the defense counsel bringing up the new standard in Bush because they spent the vast majority of their argument speaking about direct evidence that's required to prove a particular crime. Obviously, the state has put forth a substantial amount of circumstantial evidence that proves this defendant is guilty of both charges. It begins with 1,000 different facts that distinguish it from the Williams case, including that the Williams case specifically had a co-defendant that specifically provided testimony, essentially exculpating the defendant by saying, well, she didn't really help me plan the murder. We did talk about it, but I did it on my own. In this particular case, the only link between the stipulated shooter and the victim is this defendant. It's his tenant. This defendant had a motive that we spent a lot of time putting forth evidence of. This defendant had access to the 10-millimeter firearm that was eventually potentially used in this case. This defendant had a consciousness of guilt after the fact by deleting text messages and resetting his phone so things could not be discovered. This defendant's tenant went on a dry run all the way to the victim's home, all the way to the crime scene, and then back to the rental home where this defendant was. This defendant paid the stipulated shooter for what a reasonable juror could believe was payment for the homicide. Again, doesn't require specific direct evidence of the payment, merely that a rational finder of fact could find that that was paid for the homicide in context of all the payments made to all his different business ventures and those phone records, and those financial records. The outlier of Henry Tennant's $10,000 is stark and shocking, and a reasonable trier of fact could see that that was payment for the homicide. So in the totality of all the evidence, it's very distinguishable from Williams. There is competent, substantial evidence in multiple different arenas that this defendant was the link, the hub of all the spokes that ended up with this victim dead. And if the court has any specific questions or any specific things we need to talk about, I can certainly answer those questions, but I think there is competent, substantial evidence. And I'll point out that the solicitation in all those cases, the act itself didn't happen. You're just talking about it to an undercover police officer, so you have the solicitation going on. Here, the act happened, so you don't have to worry about whether or not there was an earnest ask, since the earnest ask ended up in the victim's murder.
So the defense points out that there's a lack of evidence related to, even viewing the evidence in the light most favorable to the state, of any communication for the solicitation.
Sure.
I can go down the elements, but...
Well, the communication, certainly the evidence is that he paid for it. But in addition, Your Honor, this defendant had substantial contact with the tenant in the months and days leading up to this crime and after the crime. Those contacts were deleted by both parties on their phones. There is no requirement in the law that we use one co-defendant against another co-defendant as long as there's substantial competent evidence to show that the agreement happened. Your Honor knows the agreement happened, the solicitation happened, because the victim was killed by his tenant with no link to the victim. But remember, the solicitation in a lot of those cases about the communication has to deal with situations where the ultimate act did not occur.
Okay, so I'm going back to the elements. It's commanded, comma, encouraged, comma, hired, comma, or requested.
Right.
And then...
And the only reasonable, in the state's mind, in the light most favorable to us, which is what the standard is, the only way to view the evidence that we've presented is this defendant hired Henry Tennant to do this.
Okay. Give me just a second. So that Williams case is a little dense. They go through a lot of
it's really dense. And it took
legislative history, but really what it comes down to, where the first district found that the trial court erred, is that, like Mr. Mizrahi pointed out, there wasn't any, well, actually the flip co-defendant flipped back and said that there was basically, this person, Denise, did not do anything. Additionally, there was talk prior to, which they found the trial court did not err in not, well, basically letting the case go to the jury on the conspiracy, just the other two crimes.
Your Honor, I would just point out that the Williams case was specific to the principal theory.
Of first-degree murder?
Correct.
Correct.
And I didn't know if you were speaking to the...
So there were a lot of things at play. There was conspiracy. There was first-degree murder. The principal theory, it was related to that because they were saying assist, advise, encourage, and they were going through the legislative history of the words aid and abet, and they were going through, that's the part that's dense a little bit. But ultimately, if you get to the meat of the opinion where trial courts need to be aware is that, let me go back up. So in that case, which Mr. Mizrahi points out, it says and I'm reading, let me see what page is this, 787. It says, while Brian characterized the planning of the murder as very mutual, he also stated that he planned a lot of it and that he instigated a lot of it. And Brian never testified about anything Denise did or said to incite or encourage him to commit the murder. It's very different, I guess, factually, which is what Mr. Mizrahi was pointing out, that you had someone that was at one degree/level, and I think that's where the appellate court was drawing the line, saying that Denise Williams was culpable, her conduct was culpable based on words when it related to the conspiracy, but not because of this Brian witness. He delineated that he was the main factor, therefore making the evidence not competent or substantial enough to go to the jury. That is the way that I read that. So in this case, while I hear the defense say, and your theories are based on all of the cross-examination that you did, the state of Florida is allowed, if legally sufficient, to go to the jury based on the evidence. And I am familiar with the inference stacking, but there has to also be basically, the court has to be careful between that prohibition by law and what is legally permissible related to circumstantial evidence. And so I believe that the evidence that this court has seen through the testimony of the witnesses, viewed in the light most favorable to the non-moving party, which is the state, is sufficient to go forward. So I'll deny the motion for judgment of acquittal.
Was that to both
counts? On both counts.
Understood.
So let's have a conversation about what's going to go on tomorrow. You're going to have your witnesses available and ready at 9 a.m., if any?
Yes, Your Honor.
Then what?
I would expect it to be an extremely light day. I think you've given me latitude that if that happens, we can work on our closes and close Wednesday.
Yes. So what I would like to do is, depending on the hour and time, we will finish the defense case. Is there anything left unmoved in, or everything's in from your perspective?
Everything's in from our perspective at this point.
Okay. We will do that. We will have the charge conference, as I've previously indicated. Melanie, I'm going to ask that you stay, okay? I'm going to talk to the lawyers off the record, but I'm going to ask that you stay through that conference off of the record so that we can put it on, so that starting hopefully Wednesday at 9 a.m., I would read a portion of the jury instructions up until the point, and this is where I stop. I don't know that you all have tried anything with me, Mr. Dreiser, Mr. Hill, Ms. Day. So what I do is I read up until submitting the case to jury. Oh, no, I'm sorry, rules of deliberation. So I stop there, and then I don't read rules for deliberation. I stop right before then. I let y'all argue. Then I pick up after that, submitting the case to jury, the verdict forms, and then they would retire after that for their deliberations. Does that sound okay?
Yes, ma'am.
And does the court envision not doing that Wednesday afternoon or waiting until Thursday morning? I guess since we have a waiver, it doesn't matter.
Well, I would let them deliberate late. I mean, late, like 8, 9 o'clock, and then let them come back if they can't reach a verdict. So if we start at 9, these jury instructions aren't that long. So I would envision that they would possibly get the case early afternoon. So they would have 6-7 hours to start deliberating.
And is there any chance of doing the closing tomorrow, even if it's a bifurcated proceeding?
I wouldn't do that. What I would do, I will give y'all, so what we would do the charge conference, we break so that you all have plenty of time, you're rested, the jury's rested, so that you all can work on your closings, you'll know what the law is. That would be my plan.
Yeah, just hashing it out really informally with the state, it's probably going to be like state's close in the morning, defense close in the afternoon, and then deliberation, given the time that each party thinks they'll go.
I read about a minute or so a page, and so the opening instructions are about 20 pages, so that's like 20 minutes, give or take. And then, so you think your closing would be
Say she does
all morning?
Well, if she does, let's just say she goes a couple hours, then I would probably request that they get maybe an early lunch, and then I go. Maybe we just
lunch is like a clockwork, Mr. Dreiser, so it comes at like 11.
I would tell the court probably an hour 30 to hour 45, but build in a little extra time for that, just in case.
So for your first close?
Yes, ma'am.
And then if I'm long, so just
okay.
So I would still want to that I would like to not be broken up. Like I don't want to take a lunch.
Would y'all rather them just come back the next day and deliberate?
I think it depends. Let's say we take a lunch.
I'm trying to give them a whole day. I could start the instructions at 8:30 if that would help.
Can we discuss amongst ourselves and come back to the court with some kind of better idea of scheduling? Now that I'm hearing this, I'll speak to Mr. Dreiser about how many witnesses tomorrow. It's conceivable, rather than breaking it up that way, I could get through first close tomorrow afternoon, depending, but I need some time.
I think that's a really strong possibility.
So let me propose this for your discussions. You don't have to commit. Let's say the defense finishes relatively early. We have our charge conference. I don't think it's very complicated. It's very straightforward. There are a couple of things that I'd like to talk to you all about tonight that I think would help. Would you like for me to read the instructions, send them home, and then start your closings in the morning, first thing? And then would that help? So in the morning, if they start at 9, they essentially have 4 hours. And then, do you think you could get it done by then?
I think we would have the entire afternoon.
Right.
As I like to have them rested, it seems silly to waste that time from the state's perspective. I think that the thing that makes the most sense is that we do the defense case, we have a charge conference, we have a large break for lunch. The Stifler does her closing. We come back fresh on Wednesday for Mr. Dreiser's closing in the puzzle. Then they get their case much earlier in the day.
When would I be reading, according to your plan?
Before Ms. Stifler does her closing.
So 20 minutes, you would, okay.
I think we would have the whole afternoon.
I think he may be right.
Right, that'll give us 4 hours, and that's plenty of time to get the instructions and first close done tomorrow afternoon.
And then it'll be the next day, defense close rebuttal case.
Mr. Dreiser gets a overnight to think about it, so.
They get a nurse to his minute.
It does.
I'll take it.
You're also giving him extra time to figure out what to say.
Yeah.
Longer and longer.
God, I probably couldn't do it without that extra time. But thank you. I'll take it.
I'm joking. All right.
Just a proposal.
Okay. First order. All right. We'll be done for the day then. And I want to see the lawyers at sidebar because I have a few questions that will help me. I'm going to push my draft of the jury instructions out to you all. Okay. No, I just have some questions before I. All right. Court's adjourned. Thank you all very much.
All right. Excuse me. So interesting going-ons there. Let me just kind of recap a little bit here. All right, so the state rested. State has rested. We have a poll going. Do you think the state met their burden? So the state did rest. So far, we've got 113 votes. So if you have not had a chance to vote yet, take a moment to vote. Do you think the state met their burden? So we still have, okay, so the state rested. Defense did judgment of acquittal. Judge kind of, thought about it, looked at some case law, ultimately decided on both charges, which would be the act itself and then the conspiracy. She denied both. And then they were kind of hashing out what's the schedule going to be. So it sounds like the defense is he said he's going to take a while. So let me see, what was the opening? I always say, it double, whatever the opening is, double it. And that's never a good thing. All right, so let's see. The state started at 9:41, ended at 10:43. So basically an hour. The defense started at 11:05, ended at 12:03. Basically an hour. So they both basically took an hour. So now the state closing, Ms. Stifler said she was going to be at least an hour to hour and 45 minutes just for her opening. Just for her first close. And then she gets a rebuttal, so she'll probably be at least like another half hour. So she's looking at probably close to 2 hours. 2 hours and maybe some change if she goes longer. 2 hours, 15 minutes, somewhere in that range. So at least 2 hours. I would say at least 2 hours for her. And then the defense said that he said he's going to be long. So I would think he'd probably be 2 hours as well. So we're looking at 4 hours. So right now, instructions and state first closing are going to be tomorrow. Then the defense is going to come back and close, and then state's rebuttal. So they're going to have the defense is going to put on their case in chief, and he said it's only going to be probably the morning. Then instructions are going to be about 20 minutes, and then the state's going to close for like an hour and a half or so. So that'll get us probably to like 3 to 4. So it's going to be an early day again. So I'm not going to go tomorrow. I wasn't planning on going tomorrow. So I'm going to go Wednesday. So if the defense closes and say they talk for 2, even if they talk for 3 hours, that gets them to lunch. And then the state does the rebuttal. So they should be deliberating by like 2:00. So I'm gonna stay. I'm hoping I can catch a verdict. She said that she would let them go until like 8 or 9 o'clock that first, if they wanted to. So if they start by 2, 3, 4, 5, 6, I don't want to stay too late. I want to probably be leaving by 6. So it'll stink if I have to leave and then they have a verdict come in. But that's just the way it is. I'm not gonna stay overnight. So I'll throw caution to the wind. Hopefully I can catch a verdict. So, all right. So we heard a lot today. We heard the proffer by Kim Jensen. We heard from Fred Barton. We heard from John and Juan Biggerstaff. And then finally we heard from Detective Chris Johns. So it was a full day. It was a full day. Even though they ended early, it was a full day. All right, let's see. Have they asked Mario if he tends to testify? Not yet. Oops, sorry, hold on. Hold on there, Gordon. Let me put myself over here. Actually, I can put myself over here. No, that's going to be tomorrow. He's not going to testify, especially now since they said it's going to be a short day for the defense. I highly doubt he's going to testify. He doesn't need to. He doesn't need to testify. There's really no reason for him to testify. In other trials, we're like, oh yeah, you need to get on the stand, but he doesn't need to testify. I don't see him. Plus, they said it was going to be a short day for the defense, so if he was going to take the stand, it would be like at least 4 hours, 3-4 hours. Kimbers, it makes sense. Debbie, Trial TV Live mods in chat, thank you so much. See you all tomorrow. No upside to testifying. Yeah, I agree. He would. Yeah, there's no reason for him to. He doesn't gain anything. There's no reason. So, Fanny, they're going to have some defense. He said he said it would be short. They may call bigger staff again. I'm looking at their list here. They called, actually, on the list here, the state called quite a lot of people from the defense. And I don't know, maybe ATF. The minor children are on this list. There's a bunch of, civilians, as they put it. There are a bunch of civilians that they did not call. So I don't know. I'm not sure what a civilian would add to it. There's a couple expert witnesses. Digital forensics. Yeah, I'm not sure. I'm not sure who the defense would call. Other than somebody to say, yes, he was at the house. Or I called Mario at 7:50 and he was at his house. Because remember, this happened at 7:52. Or I saw Mario at going to the deli down the street and he was there at 7:50. Something like that. I mean, I'm not sure. I'm not sure who they're going to call. Pipeline says, if you go to court and get a chance, I will definitely be going to court for sure. I'm definitely going. Will you be so kind as to extend condolences, support for justice to the Bridigans? I try to be really respectful because I've only been there once so far and I don't want to overstep my reach. If I had been going there multiple times, especially when there was nobody in the courtroom, I probably would have been able to build a little bit more of a rapport. But I will do my best. I will do my best to extend our condolences to the Bridigans. I don't want to, I don't want to be that guy, you know what I'm saying, where, you just walk up to somebody and be like, sorry for your loss, all that stuff, even though I wouldn't do it like that. But I want to be respectful. Like I said, if I had been going there a couple times and especially when there was nobody in court, you kind of build this rapport with people because they see you there every day or they see you and they recognize you. And then you can kind of start a conversation with them. I will do what I can. I will certainly do what I can. But I will. That's a very nice thought, Pipeline, and I will keep that in mind for sure. Pipeline says, if you could, it would be greatly appreciated. Jared's brother Adam and sister usually attend, and they're absolutely seeing grieving and sad. I saw what I would assume was his brother. I do not know what they look like. I'm not that familiar with who's who. I just know like the main players, Kirsten, of course. I did see a gentleman with his head in what I would assume would be his wife. Head was in her shoulder. Not just when they were identifying Jared, not autopsy photos, just talking about Jared. He seemed pretty distraught. So I would assume that would be his brother. So I don't know them well enough to say who's who yet. Lassie, thank you. Paula, defense always implies they will put on a case and then don't put on a case. That is true. Jenny, thank you. I love this channel. Thank you to Pipeline. I love this channel. Chris and Aaron, the channel owners, my mod and chat family. Appreciate the kind words. Because Pipeline says you are a rock star, Jenny. Thank you for your incredible presence. Good luck and bye. I echo that sentiment, Pipeline. Jenny G is a cut above, and all our mods are just spectacular. If you guys have been with us long enough, you know we have a fantastic group of mods. Just a fantastic group. So. All right, you guys, that's going to be it. Programming note, we are not going to be covering Dwayne Davis tonight. We have other things we have to do, so we're going to focus on those things. So we will be back, obviously, tomorrow for day 7. it seems like they're going to end early, so I'm going to try and get Friday's Keefe D in tomorrow. So look for that if you guys are looking to rewatch that. So we'll be doing that tomorrow. So Pippi, yes. Yep, she denied it. Both counts were denied. Both counts were denied. Oh, thank you. We do have the best mod squad. Yes, we do. All right, you guys. With that, thank you so much for joining us. Dwayne, if you're Grampy, if you're looking, if you're watching, got your girl over there. I'll try and scritch your head. So we got a little Super Ball over there. She's crashed out. So okay. So let's see. Okay, let's see. Just to recap, today we had Fred Barton. He held the cabinet for John Biggerstaff. I thought he was pretty forthcoming. I didn't think he didn't. Oh, I have to end the poll too. Let me end the poll first. Let's talk about the poll. Let me end the poll. Where'd it go? There it is. Okay. So, did the state meet their burden? So, did the state meet their burden? So, we have 138 votes. So, did the state meet their burden? 74% of you think yes, the state did meet their burden and that Mario is guilty. 26% of you said no, the state did not meet their burden and that Mario is not guilty. So let's see. Yeah, we had Fred Barton. He was he held the cabinet that presumably had all these firearms in there. He kind of contradicted what Juan said and John said. Juan said it was. I don't think he said there was in a bunch of. I don't think he said it was a cabinet. I think he said they went over with a bunch of bags and stuff. He did talk about the firearm in question being stolen in Texas. He was law enforcement in Texas. And then finally, we heard from Detective Chris Johns, and he went over all the finances. And it was interesting. It was an interesting day. All right. With that, I am going to wrap it up, say goodbye to you guys, and thank you again for joining us. Really appreciate it. I'm going to post my notes. I'm a day behind. I'm going to catch up on my notes. If you guys are members, dial up and higher. I post my notes every day. So I fell behind because I went to day 1. So I'm going to catch up on that. I'm going to post days 5 and 6. So if you want to see my notes, I'm going to post those for you guys. And with that, thank you for joining us. I really appreciate you spending your day with us. Debbie, thank you for all the gifted memberships that you gave today. It was unprecedented. We've never had that many gifts, I think, in one single day. So I do appreciate that. Thank you guys for the gifts, the super chats. I really appreciate that. And thank you just for watching. Really appreciate you guys just hanging out, watching, hitting the like button. And thank you to our mods. Thank you to Kaylee she became a mod on Saturday, and then Sunday was her first stream, and then today was truly her first live court stream. So be sure to thank Kaylee on your way out. And thank you to all the other mods, and thank you to Erin for creating shorts and videos while she's doing her work. She has her clients that she's working, and yet she still has time to help out on Trial TV Live. So with all of that, thank you guys. Delene kitties. All right, guys. We will. I'll give you one last shot of some kitties. We got Rafa over here. Little Rafa's chilling out over there. We got I think that's Riker, and then Super Ball's over there, and then I don't know if anybody's. Oh, Roger's way up. Roger's way up there. So, all right, you guys. Oh, and here comes Houdini. Hi, Houdini. Yeah, good girl. We just had Houdini cruise by. Oh, she just woke up. Super Ball. All right. She just woke up Super Bowl. Hi, Houdini. Yeah, it's a good girl. Hi. You gonna come say hello to everybody? Come here. Yeah, good girl. All right. All right, you guys. Thanks again for joining us. Really appreciate it. And we will see you tomorrow at, I guess, 8:45. Look for us then. Have a good night, guys. Take care. Bye.